Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
Come out with your best.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip! Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry. She's the devil.
Megan.
Megan Fox.
Megan.
Megan.
Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go?
Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan.
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 Megan Fox. Thank you. Cheers.
Hello, everyone. Good morning to the Fox Den and everyone watching. This is not Megan Fox, surprisingly enough. I am IT Goatee, filling in for Megan. Megan messaged me this morning and said, uh-oh, I gotta get a kid swab for strep. So, can you run trial watch until I get back? So, we are currently standing by, waiting for said trial to get started. The trial we are watching is Jennifer Crumbley, the mother of Ethan Crumbley, who was the Oxford school shooter. She's being charged with a couple of counts of negligent homicide, and so we've just finished most of the trial. The lawyers have finished their closing arguments last Friday. We're going to go into jury instructions this morning and then start verdict watch. How's everyone doing today? We got Squid, very nice to see you. Ginger, thank you for helping as well. Hello, everyone else. No one else going to talk? Okay, I get it. There's only 48 of us. You know what? I'll bet you we could get all 48 of us to like the stream. We're only at 9 right now. Megan says she'll pop in once she's finished taking Kid in. Squid, I'm sorry you didn't sleep well last night. So, funny story, we had that wonderfully raucous stream about the fetal attraction Saturday evening, and I did not sleep well because we were up until almost 2 in the morning. My poor wife got up with the little one, and then he went down for an early nap. She went down for a nap. Yeah, I'm not going to do camera today just because we're expecting not a whole lot to be going on this morning. We can carry the jury instructions if you really want, but I imagine they're probably going to be something in the neighborhood of like 40 pages or so. And of course, I sound like crap because I've been dealing with this cough for 3+ weeks now, and I don't know when it's ever going to go away. So, what does chat want to talk about while we're watching the state of Michigan emblem on the back of a court? This is your one chance to interview me, figure out anything you want going on. Or waiting for questions to come in. So, I've been, since I've been helping Megan out with her tech problems and all sorts of things, my locals, I did set up a locals fan page, but I've been getting a significant amount of people following me. And right now, I don't do anything on locals. I just kind of exist as a personality. But I've got 531 followers on locals, which is pretty crazy. So, trying to figure out, one, I have more followers on locals than I do on X. And then, I would even say I have more followers on locals than I do on Facebook. I mean, I'm not the big social butterfly as most everyone else, but it's just kind of funny. But if I were to get put more time and effort into setting up my local site, what do you, as people who want to know either more about IT issues or just things in general, what do you want to see? Because at the moment, I have zero ideas for a quote-unquote business plan or anything to try and do with it. So, first question. Amy says, "Goatee, what do you do for work?" I am an IT engineer for a company here in Michigan. I help manage servers and infrastructure for the company, delivering services to our clients. Primarily, my focus has been on Linux infrastructure. Linux is well, you can get in the super big weeds, but it's a separate operating system similar to Windows. You have Windows, Mac, and Linux. Those are the three main types of operating systems that get installed on systems. Generally, IT organizations install Linux when they want low overhead, high performance computing. And I've been doing IT work since 2007, so that puts me at almost 20 years of, or 3 years shy, so 17 years of IT experience. Angela, thank you for the like. Everyone, is the more likes that we can pump out, the better for Megan. I know that watching the state emblem isn't the funnest of things at the moment, but doing our best to try and fill the time, entertain you guys, and then we'll be off to the races here once court starts. I have a sneaking suspicion once Megan gets to the doctor's office, she's going to pull open the stream and listening critique to all of the wonderful things that I have to say. We just brought in audio, but nobody's there. Unhung Hero, thank you for the $5 super chat. Today I learned IT Goatee and I have been working in tech the same amount of time. Yep. Helps when when I started messing with computers back in when I was 14 or so. Funny story about that. When I was completely green on working on computers and whatnot, I got the smart idea that I was going to try and reseat the RAM while the computer was powered on, and got the ugly smoke and smell, and I killed that computer harder than oh gosh, man, my brain is just done right now. I killed that computer pretty hard and quick, so got the nice zap and it was done. So, but that was one of my first introductions to working on the hardware of a computer. Since then, I've built and maintained a number of my own computers, as well as server infrastructure platforms for clients that I've worked with. Hello, Melanie from West Yorkshire. Very interesting. And yes, it is Yorkshire, not Yorkshire. I'm a member of the NASA Spaceflight Discord, and the member or the person who runs NASA Spaceflight is a Yorkshire man, so he likes to instruct everyone the proper pronunciation of how to say Yorkshire. Hello, Bethany. Thank you for joining. Unknown Hero says, built my first website in 6th grade, built my first computer as a freshman in high school. Pretty much knew what my career was going to be by 16th. That's basically the same thing as me. I ended up doing my senior project, was showing people how to build a computer, using my own computer as a test subject. So that was terrifying and whatnot. Porcelain Thunder says, RAM is cheap. Yes, but back in this may have been DDR1 or DDR2 days, RAM we didn't really have the ability to get parts in the way that we did now, but you had stores like CompUSA around and been able to, or when Best Buy actually carried usable or decent parts instead of the hodgepodge of crap that they do now. God, I miss CompUSA. We do have Micro Center. Micro Center is pretty good. If you ever want to watch me burn a lot of money, put me into a Micro Center, because I can find a lot of things to sell at Micro Center. Trophy Wife. S. has the jury come in and been released to deliberate? No. At the end of things on Friday, the lawyers have been able to finish their closing arguments. However, we still have jury instructions. Jury instructions have to be read to the jury before they're released to go to before they're released to start the deliberations. There are currently 17 jurists in the panel, and 5 of which will be separated off and sequestered for the off chance that someone from the current jury pool has to step away. Oh, I forgot about Tiger Direct. Tiger Direct was pretty cool too, and until they ended up dying. Megan has transitioned to a man named IT Goatee. Please like the stream. Yes, I am Megan Fox now. So don't ask me how we were able to do a stream together, unless that's just her multiple personality disorder coming out and having both of us stream and be able to talk over one another. Unfortunately, I do not have the ability to do polls in the chat, so when Megan gets back, we'll do a poll for what everyone's thinking will happen with the jury. We did one on Friday, but you can always refresh it and do another one today. Unhunk Heroes. I was clearly streaming with Megan GPT. See, it's all a ruse. You think it was Megan that transitioned to IT Goatee, but I was killing off Megan Fox before taking over. This is now the IT Goatee channel. IT Goatee Investigates. This is got an appointment in half an hour, so may have to do some catch up later. But hello, everyone. Well, hello, Liz. Nice of you to join us, and no problem playing catch up later. And I'm sure there's going to be a lot of open air time with either Megan or me talking into the wind, waiting for Verdict Watch. Kiwi Green says, "Do you have Babbages? I have not heard of Babbages." Let me do a quick package. Babbage's looks like it got turned into GameStop. So I'm going to say, yes, we do have Babbage's, but just in the form of GameStop. Now, I remember way back in the day, we used to have a video game company, well, not company, but a video game outlet called Funkoland. And Funkoland was the coolest place to go to because there was no GameStop that we could go to. But Funkoland, you had the glass case in front, and you could see all the Game Boy games laid out next to one another. And then you had the SNES games in their boxes, and back when boxes were useful instead of just carrying a piece of paper that had a key that you had to go enter in a Steam. But God, that was so much fun. I loved Funkoland so much. Here we go. Get some nostalgia going. Stop presenting that. We'll share this. All right. Funkoland. And then you would go inside and see this. Old school video games, as far as the eye can see, using quick hang walls so that you could hang all the boxes and shelving and whatnot. And then you'd have your Dreamcast, PlayStations, Super Nintendos, N64s, all that stuff. Yeah, look at them all those old things. But yeah, that was the best. David Moore says, it's fun memories, but the games suck if you go back and play a lot of them. I would disagree. I ended up purchasing a Raspberry Pi and using that to emulate a bunch of the old video game consoles, and a lot of the old systems I still love and enjoy playing. You have a lot of those games were could have been arcade games that got turned into something that you could play at home. Or like I remember playing Gladius 2 on Super Nintendo, and I could play that for hours, just flying my ship on a side scroller and shooting everything. Yeah, Squid Super Nintendo was the best. Victim Advocate says, "What's a Raspberry Pi other than a dessert?" Well, Raspberry Pi, if I'm not familiar, is a single board computer made out of the UK. This is a Raspberry Pi, and Raspberry Pis, they largely look the same. There's been 5 iterations of it so far. The original Raspberry Pi, Raspberry Pi 2, 3, 4, and now they have a 5 out, as well as a couple of different form factors, but those are irrelevant at this point. But the idea is that it's a cheap and low-cost computer that you can hobby with, do a number of different things. And they run on processors. Everyone remembers the Intel commercials. Well, the processors that Raspberry Pi runs are more similar to Apple M1. They use the ARM instruction set. ARM is a computing company that publishes the instruction set information, but you have to purchase a license in order to be able to use it. So Apple pays ARM a ton of money to be able to utilize their instruction set. And every so often they'll upgrade the instruction set. Right now we're on ARM version 8, I believe. But a lot of people have created a thing called RetroPie. And the idea was to originally take a Raspberry Pi and make it be able to play old arcade, home console, and classic PC games with minimal setup. So you can do Game Boy games, you can do old school NES games. Nope, can't see it. Anyway, so it's super cool. I love it. I don't get as much time as I want to be able to play on it, but when I do get the chance, it's really cool. Looks like the prosecution just walked into the courtroom. I'm monitoring it in my ear, so I'll bring it up when we're ready. Amy DeRusha I'm sorry if I utterly botched that, but it says, Goatee, do you have your own YouTube channel? I technically do. I have a YouTube account. I am set up to have it function as a channel, but functionally it is useless at the moment. So, similar to what I was talking about earlier, I have zero idea or as to what I would want to talk about or be able to present as a core business concept of what to be streaming. You know, Megan does her journalism, talks about trials, things that she's interested in. For me, I don't know if I would want to do more of a live a live streaming function more so than scripted, highly produced content. So definitely would want to try and figure out what the heck to do with that and have it not be repetitive. The biggest thing for me was I don't want to feel like I'm duplicating other people's work. You know, how to set up a Minecraft server. There's a ton of content on how to set up a Minecraft server. So I just don't want to be another voice in the void of content. Because, I mean, if people want me to do it, I'll do it. But I just don't think I can add value into that particular area things. But I can certainly try. Megan needs her coffee. No, Megan's had her coffee. She's driving to the doctor's office. So she's awake. She messaged me and said, "Hey, can you help run things?" David Moore says, "Sell your soul to Google." Oh, please no. I'm actually trying to de-Google myself at the moment. One of the things I've recently, well, I shouldn't say recently. One of the things I've been doing is set up my own email server. That's been quite fun. So my wife and I have our own private emails there. Our son has an email there so that he can get his Apple ID. Block my face says, is Xbox collapsing? No, Xbox is certainly not collapsing. Microsoft is continuing to put tons of money into Xbox. The biggest thing for Xbox right now is they just acquired Activision, and when you do acquisitions, what you find is that you incorporate a whole company into your new enterprise. But the problem with that is you're bringing on a team's HR department, you're bringing on a team's finance department, you're bringing on a team's legal department, and all these other departments. So you could probably take in about half of those staff to justify the amount of employees that you're taking in with the organization. But you're going to find that you're going to have more people than you actually need. So generally, you will lay off a number of people after some time because you realize that there's inefficiencies in being able to do certain things and having too much staff. So they're going through and laying off some people from Activision, Blizzard to right size what they need, hopefully going forward. Megan's in the chat. Says Hangry needs a strep test. So she's listening to the dulcet tones of me talking about video games, Raspberry Pis, and all that. And driving. So hopefully Hangry will get answers on his whether he has strep or not. Bring this up. So we've got Miss Crumbley has just been brought into the courtroom and is currently being deshackled. I expect we'll get the judge coming in here shortly, and then the judge is going to ask if the attorneys have anything to talk about before they bring in the jury for jury instructions. I don't think we have any outstanding jury motion or attorney motions at the moment, but right now we're waiting to see. Block My Face says, I have an Xbox now, but don't know whether to get an Xbox X or a PlayStation 5 or a gaming computer. A lot of it is going to depend on what kind of games that you want. If it were me, I would say a gaming computer, and I'll give you a couple of reasons. Right now, you're seeing Microsoft pushing a lot of content to Xbox and PC. So when Starfield came out, Starfield was an Xbox exclusive and also a PC release. And the PC is really seeming to get most of the games at the same time as console releases. The caveat to that is you have some PlayStation exclusives, Final Fantasy 16, new Spider-Man games, things like that, that don't get a simultaneous PC release. So it's really going to come down to what do you find yourself playing. If you have an Xbox right now but don't have a desk and whatnot set up for a gaming computer, or you don't have monitors, speakers, and headsets, then that's going to increase the cost of your setup in order to get into PC gaming. But if you already have all of that set up, then I would say PC gaming is probably going to be worthwhile. The problem that you're going to run into is that whether you go to Xbox Series X or PlayStation or PC, you're probably going to have to buy a bunch of games. So you're going to have to look at that investment in terms of the cost of switching platforms and whatnot. I've been investing in PC gaming since, gosh, we won a PlayStation 4. So if you remember, 8 years ago or so, Taco Bell did a golden PS4 contest. And I happened to win that. So they gave out, I don't know, 400 to 800 golden PS4s and controllers. And we bought, I'd probably say 8 games for it. But for the most part, we really didn't play it. My wife and I, we missed the ability to... Megan, stop it. No, don't tell me of course I won. That was the first time I've ever won something from one of those contests or whatnot, so I felt very blessed to be able to win that. And it's sitting in a basement right now and collecting dust. But my wife said we'll never get rid of it because one, it's just so unique. Even though they're selling the golden controllers now. And Judge is now in the courtroom. All right, Judge Xanax, let's go. And we do have the captions working.
Your Honor, calling People v. Jennifer Crumbley, case number 222799990 FH.
Good morning, Your Honor. Karen McDonald on behalf of the people.
Thank you, Marquise. On behalf of the people.
Orson Thunder says, didn't you just win all that crap? Yes, she did win. She did win all that crap at her party function that she went to on Saturday.
Thank you. Regardless of the verdict in this case, we agree that the gag order will stay in place until after the trials of James Crumbley. Is that correct?
That's correct.
All right. Can you approach on the
He said that there's going to be a gag order that'll stay in place until the end of the James Crumbley trial. I would imagine to ensure that they don't taint that case as well. More sidebars. Yeah. I don't know why they do. Well, I know why they do it. They're doing a sidebar because they don't want whatever they're talking about to be entered in the record. Or no, sidebars are in the record because we were reading the we were reading the sidebars that were being transcribed in the Johnny Depp case. So if it's going to be transcribed and published once the record gets transcribed, then what's the point of doing the sidebar when the jury's not even in the room? Hair is a strategy. Are you saying Jennifer's hair or or her attorney, Shannon? I mean, obviously, for someone who's been in prison for 2+ years, then yeah, making her look as I don't want to say pathetic, but that's kind of the best term. Making her look more disheveled in order to increase an attempt at likability. Frumpy, yeah. Frumpy's a good term. Templin says, it's so sad today. That is what we're discussing in the Lori v. Daybell case. Did not look like this. I'm not so familiar with the Lori v. Daybell case, so you mean about the defendant being in their appearance, and so I imagine that attorneys worry about what their client looks like to a jury all the time, whether it's a part of strategy or lack thereof. And also keep in mind, Amber Heard had a strategy of changing her look every day, and in addition to her courtroom appearance and mannerisms and whatnot, her likability was affected by it, and looks like Shannon got a perm over the weekend because her hair is super curly. Ooh, Megan says she's had a major shift in opinion on this case. Well, when you get back, we certainly will explore that. And can you guys hear? That's a big important thing, because I thought I did boost just to make sure. You should be hearing some white noise. Megan says those are iron curls, so definitely not a perm. Okay. I would certainly not know the difference. I just know that perms equal curl.
been so wonderful and timely that I have another jury starting next Monday, and I'm wondering if I'll be willing to come back next week. No? Hard no? I'm gonna read you some jury instructions.
I'm going to turn it down just a
You're
tad.
gonna get a copy of these in the jury room. Then I'm going to,
Unknown Hero says stop talking about hair. We can talk about hair when it's pertinent to the trial. Megan talking about hair, trying to increase median income is a different story.
Like the show Survivor when the teams are merged, right? The tribes are merged, right? So I know you've been in 2 different jury rooms, but we'll be putting keeping the 5 alternates still sequestered in Judge Anderson's jury room, and the 12 will be in my jury room. That's why I asked you to bring your personal belongings when you came here, right? Members of the jury, evidence and arguments in this case are finished, and I'll now instruct you on the law. That is all.
God, that looks like 40 pages of jury notes. Good Lord.
Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as a law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of crime beyond reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses, are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender or gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. James Robert Crumbley and Jennifer Lynn Crumbley are both on trial in separate cases. The fact that they are both charged is not evidence that either one is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her. The prosecutor must prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find if the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made, and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of the crime. In other words, you should consider all the evidence that you believe. There has been some evidence the defendant ran away and tried to hide after she was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. You have heard evidence that before the trial, a witness or witnesses made a statement that may be inconsistent with his or her testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness or witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness and or witnesses said in the earlier statement when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about what each witness, about each witness and each piece of evidence and whether you believe them. Then you should decide the case. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talked to one of the witnesses. There's nothing wrong with that. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what that witness's testimony will be. You've heard testimony from witness Detective Edward Wogrowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing that act caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Tate Meir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count four, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Justin Schilling. That is, Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. As I explained earlier in my instructions, the prosecutor asserts two different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are two different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. In count one, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of the defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count two, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to take Mir. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, the death of Tate Mir was directly caused by defendant's failure to perform this duty. That is, that Tate Mir died as a result of defendant's failure to exercise reasonable care to control her minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count three, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Hannah St. Juliana. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control her minor child, so as to prevent the minor child from intentionally harming others, or the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had a legal duty to Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent their minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. A, the parent knows or has reason to know that they have the ability to control their minor child. And B, the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control her minor child, so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that she had the ability to control her minor child and knew of the necessity and opportunity to do so. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring someone. Let me read that again. First, the defendant knew of the danger to another, that if she knew there was a situation that required her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I think I've told you this before. I'm not sure we did the greatest job at this, but I previously ordered the parties to be precluded from using the shooter's name during the trial. When you go to the jury room, you'll be provided with written instructions of the final jury. You'll be provided with a written copy of the final jury instructions, and you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way, and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you will discuss the case amongst yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about this jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my clerk. Possible penalties should not influence your decision. If the defendant is found guilty, it's my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the clerk. It's not proper for you to talk directly to me, the lawyers, the court officers, or any other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with the unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. I believe that the defense exhibits are hard copy, and the prosecutor has their exhibits on a thumb drive. We have a computer that we're going to set up in the jury room, and you can look at those exhibits. If you want anything else, you can let us know. I think it's a thumb drive, right?
It's a portable USB or hard drive.
And Your Honor, I just want to make sure that mine are in a binder. I left it for Ashley.
Okay. Yeah, we're gonna send all the exhibits in right away, all right? If you have a written copy, I think I told you this earlier, we can replay a witness. That's very possible. And I think I told you this in the beginning of the trial. You can't, however, fast forward to the spot where you have a question and I'll yell, aha. You have to hear the whole witness, direct, cross, redirect. It's the only way that's fair to both sides, but it is possible to replay testimony, all right? The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately and all of the evidence in the case. You may find the defendant guilty of all or any one of these counts or not guilty. I have a verdict form here. It's like a flow chart. There's questions. Number 1, involuntary manslaughter as to man's involvement. You can check not guilty or guilty of involuntary manslaughter as to man's involvement. Count 2, involuntary manslaughter as to Tate Muir. Not guilty, guilty of involuntary manslaughter as to Tate Muir. Count 3, involuntary manslaughter as to Hannah St. Juliana. You can find the defendant not guilty or guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. You may find the defendant not guilty or guilty of involuntary manslaughter as to Justin Schilling. So I'm amazed that we maintained 5 alternates. It's a credit to how great you were at being here in time and following the instructions, and we're so appreciative. So we're going to choose 5 alternates, but I'm still going to sequester you. All right. I'm gonna have you kind of cooling your heels and being bored in Judge Anderson's jury room. If deliberations went beyond today, I might consult with lawyers about dismissing some or all of you. I think you can imagine that this has been a very emotional and stressful event for both parties, the prosecutor, the defense, and the families, and it's been a lot for the courthouse too. So you all look really healthy, but life happens. So I am going to sequester 5 of you. When I pick your names, my clerk is going to take you to Judge Anderson's jury room. You've all ordered lunch, so we'll match up the numbers and you'll get your lunch in a while. I know you're going to be kind of bored and stiff for a while, but we just want to be sure that we can conclude this trial. Then the other 12 of you will go into my jury room and start deliberating. I should also say the 5 of you that are sequestered still cannot discuss the case. or do research or Google it or look at newspapers or go on Facebook, you're still sequestered as if you're home. All right, sometimes I would, I thought about sending you home, but I'm gonna keep you for a little while. But you're still sequestered. Can't look at me or talk to anyone about the case, and can't discuss the case amongst you 5. The 12 of you can start deliberating momentarily. I'm going to consult with the lawyers to make sure that there aren't any errors in the jury instructions. Bring in the exhibits, and then you can start deliberating. It's important that you only deliberate when you're all there. If one of you steps out for some reason, you should be deliberating. And you can send us notes about when you want to take a break. I still would like you not to go to the cafeteria, please. And be careful if you're walking through the courthouse, because there's obviously a lot of interest in the case, as you know. And we've gotten this far. So in any event, I'm going to choose 5 of you randomly, and those 5 of you will go to Judge Anderson's jury room. All right. Juror is seat 15. You're seat 15. Juror in seat 17. Juror in seat 10. Are you 10? Seat 10? You're in seat 10. Juror in seat 4. You're in seat 4. And juror in seat 9. All right. So 17, 15, 9, 10, and 4. I'm sorry they could call you board. We'll get back to you as soon as possible. All right. I do bring some cookies, and there's candy, and there's muffins, and what else? Licorice, oranges, apples. So if you could, I'm trying to think of it. Might be best from this way. Can you go? Can they go both ways? I know it's so crowded. It's the coziest my box is ever known. So I'm gonna ask the alternates who I chose to go to Judge Peterson's jury. We'll bring you coffee too.
Okie dokie. So they have chosen alternates, and now Judge Xanax is now going to be known as Judge Muffins.
Give me a moment. I want to consult with the lawyers and make sure that there are no errors in the jury instructions. And then I'm going to send in all the exhibits and copies of the jury instructions for you. All right. And if you all decide you're going to leave and walk around or whatever you're going to do, just let us know. We will all be awaiting you. Okay. All right.
All rise for the jury.
No, it does nothing.
Nothing from the defense.
We're going to send in the jury instructions, and you're giving us.
Yeah,
that computer can do that. Okay. You're not giving us any hard copy.
Correct.
Right. Yeah. Okay. And we have your exhibits. Please make sure we have phone numbers for you, because we get that usual question. We have copies of the police report, all the questions that usually come out of there. So
There are 5 exhibits that we didn't include in the USB to the jurors. That's the shooting video, the photograph with the blood from the bathroom, crime scene photo depicting the 2 victims, the video that was played with Gibson Marshall, and the video that was played with Molly Darnell.
Okay, do you want me to to somehow tell them that?
I think
Maybe I
they
should.
should be made aware of that, Judge.
Oh, okay, well, I would have told them that before we went in. Can you write those things? Do you want me to just tell them?
That's fine. I can write a note on the envelope.
Okay. Or we can give you a, maybe right there, no, just, if you can initial it, and you just initial it. Right. What else? Please just be sure that we can find you, because sometimes there's questions.
I'm gonna be right here.
How many
We're
sets of instructions are sending? We could send 12 sets of instructions. Is that good? Maybe that won't throw.
Yes. Those are, yeah, and then I gave the binder, so I use the binder. Yeah, the binder just has it like in pages or page covers. Thank you. You have my cell phone.
I hope everybody here would be careful not to have any interaction with any of the jurors.
Yeah.
I think some members of the media have asked that the jury instructions be emailed to them, and I agreed that I would do that as soon as I had read them to the juries.
Oh, there you go, Megan. They're gonna make them available. Ask you showers.
Oh, it's your signature. Okay, got it.
If you have any thoughts about the other thing I raised at the bench previously, let me know.
Thank you, Judge.
I guess-
Judge.
Sure. All right, so we're sending a note, we'll let you know, okay?
Thank you, Judge.
All right.
So,
They're just leaving the courtroom.
This one is just gonna tell them to start deliberating. So.
It's just paper. There's no staples. Thank you.
Okay. Mute that temporarily. So you're now fully in deliberation. Jury went back about a few minutes ago. I would say 9:45-ish. So now we're going to be staring at the Michigan seal for, God, straighten your camera, damn it. Megan, they did say the media has asked the judge to release jury instructions, so they're going to be posted somewhere. Your camera is tilted. Fix it. Let me edit this banner real quick. Bethany, I will not be able to do a poll. Megan is the one who can do polls. However, she is currently dealing with sick, hangry fox. So when she gets back from finishing all of that, we'll do polls. I think we're probably just going to do guilty, not guilty, or I believe not guilty, but jury will find guilty options. But I don't know if we'll do a length, just because they said 3 weeks for the trial and they did it in 2. I know that doesn't really say much for how much discussing they're going to do. I think it could probably go up until 5, 6 p.m. today. The judge didn't make any kind of opinion on whether or not they would, how late they would allow them to stay. Sometimes that you get a better sense from some. Yep, we are now on jury watch. So, or I should say verdict watch. Probably. Not verdict, verdict. There we go. You tell it's a Monday morning, folks. Anyone got any games to play while we're waiting? I know Judge Schrader had the, what was it, family trivia or whatever they would play in the courtroom while they were waiting. Like he had no other cases that he was going to get done. Oop. Okay. Oop, there it goes. All right. So, as we were talking about before, video games and building computers, RetroPie, Raspberry Pi. We'll do a full Q&A session until Megan comes back. So if you've got a question that you want to ask me, please feel free to ask it in chat. Chats for Megan with super chats or super stickers will be taken priority. So if you can, please help make contributions to Megan to help her in all of her endeavors. You can throw up her standard there we go. Her standard one. Super chance for Rumble Rants, locals tips. I do not have locals open because I'm a terrible co-host or fill-in host. So let's go ahead and get locals open. If you are not subscribed to Megan on Locals, I highly recommend you do. meganfox.locals.com. Join chat. There we go. Now we're seeing all of it. No memes. And the meme farmers are sleeping still. There's nothing there. And we'll get Rumble up. We can check out Rumble Ghetto. About. Whoop. We do not want double mic feeds. That would be terrible. All right, Lynn's asks, is the civil suit against EJAC and Hopkins going forward? I don't know what EJAC is. Oh, I guess that would be another option is hung jury. So 4 options. That looks terrible. Oh, well. This 2 school employees. When I think of Hopkins, I think of the Maya Kowalski case, so I'm not familiar with that. I honestly don't know if they're going to do a civil suit. Yeah, and on here, the weird thing about this case is the storage of the weapon and ammo. And when this case was in question, i.e., before the passage of the gun storage law in Michigan, firearms owners in Michigan, which I'm a current resident of, firearms are everything. It's not uncommon for students to take the morning of November 15th off because they want to go out for the opening of firearm season for deer hunting. It's, you know, outside of your urban centers, the big 4 being Detroit, Flint, Saginaw, and Grand Rapids, you know, it's not uncommon to have some kind of firearm, whether it be a pellet gun, rifle or something to be able to be sitting around because you either want to shoot a squirrel or a nuisance animal or whatnot. And they always say keep the firearms stored away from ammo, but some parents have taught their children how to properly handle firearms and to never touch them unless, or if you find one, go find an adult. So it's just is hiding ammunition in beer steins, which is what Jennifer said they would do. And they said there was a number of beer steins throughout the house. So is that a sensible enough way to be able to prevent? Is that reasonable storage? And and that's not looking at it from the law is now passed for storage. It's that was that enough at the time to I'm not familiar with the Megan Imowitz case. Rosie, where's Megan? Megan's dead. I've taken her out. Shh! Don't listen to that Megan Fox. She's not here. Angry tested positive for strep, is showing minimal symptoms, but because strep is going throughout the school, Megan thought it was appropriate to get him tested. It's the other Megan Fox, Palmyra. That's the one that with toe thumbs and whatnot. Singing skills? I have no singing skills, especially with my voice as raspy as it is at the moment. I have been known to belt out some power metal songs in the car. Right now, some of my favorite bands are Sabaton, Manowar, Dan Vask, Old Glory Hammer, that still had Thomas in it, and his new band, Angus McSix. Rap? No, I don't rap, no. This microphone is not suited for singing. My dogs will start howling if I start singing. That's nothing that nobody wants. The only serenading that I will be doing is my velvet voice, but we need the chat to come up with some questions and whatnot to start getting the things going. Where's Megan with good hair? Megan is currently driving home. She will be home momentarily. What do you call a deer with no eyes? Ooh, thank you, Hemplin, for the 5 gifted memberships. If you were gifted one of those memberships, be sure to thank Hemplin in the chat. Judy brings up a good point. Both parents have a job. Do you know everything your kid is up to? You can't watch them all day round. Well, when you're co-parenting, hopefully someone has an idea of what the child is doing. Back in the 80s, 90s, and early aughts, you could send your kid out into the neighborhood and they would preferably stay out of trouble. But, nowadays it's not as easy. All right, now we've got oh, there we go. What do you call a deer with no eyes? No eye deer. Well, that's definitely an interesting one. Where does a bee keep a stinger at night? Good question. Not sure. In his honey. Okay, yeah. Linda, I cannot make polls. I do not have that control over Megan's YouTube account. She has to be the one to make the poll. Sing Megan's intro. I don't even think in my best rock voice I could get some of those tunes out. I'm I'm musically inclined. I used to play flute in high school, but I do not have a singing voice, and nor was I trained in any sense of the words for doing modern or classical singing. Yeah, it was funny. My family was very musical. We had a person in our family play about every instrument, but nobody had played flute, so that's why I decided that I was going to play flute. I still have my flute around here somewhere. It's Gebedhart 40 or 50th anniversary edition. Megan's home. She can save me. Thank God. Megan, if you're home, you should be in chat. Come on. It was not Yaz flute. It was just regular flute. Yes, we should get Doggo Cam. Megan did promise today that we would get Doggo Cam. Archie Ruckus will be very happy to have his frozen peanut butter tire treat. Megan, if you're listening, you might want to prep the laptop for Archie Ruckus Cam. 8 milliliters. Yeah, 1 teaspoon is 5, so that'd be like just eyeball 1.5 teaspoons. Maybe a spoon in milliliters. So either half a tablespoon or 1.5 teaspoons. No, I said half a tablespoon. The problem isn't so much he's old enough for pills. The problem is that the doctor prescribed probably something with codeine or whatnot, and it comes in liquid form. So here's my hot take. I think the U.S. should convert to the metric system. Set an arbitrary date like they do with emissions plans and say, by 2040, all new products manufactured or sold in the United States will be done in metric, and just call it done. That gives more than enough time to do conversions over to things, get it done and over with, and then we can stop complaining about how we have this system and how it's different than everyone else. Men need inches, Jess. That's the problem. Oh, come on. I listen to Nick Ricada and Megan on some of their worst streams, and you think I can't hang with the best? Come on, Squid. Think lesser of me. Why would we make a band? I can't think of any reason that we would want to have a band. I'm not shocked by the discussion, I just can't add to it without getting thrown out of chat. Which discussion? The IT Flute Brothers Band. You don't want 6 flutes together, because then they're going to conflict with each other. Although, I took a trip to Chicago with our symphony band back in 2003, 2004. And there was a music convention going on. And our band director had gotten invited to give a seminar on how to, the thing that he was doing a seminar on was about warm-ups. So he was going over the warm-ups and using his band as the practical implementation of his seminar. After we did our seminar, we were able to go down to the exhibit hall and check out everything. And while I was down there, I ended up being able to see a bass flute and contrabass flute. And if you didn't know that those exist, yes, they do. In the same way that what should we call it? There's a piccolo, which would be like a treble flute, or no, because there's flute, alto flute, bass flute, and contrabass. But anyway, I got to attempt to blow in a bass or contrabass flute. I can't remember which one. I think it was contrabass because the end was wrapped around. But the amount of air needed to blow into those, and this was, I had been in band for 6th, 7th, 8th, 9th, 10th grade. So I was 5 years in, so I was still almost at the height of my performance ability, and I could almost not push the amount of air needed to get it to go.
Well, well, well.
Oh crap! Mom's here.
I'm here. All right, Brad. Thank you so much for taking over and doing such an excellent job of filling in while I was out. So everything's taken care of. Hangry has his medicine and his tea, and he is ensconced in his bedroom where he will stay, strep positive, away from the rest of us. Okay.
Playing Fortnite.
Playing Fortnite, yeah. What you were just saying, though, a couple of minutes ago about how we grew up so different and how, you would send your kids out to the neighborhood and you pretty much knew what they were doing, as far as bike riding or, whatever. I said in the chat earlier that I've had a shift in my thought about this case. And I have, because I started to feel really guilty. Like, you know what? I have an obligation to know more about what my kids are doing online. I really do. And if this woman or her husband had taken even the slightest interest in what her kid was doing online, they would have seen major red flags. I did a bunch of reading last night about Ethan Crumbley. I didn't know anything about the case, I knew that there was
his specific case, not the Crumbleys in general.
Right. I didn't know anything about Ethan's specific case. And I looked into it, and he was doing stuff online that, like, he was visiting these death websites, gore websites where they're showing pictures of accidents and gory deaths and, just awful stuff. Like if I as a parent saw that on my kid's web browser history, I'd flip out.
Right.
Right? I mean, that's something that you don't ignore. He was torturing animals. He had decapitated a small baby bird and kept its head in a jar. This is not an okay kid in any way. And so I think that we want to give the Crumbleys the benefit of the doubt. And maybe they don't deserve that. Like we want to say that parenting is hard and this kind of stuff can slip between the cracks. But can it? Should it? And if we aren't paying attention to what our kids are doing online, aren't we responsible for what the hell is happening there? Like we basically handed a loaded gun to our kids when we gave them iPhones and said, go have fun.
So now there's the reasonable duty as described in the legal standard, but then there's the practicality of it. If you were, how does one monitor said child's online activities in a way that isn't someone literally standing over them every time they have a device?
Well, do you have a monitoring system at your house? Will you be installing a online monitoring system? Because those things exist. And in fact, at 3:30 p.m. today, I have a representative from Bark coming to talk to us about it.
Not heard
because
of Bark,
I started feeling like, holy shit, maybe I'm doing it wrong. Like perhaps I'm doing it wrong. I think we do have a duty of care. And it costs a lot of money. It does. So it's like, yeah, what about parents who don't have money? Like you've got the money to get your kid a cell phone or whatever. You know what I think? I think Apple's guards, because I have parental controls through Apple on all of our stuff. So my kids have to get my permission to like download any apps. So I know every app that's on their phone. They can't delete things without my permission. They have to, but I don't see their text messages and I don't see their online browser history. I know how much time they're online and I know what they're spending their time on, how much of entertainment versus educational. But I don't know the details, and that is something that you have to pay for if you want it through other private companies. And it's not cheap. I think Bark is $15 a month.
Yeah, the only one that I know of is actually a local company here called Covenant Eyes, and that's geared more towards pornography viewing for people and having a personal confidant that gets emailed a transcription of what you're looking at in order to help be accountable. But that's not like I'm sure you can do it for from a parent to a child, but it's not really geared towards that because it's more geared towards website viewing history than like an intensive view of what your child is doing on your phone. Because I had a family member who was getting harassed on Discord, and it became a significant mental health issue for them. And if I was to purchase Covenant Eyes for my son, I don't think it would cover Discord, especially since most of these apps are segmented within the phone.
You've come up with a good question for me to ask the Bark representative, because Titania Jordan is coming at 3:30 to talk to us about what Bark offers and how it may have helped this situation. Like, what if the Crumbleys had this? If they had this monitoring system, would they have found these things? It's kind of like what I wanted to ask is like, what are the safeguards you have? So they sent me this annual report on children and technology. Let's look at this because this is really interesting and important. Like I think this case really bothers me because I worry about this stuff all the time and I don't really know what to do. And I feel like we're living in this age right now where so much is going wrong with the technology. So here's their 33% of tweens and 57% of teens were involved in a self-harm situation. That's a high number.
That's really high.
58% of tweens and 75% of teens encountered nudity or content of a sexual nature online.
You literally have
That's
to be actively avoiding it in order to not see it. It's so pervasive
right.
throughout the culture.
Right. Anxiety. 19% of tweens and 36% of teens used language or were exposed to language about anxiety. 58% of tweens and 77% of teens engaged in conversations surrounding drugs and alcohol.
Now, for that, if I was to have barks when I was a teenager, and all the times that we talked about drinking and smoking while not actually participating in,
Right.
was just because you engage in a conversation talking about smoking a joint or whatnot does not mean that you were actively promoting it or having done it. So that
Right.
could be misleading.
Right. Bullying. 67% of tweens and 76% of teens experience bullying as a bully, victim, or witness. Depression. Those numbers are high. Disordered eating. Predators, this number is lower than I would have expected. 8% of tweens and 10% of teens encountered predatory behavior from someone online. I would have thought that was much higher, to tell you the truth. And look at the violence numbers. This is really sick. This is the highest number of all. 82% of teens expressed or experienced violent subject matter and thoughts.
I mean, it depends on what they define as subject matter and thoughts, because I mean, is looking at a news article on a school shooting considered a violent subject matter, or?
Well, I don't know. We'd have to, I guess we'd have to ask them how they came up with the numbers, but what is the responsibility that we have as parents to make sure that the technology that we are providing to our kids is not being used in dangerous ways, is not throwing them down these rabbit holes from which they may not recover? What is it? And I don't know the answer to that question. I'm not suggesting that I do. I'm just saying that could we be doing more? Are we not doing enough? What is it that we need to be doing? Now, I have looked into some of these. I think I had Bark for a little while, but it was screwing up the phone. So it wasn't allowing my daughter to use her phone properly. And I had to take it off because it actually messed up her phone and we lost a bunch of stuff.
Oh, goodness.
So I don't know if I just did it wrong. It's possible that I just did it wrong. But Bark is rated number 1. That's why I contacted them, because they have all the greatest ratings as far as on all the tech magazines and stuff. I kind of think that this is not the responsibility. It is the responsibility of parents to be checking up on their kids. But the technology itself, I'm actually thinking that the companies that bring us the internet, the providers, ought to be the ones with this technology, and it ought to be offered in our packages when we get it. Because I already pay so freaking much money, and they're the ones bringing it into my house. All this shit I don't want. They are the ones bringing it into my house. I didn't bring any of this into my house. They did.
Okay. Counterpoint. When everyone had landlines and you had a line to be able to call literally anyone in the world, was it on the phone operators to block 900 numbers?
No, probably not.
Yeah.
However, you're talking about, I don't mean for me personally as an adult. Like, I don't need it, but my kids do, because they don't have, their brains are not developed.
Right, but nothing is stopping a teenager from calling a 900 number. And the phone operator is not going to be able to age verify who is using the service, nor are they going to.
But I could call them and have them block it. So I could have, back then, you could call the phone company and block 900 numbers from your phone.
Oh.
But I can't call the internet provider and say, I want this violent and sexual content blocked from our internet.
So there is something that you can do similar to that. There is a company out there called OpenDNS, and you can subscribe to their service. There's a couple of companies that do it. OpenDNS is one of the biggest ones. It's actually run by Cisco, and they have the ability to do category filtering at the DNS level, which is whenever your computer decides that it wants to go somewhere. So you type in google.com, DNS is the resolution from google.com to the actual IP address of where their servers are. So it's kind of like figuring out, like we write a letter to someone, we put their address down, and then you put it in the mailbox, then the mail service finds the path that it needs to go that way. It's kind of like that. But yeah, you could say, I don't want pornography, I don't want violent subjects, I don't want extreme topics or
but the
gore.
problem with that is that it goes for the entire family, right? Your entire, and that means I can't do my work.
So
because do you know how much violent content I look at every day? You know, like, do you know how much?
There's VPNs and all kinds of things.
Unhung Hero says that's just inviting ISPs to control your content. First, it's parental controls, then it's conservative news sites. But what if I was able to pick and choose what I wanted to be blocked or not blocked? Why shouldn't it be up to the consumer that buys the product? I think it would be far easier for these companies to install these things at that level than it is leaving it to every person to try and do this, because it's very complicated. It's not just that we're not sure which company to use, but it's a very convoluted kind of thing that a bunch of us don't have the tech skills to do. My friend I have another friend who's an IT guy, and he had installed.
Are you cheating on me, Megan?
He had installed this, program to watch, send him text messages when his kid would send a text that was problematic or whatever. And I asked him about it like 3 or 4 times, like, what is this? How do I do it? And I never could figure it out. So I want these things, but I can't figure out how to do it. It's not user friendly to me. All right, let's read my article because I was really thinking about this last night. And I stayed up till like 2 a.m. writing this. And you got the gifted memberships, right, Brad?
Yes.
Okay, got that.
And
did you get this one too?
Yep.
Okay, cool. All right, let me unstar those so we get those out of here. Okay. Unhung Hero also said, I don't trust them to acknowledge my choices. Well, I mean, they are providers that you pay for things. You're a customer, they're a service provider. They should do what you ask them to do.
I think that's where the net neutrality argument comes in. The idea that you're paying for a pipe from the provider, and the provider should not be doing any filtering or restricting of content that you're getting over it. The problem is that the Netflixes of the world are causing significant bottlenecks throughout the ISP's infrastructure, which is why what they call paid priority highways or whatnot is their way of getting these companies to be able to pay to justify the amount of bandwidth that they're causing on ISP networks.
All right, let's read through this. Let's see. The curious prosecution of Jennifer Crumbley is fraught with peril for parents. It is trending at number 3 right now. Clickety click so that we can get it trending at number 1. That would be great. Here you go. Here's the link. I don't have Rumble open. The Rumble ghetto is all by themselves. Sorry, Rumble.
You didn't see any. There's a couple of chats there.
Rumble, are you there? Hold on. Let me open my content over there. And here we go. Let's pop out the chat. Hi, Deb. And I will put the link to my article on Rumble as well. Okay. All right, wait, I can close that down. I have too much shit open right now, Brad, as usual.
Happens.
Okay. So I was up real late last night. This case was really bothering me. The state of Michigan is determined to put mother Jennifer Crumbley behind bars for manslaughter in the shooting deaths of 4 Oxford high school students. 15-year-old Ethan Crumbley, Jennifer's son, carried out the shooting. The state says that the mom should have seen red flags and somehow stopped the tragedy. James Crumbley, Jennifer's husband, will be tried later for the same thing. Both have been sitting in prison awaiting trial for almost 3 years. It is the first time any parents have been charged criminally for a school shooter's actions. Their disturbed son pleaded guilty and was sentenced to life in prison. But the state and the community want more vengeance, which is understandable since these terrible killings keep happening and no one seems to know how to stop them. Perhaps upping the ante and putting parents in prison will do it, they think. But there are problems with this case. As the jury goes into deliberations on Monday, there are many questions left unanswered. The jury is being asked to find Crumbley guilty of the deaths of children she didn't harm. But there is a child she arguably did harm, whom the state would rather not notice. All the evidence points to the Crumbleys being absent and oblivious parents at best, and abusive and neglectful parents at worst. Why didn't the state charge them with child abuse of Ethan? If they had, it would probably be a slam dunk. Ethan lived in a filthy bedroom that was so messy that his mother let him move to another room rather than clean it. The Crumbleys left him alone so often that his defense attorney's expert witness called him a feral child who had been abandoned by his parents. Neighbors reported that the couple fought loudly and often in front of their son. Jennifer was carrying on an affair, not just with another man, but with several people she and her boyfriend found on an adult swingers app. Ethan developed 13 cavities at the same time. There were reports that food was often in short supply in the Crumbley home. Jennifer, however, continued to lavish time and money on her horse hobby instead of stocking the cabinets and making sure her son was okay, even after he lost his best friend, his grandmother, and his dog in a short period of time. But instead of charging the parents with child abuse, which would seem like a slam dunk, the state has overreached and charged them with unintentional manslaughter. Even the New York Times opinion page can't figure it out. There is a logical contradiction in the state declaring Ethan Crumbley an adult with full responsibility for his crime, while prosecuting his parents for gross negligence in child care. Ethan Crumbley was a child, or he wasn't. He was responsible for his actions, or his parents were. Can the state argue both positions at once? Prosecutors insist that they can. While the parents have been excoriated for giving him access to the gun, this is something of a legal dead end. Michigan at the time of the shooting did not have a safe storage gun law on the books. It does now. The Crumbleys were not legally obligated to keep the weapon locked away from their son. Prosecutors then have tried to build a case from the vagaries of the family's interactions as reconstituted from text messages, Facebook exchanges, and the testimony of acquaintances who didn't seem to have known the Crumbleys very well or have liked them very much. The Crumbleys had their share of problems. We can puzzle over the true meaning of the fragments of family life in the evidence, but all we really know is this. Ethan Crumbley was depressed and struggling. Everything else in the end is open to interpretation. Jennifer Crumbley's attorney pointed out the state's mistake in her closing arguments, which should make all of us worried about how far politically motivated prosecutors can go in their never-ending quest for convictions. Can every parent really be responsible for everything their children do, especially when it's not foreseeable? Asked defense attorney Shannon Smith. If my son starts looking at nude pictures on his cell phone that I got him on his birthday, should I be held accountable? Am I responsible if he sends a picture of his penis to a girl? Everyone knows that if you give the state an inch, it's going to take an entire continent. What more atrocities will they inflict on parents if a new precedent is set and Jennifer Crumbley is convicted of involuntary manslaughter? I shudder to think of it. One need only look at my regular reporting on juvenile court to see the kind of injustice that parents are already facing. The state would love nothing more than to add more jailable offenses to their already too long list. Jennifer Crumbley isn't likable, and her parenting was pretty terrible. I don't like to judge others' parenting because the evidence in a courtroom is only a small snapshot of what probably went on behind closed doors. Jennifer is most likely not the monster the state described, but is also not the innocent, loving mother the defense tried to construct. There seems to be more than enough evidence to find both parents guilty of neglect and abuse of their child who killed other people's children. But the state did not meet its burden to show that the Crumbleys knew that their son would or could do what he did. The evidence suggests that Ethan hid his activities from his parents, and they were so absent and consumed with themselves that they never saw any of the problems he was having. Why didn't the state charge the Crumbleys with neglect and abuse of the child they were responsible for instead of manslaughter for the children their son killed? We should all be asking why prosecutors for the state chose to break new ground in the war against parents instead of using easier laws on the books to punish these two. Who is your government planning to use this new weapon against after they jail the Crumbleys? If the jury finds Jennifer Crumbley guilty of involuntary manslaughter, you might not feel sorry for her, but consider what the consequences and implications could be for the rest of us. I hope the jury doesn't hand more power to an already out-of-control judicial system that is careening over a cliff with unfair political witch hunts everywhere you look. It also shouldn't surprise you that the school officials who failed to check Ethan's bag on the day of the shooting where the gun would have been discovered and didn't send him home after finding a violent drawing and a clear warning of danger got immunity from prosecution and lawsuits. Conveniently, the state can't prosecute their own who were involved in this failure to protect children while hoping we'll all be too busy hating the Crumbleys to notice. Please make sure that you like this post, that you send it out, that you share it on social media, because Facebook and all the social media is really, well, they censor me. They censor PJ Media. They don't want anyone reading our articles. So the best thing that you can do, and it does help me get paid, is to click on it. Clickety-click and share it on your social media. If I share it on Facebook, they immediately hit the algorithm, takes it down.
They allow and
But
push
if
medium.
you share it, it'll be okay. Say that again, Brad.
They allow and push medium articles, but when
Right.
you have more reputable journalists, they censor and.
Yeah, they call us fake news. It's not true. They are fake news. Facebook is fake news.
You are fake news.
I'm going to pin my article to the top. Let me see how do I do this. Pinning it. Pin message. There we go. All right. It is now pinned to the top of the chat so that you guys can click on that and share it. Actually, I'm not sure that there is a liking. You can't like it on the site. Sorry, I misspoke. You just need to click on it and then share it. All right. What did I miss on locals? There's a locals tip. Oh, I must need to refresh. My locals chat's not updated. That's weird. There it is. Duncan, Idaho, thanks for the $4 tip. Says, what if we have a family where mom says, oh, I don't know anything about guns. I let the dad worry about all that. Do we say, nope, you're married and that's a serious thing, so you are equally responsible? This just has so many serious implications about prosecution based on marital status and parental rights and freedoms. Yeah, I mean, that is kind of what the defense case here is that Jennifer she wasn't responsible for the gun. That was James.
Well, I mean, in that same scenario, you could finger point both ways. If Jennifer points at James and says it was his responsibility, and he points back and says you were taking him to the gun range, you have an equal duty of care to the safe storage and of the firearm and the ammunition. They could point the fingers both ways, and a jury can decide whether or not both are not liable for the incidents that occurred.
Duncan sent another one before that I missed that said, more germane to this trial, I think, is this country going to suddenly start taking marriage seriously and assume both parents share an equal role in what their child has access to? If a dad buys the kid a gun, is the mom criminally neglectful if she doesn't loudly refuse or inject herself equally into custodianship of the gun at all times? These are all good questions. I mean, and it's not unusual at all. Like you were saying earlier, Brad, you're in Michigan. I'm in rural New York. It is not unusual for kids to have guns here. They do. They go hunting. every single season. It's like a big deal. Like you said, kids take off from school there.
Mhm.
They do here too. So that New York Times article, it's actually quite good. It's an opinion piece, and I want to read it because this person disagrees with me on what she thinks is wrong with what the problem is. I think she's trying to make, but she's doing it in a very subtle way. She's trying to make the point that we haven't done enough about gun legislation. I disagree. I think we have too much gun legislation, and criminals never follow any of the rules. So why do we keep making new ones? That's not working, you know? However, there's a lot of stuff in this article. Oh, I have to make an archive because I've used up all my free articles. Hold on. Archive.is. But there's a lot of argument in this. There's a lot of subtle points in this opinion piece that I think is really excellent. Let's read this. This is by Megan Stack, who is an opinion writer at the New York Times. What is this mother really guilty of? She writes. As the mother of a school shooter, Jennifer Crumbley's reputation... Oops, I forgot to put it on the screen. As the mother of a school shooter, Jennifer Crumbley's reputation has stains that can never wash clean. Mrs. Crumbley is now spending her days hunched in a Michigan courtroom, weeping at times as she listens to the testimony against her. The jurors may condemn her to prison, or they may absolve her, but she will always be a walking symbol of gun violence and bad parenting. On November 30th, 2021, Crumbley's 15-year-old son, Ethan, drew a 9mm semi-automatic handgun from his backpack and opened fire, killing 4 students and wounding 7 people at Oxford High School. His parents had bought him the gun as an early Christmas present. His mother celebrated by taking Ethan to a shooting range, an outing she called a mom and son day. Both parents faced and there's nothing wrong with that. Mom and son day at the shooting range. I mean, it's just literally nothing. That's normal behavior for a lot of people in America. Both parents faced charges of involuntary manslaughter. James Crumbley, Ethan's father, will be tried later. Prosecutors argue that their indifference to their son's collapsing mental health, even as they gave him access to the murder weapon, make them criminally responsible for his attack. It's a remarkable and unprecedented gambit. Hundreds of mass shootings have struck American schools in recent decades, leading to prosecutions of the shooter and civil lawsuits against schools, administrators, or parents. The Crumbleys are the first parents to face homicide charges for a school shooting by their child. I've listened to hours of testimony in the trial and in pretrial hearings on the dynamics of the Crumbley family and the events leading up to the shooting at Oxford High School. The more I've heard, the less clearly I've understood the case against the parents. I know, I feel the same way. Mrs. Crumbley doesn't strike me as an insightful or affectionate mom, or even perhaps a very nice person. But she's more complex than the monstrously callous and neglectful figure suggested by her dour mugshot and the few choice details about her personal life that have floated into the headlines. The case against the Crumbleys is more complicated than it sounds. The prosecution of the parents seems to be motivated, at least partly, by the grief of a local community and the ambient desperation of a country trapped in the reoccurring nightmare of mass shootings. Our politicians are ineffective. Word. The courts don't make headway. We can't even agree on what's causing the bloodshed. This sentence right here, we can't even agree. We can't even agree on what's causing it. So what hope do we have to fix it? Parents are worn brittle by daily awareness that our own child's school could be next. We can't fix the interlinked failures behind the slaughter, but we can sue schools and parents, and now we can drag the unsympathetic Crumbleys into criminal court. We crave villains to blame, a case to try, something tangible to do. Maybe at least it makes us feel better. This is a brilliant article. It's true. Some victims and survivors have managed to win damages in civil lawsuits against parents. These cases are often championed by anti-gun violence groups looking to make an example of carelessness. I do think it has a deterrent effect, said Alla Lefkowitz, a lawyer with Everytown for Gun Safety, who has represented survivors against shooters' parents, gun stores, and manufacturers. Nobody wants to be involved in a lawsuit like this. An involuntary manslaughter conviction, however, requires much harder evidence. Prosecutors need to prove that the Crumbleys knew there was real danger of their son attacking his schoolmates, but were indifferent to that result and wantonly neglected to intervene. We are approaching the parents with one of the highest charges in our criminal system, which can lead to the loss of liberty for extended periods of time based on the conduct of their teenage son, said Eve Brensike, Primus, director of the Public Defender Training Institute at the University of Michigan Law School. A layperson thinks, okay, you should have known better, but that's not the criminal standard. I don't know how the full trial will play out, but from all I've seen, I'm not convinced the Crumbleys had any idea or any way to know that their son was likely to kill. The only thing I would say there is they could have known if they had paid more attention to him. If they had paid more attention, if they had just cleaned that room, they would have found the headless bird in the jar. If you found a decapitated bird in a jar in your son's room, Brad, what would you be doing? What would you think?
I'd be trying to figure out what the heck was in his mind, because
Right.
unless it was quote unquote fresh, you wouldn't you'd be like, why do you have this? And then it's not, because even then, if the kid lies to you, you're not going to have a way to know, or unless you have the ability to pick up on your child's mannerisms to figure out if they're lying or not, to try and figure out what's going on. But
Okay, the chat thinks that they did know about the head in the jar because it was on the floor of the room, but did you see the picture of the room?
I didn't, but I can
You
imagine.
can't see the floor. You can't see the floor. I don't believe that they said that in the press, that they knew the jar was there, but then that's one of those things the press does where they say something and then they don't have any evidence in the article to back it up. They actually just said that they knew it, but there was nothing in the article saying that there was any evidence they knew it. And the room was such a mess and nobody cleaned it. Like his mother, okay, now listen, I have a 14-year-old going on 15. She's actually much better now about keeping her room clean, but she has ADD. And when she was a child, when she was littler, her room was horrific. And it wasn't something that she could clean herself. She was not capable of doing it. She would get very overwhelmed. She would get bad anxiety, and I would have to, me or her father would have to go in there and help her clean. Most of the time, I had to wait till she was out of the house, and I would have to do it myself because she wouldn't be able to let go of things that were broken or trash, you know? That was just part of her difficulties. She's gotten over that. I'm really proud of her. She's keeping her room so clean now. But as you become a teenager, you know, you're suddenly more interested in hygiene and things like that, you know?
I still have that problem. I can't. My office is pretty trashed.
Oh my God, you should see my office right now. I was actually thinking during the downtimes today, I might clean my desk. Like it's disgusting. Like this is, I need to get the vacuum cleaner out. There's dust bunnies underneath. It's awful. So we all struggle with keeping stuff clean. And
I don't know who said this, but someone made a mention of, I think it was an Instagram that I was following, and it was a matter of, I'm not the best parent, but I make decisions, and I could clean my office, I could clean the house, but I choose to sit and watch trashy shows with my daughter. Oh, it was the defense closing. She was saying, I do these things because I'm placing quality time with my child over things I know will help me feel better about the house and things that I know will nag me going forward.
Except if you're allowing your children to live in a pit, That's not helping their mental well-being or
Well,
your quality
right.
time. You know, like his room was a disgrace. I saw the pictures. No parent should allow a 15-year-old to live like that. If that means you have to go in there and do it yourself, then you have to go in there and do it yourself. And who knows what she would have found. I know she would have found the head in the jar. I know she might have found his journal. And in his journal, he was premeditating and planning this entire thing. And if I found the head in the jar, I would absolutely read the journal. Because that would be my indication that now I need to invade this kid's privacy. I need to check his text messages. I need to look at his internet history, and I need to see his journal. Period. If she had just done that thing, that one thing, clean the room, this could have been stopped. But yeah, she was too busy swinging in the Costco parking lot like a whore. I'm sorry, but that is what happened here. And I still don't think that this is criminal negligence for homicide, but it is criminal child abuse. It is neglect. Of all the cases I've seen where parents are convicted of child abuse, this one is absolutely worse than most. Like, the facts of this case are worse than most of the ones I've seen CPS take kids away for. Most of the time, CPS is taking kids away for bullshit. But if CPS came into their house and looked around and saw the state he was living in, where he had to move out of his room because it was so messy, and he was home all alone all the time and there wasn't food in the cabinets, that's neglect, my brother. That's neglect. So I think they could have gone after him for child abuse. Duncan, Idaho, thanks for the tip on locals, says YouTube censors super chats with the words gun and shoot. I really hate YouTube. They're a disgrace. But taking your child to the gun range, or even better, just to a quarry in the middle of nowhere to shoot and gain familiarity with guns, is a wholesome family activity. It means they were doing things together as a family. Well, the more I read about it, the more it seems that Ethan did not do anything with his parents except shoot. And I think that should have been a red flag too. That the only thing he wanted to do with his parents was go to the gun range. And if they had read his journal, they would have seen that he was plotting to get his father to buy him a gun so he could commit these murders. And he manipulated his parents into doing that. And they were not concerned with him because they didn't know what was going on in his life. And I'm sorry, but you got to be way more up in your kid's grill than that. What's not true, American Dreamer? I read his journal. I read it. It was horrific. It's online. You can read it. I don't want to read it here because it's that bad.
Vice read.
Legal Vices. Welcome to the chat, Vicers. What do we call you?
Vice Raiders.
Vice Raiders. Vicers. Where were the CPS reports from all the people seeing them arguing about and no food, etc.? Well, they were witnesses in Ethan's trial, not CPS. Nobody called CPS, I guess. There didn't appear to be any CPS involvement, but there certainly could have been based on the evidence that we have that came out in court.
There they are.
Where? What?
At the top of YouTube chat, it says Vices and their viewers just joined.
Is Vices what?
It says the raid has officially occurred.
Excellent. Get on in here. We are talking about Ethan Crumbley and his parents, and I think the state screwed up by charging them with manslaughter, but I think they definitely could have gotten child abuse charges, which I think would have been appropriate. I mean, if you raise a kid who goes on to kill other kids, and it comes out that you were neglectful of that kid, well, then you should face criminal charges of neglect, because neglect and abuse, that exists. It's on the books. So why not go after them for that? Why try to make new precedent by going after them for unintentional manslaughter? I think it's an overreach, and I think it's that no one knows what to do. No one knows what to do. And this is just not going to fix anything.
Do we want to? Legal Vice is asking. I've been
To
told
watch
that
the
I have
closing
to.
arguments.
Yeah.
Perhaps.
They're honestly short enough. We could probably do it.
We have time, but I do want to go over. I want to finish this article, and then
Right.
maybe we'll go back and watch that. One outstanding oddity of this case: Ethan Crumbley was charged as an adult. He pleaded guilty on all 24 counts, including first-degree murder, and was sentenced to life with no possibility of parole. During his sentencing, Ethan insisted that nobody could possibly have known about his plan and specified that his parents should not be blamed. "I'm a really bad person," he told the court. Prosecuting children as adults is a particular obscenity in our criminal system. It is my firm, albeit unpopular opinion that no child, no matter what they did, should be condemned to a life of punishment with zero possibility for rehabilitation. I actually agree with this. But that's an argument for another day. There is a logical contradiction in the state declaring Ethan Crumbley an adult with full responsibility for his crime, while simultaneously prosecuting his parents for gross negligence and child care. Ethan Crumbley was a child, or he wasn't. He was responsible for his actions, or his parents were. Can the state argue both positions at once? Prosecutors insist they can. While the parents have been excoriated for giving Ethan access to the gun, this is something of a legal dead end. Michigan, at the time of the shooting, did not have a safe storage gun law on the books. It does now. The Crumbleys were not legally obligated to keep the weapon locked away from their son. Prosecutors, then, have tried to build a case from the vagaries of the family's interactions as reconstituted from text messages, Facebook exchanges, and the testimony of acquaintances who, so far, haven't seemed to have known the Crumbleys very well or like them very much. The Crumbleys had their share of problems. We can puzzle over the true meaning of the fragments of family life and evidence, but all we really know is this: Ethan was depressed and struggling. Everything else, in the end, is open to interpretation. The vagueness at the heart of this case is not unlike the emotional haze that clouds our national response to gun violence. It's more about feelings and perception, about finding somebody to blame, than clear-cut criminal intent or meaningful reform. Ethan's father was between jobs at the time of the shooting and had been driving deliveries for DoorDash. The family needed Mrs. Crumbley's salary from a real estate company, but she complained to her husband that she hated the job. Their marriage had recently foundered. Foundered is not a word. I think she meant floundered, with reports of infidelity from both spouses. As the first sentence of a Detroit Free Press article put it, Jennifer Crumbley was having an affair while her son battled loneliness and often snuck off with her lover during breaks from work. Aside from the suggestive tone, which seems to imply, is foundered a word? It is? What does it mean? Foundered. Their marriage had recently foundered. What does it mean? Struggled? I've never heard that word used in that context.
Of a plan or undertaking fail or break down, typically as a result of a particular problem or setback.
A breakdown, a fail or breakdown. Okay, well, you learn something every day. See, I only promise medium smart commentary. This is not high smart commentary. It's medium smart. Sometimes we have to look stuff up in the dictionary. Aside from the suggestive tone, which seems to imply Mrs. Crumbley's alleged extramarital dalliance meant she couldn't have been a good mother, there is, can you though? Can you really be a good and involved mother when you are running around with multiple people and swinging in the Costco parking lot? Have we lost our freaking minds? Is that what a good mother does? I mean, yeah, I don't think so. I think we can safely say she wasn't a very good mother. Mothering was not high on her list of priorities. Again, though, it's not a crime to be a shitty mom. There has also been much discussion of her fondness for horses. Kira Pennick, a Michigan stable owner, testified about the 2 horses Mrs. Crumbley boarded. She started out with one, but bought a second horse online for $5,000 during a night of drinking, Mrs. Pennick said. Prosecutors have lingered over the time and money the Crumbleys lavished on their equestrian hobby, $400 a month per horse to board and feed, several visits to the stables every week for paid lessons and veterinary expenses. It's a lot of money that could have gone for Ethan and therapy and more food in the house. Just saying. The implication, of course, is that Mrs. Crumbley cared more about her horses than about her son. Well, she might have. Gonna get drunk and ride my horse, she texted her husband one March afternoon in 2021 after what she described as a bad day at work. This particular quote is now evidence against Miss Crumbley, one of the dumber pieces of evidence. There's nothing
on St. Patrick's Day.
That's nothing wrong. There's nothing wrong with drinking and riding your horse. It took place 8 months before the shooting. Later that same day, around 6 p.m., Ethan texted his mother to complain that the house was haunted. He was home alone and he was scared. I got some videos and a picture of the demon, he texted his mother. It's throwing bowls. Can you at least text back? He added about 25 minutes later. Mrs. Crumbley didn't reply. She is believed to have been at the horse farm where connectivity was spotty. Alex says, I don't think I'd get drunk and ride my horses. Not a great idea. It's not a great idea, but it's not illegal either. Some kind of domestic trouble erupted over those few days in March 2021. The Crumbleys 2 days later exchanged messages about how Ethan had been really worked up and out of control the night before. They described giving him melatonin to calm him down. There was also a suggestion that Ethan had been disciplined by losing access to some of his stuff. All I know is he needs to eat, go to work, and work hard, not complain, and he can get his stuff back, Mrs. Crumbley wrote. The next day, Ethan was home alone again, apparently tasked with tidying. I finished picking up the room. I cleaned until the clothes started flying off the shelf, he texted his mother. This stuff only happens when I'm home alone. These messages are the strongest evidence prosecutors have offered that Ethan told his parents he was experiencing severe mental health symptoms. There are disturbing texts from Ethan to his only friend complaining that he needed help, that his parents wouldn't take him to a doctor, and that Mrs. Crumbley thought he was on drugs and doesn't worry about my mental health. But there's no indication his parents ever saw those texts, nor is there any way to assess their accuracy. And the friend didn't tell the parents either. The demon text is different. Prosecutors say it proves that Ethan told his mother that he was having hallucinations, and that Mrs. Crumbley shrugged him off. That's a plausible reading. Or maybe Ethan, a lonely child in a turbulent household, felt pressured and upset by his parents fighting. Maybe he mentioned demons and haunted houses because he wanted attention, or hoped they'd stop leaving him home alone. Maybe he had a bad dream or a lurid waking fantasy that he presented as reality. Maybe in the strange storms of hormones and unfamiliar emotion that typify adolescence, he himself could not have explained what he was saying to his mother or why. The demon text above the other oddly harsh comments contained in her communications swings sympathy against Mrs. Crumbley. Who hears her son claiming to see a demon and then opts against taking him to therapy? But after that, as far as we know, 8 months passed without any major red flags. That's not to say things were going well. Ethan Crumbley's friend left school, his grandmother died, and so did the family dog. And then I also heard the press reported that his parents made him dispose of the dog, but I looked up several articles that had that claim, and there was no information on that at all. So I can't confirm whether that's true or not. If it is true, that's really sick.
Yeah, I don't know. We were living at the previous house, and they had a boxer, and this boxer was frequently getting out. And they left the front door open, but had the screen door closed. That dog went running through the screen door and ended up getting hit. And they took him to the emergency vet, but I think they said he passed on the way there. And then not like an hour later, Dad was in the backyard digging the hole that they would lay him.
Well, Dad can do that, but making your son do it,
yeah,
it's a little much.
They were there with him, but...
My husband has disposed of or buried many animals in our backyard. We have a lot of animals buried in the backyard, but never once has he handed my son a shovel and been like, go dig the grave. Or I don't know, but this is not confirmed. So we don't know if the media is lying about that or if it was a rumor. We don't know. It was not confirmed. Did not come into this trial that I understand, that I heard. Geez, my husband even buried my neighbor's dog once. They knew about it. It wasn't like he buried the dog. He didn't go over there and like just, kill their dog and bury it. The dog got hit by a car and they were on vacation, so he did it. But Ethan didn't get into trouble at school. Oh, wait. He'd struggled with anxiety and isolation while distance learning during the pandemic. His mother described him as weird. But Ethan didn't get into trouble at school, where he had a solid attendance and had been on track to graduate on time. There's no indication that he fought with other students, creeped out his teachers, or acted up in class. So discordant was Ethan's image with our notions of a school shooter, it seems that Oxford High School's assistant principal testified at her shock in seeing Ethan carrying the gun during the attack. She was so stunned, she told the jury that she couldn't process what she was seeing. It just didn't seem right that it would be him, said Christy Gibson Marshall. It was when I realized it was Ethan that I didn't think he could possibly be the shooter. It seemed so odd that it would be him, so I said, Buddy, are you okay? What's going on? When he didn't respond to me and he looked away, that's when I knew it was him, that he was the shooter. Finally, there is the question of the gun. With Christmas approaching and their son's spirit still slumped, the Crumbleys bought Ethan a new gun. This proved to be a ruinously irresponsible gift. We now know that Ethan had secretly been waiting for just this moment to carry out the attack he'd described in his journal. In the minds of his parents, though, the gun seems to have been a ham-handed effort to cheer him up. Even in the early hours after the shooting, during the Crumbleys' first talk with the police, a video of the encounter was shown this week at trial. Hold on, I'm getting a phone call. I need to respond to her.
Hold, please.
Where's my hold music? Hold, please. All right. Okay. He was a perfect kid. Oh, first, the parents appeared to be legitimately stunned to discover their child was suffering from anything beyond sadness. He was a perfect kid who never got into trouble, Mr. Crumbley said. Asked whether Ethan had any school suspensions or run-ins with the law, both Crumbleys exclaimed, "No, nothing." Firearms recreation may be repugnant to some, but it is neither illegal nor unusual. This disconnect, the different ways in which different jurors may regard the gun itself, could end up shaping the Crumbleys' fate. A lot of your cultural priors about guns and the ownership of guns will really inform whether you think these parents did something wrong, Ms. Primus of the University of Michigan told me. During oral arguments last year before the Michigan Court of Appeals unanimously ruled that the state could try the parents, Judge Michael J. Riordan sounded troubled over this problem. There's nothing wrong with being interested in guns or letting children shoot. Heck, all these American Legion halls throughout the state have shooting classes for kids. So what's the precedent we're going to set here? Asked Judge Riordan. There are a lot of families with kids who might not be as stable as the parents would like them to be, he added. Is it the kid bullied at school comes home complaining about that? Lock up all the guns. Is it the kid seems down? Make sure the kid doesn't go to school. What message are we going to send with this case? Unambiguous signs of crisis flared in the 24 hours before Ethan attacked. But the adults around him, not just his parents, but the school officials trained to spot danger, grievously underreacted. The day before the shooting, Ethan was sent to the school counselor for researching ammunition on his phone during class. Compliant, calm, understanding is how a school counselor, Sean Hopkins, during a pretrial hearing described Ethan's behavior that day. Ethan told the counselor that he and his mother had recently visited a rifle range and that shooting was a hobby, Hopkins testified. The school called Mrs. Crumbley, who scolded her son by text, but added in an apparent attempt at lightheartedness, "You have to learn not to not get caught." The following school day, Ethan was once again sent to the counselor. During class, he'd been watching a violent video depicting shooting and had covered a geometry worksheet with pictures of a gun and a bleeding body, writing, "My life is useless. The thoughts won't stop. Help me," and blood everywhere. Mr. Hopkins had been persuaded the day before that Ethan was fine, but now he got worried. He testified not that Ethan would hurt others, but that he might be having suicidal ideation. The Crumbleys were called again, and both parents drove to school, where Mr. Hopkins warned them that Ethan might be a danger to himself and should not be left alone. The counselor told the parents it was urgent they take Ethan to the therapist, that very day if possible, but certainly within the next 48 hours. At some point in the meeting, the period ended and students milled around switching classes. At that point, Nicholas Ejak, the dean of students, fetched Ethan's backpack from a classroom, brought it back to the administrative offices, and handed it over to Ethan. Nobody, neither the parents nor the school officials, looked inside the bag. Had they done so, they'd have seen Ethan's gun. Survivors and family members of the shooting victims are fighting in court for the right to sue the school, which has so far been shielded by Michigan's government immunity laws. Motherfuckers. Mr. Hopkins, the counselor, testified in pretrial hearings that he found the parents strange during the meeting. They didn't hug their son, he said, not when they arrived and not when they left. He was also surprised they didn't take Ethan home from school right away. The Crumbleys, however, appear to have been focused on the advice that Ethan shouldn't be left alone. Mrs. Crumbley's text to Miss Pennock, hold on a second.
Gosh darn it.
Wrong text. I sent that to the wrong text. Darn it. Don't you hate it when you do that?
Yeah, it's definitely not fun.
I have
but
too many of the same named people in my phone, you know? Like, how do I do this? I need to get to the person who just called me, recents. Aha, there we go. And send it again. Hold, please. Okay. I texted one of my old friends on accident.
Whoops.
All right. The Crumbleys, however, appear to have been focused on the advice that Ethan shouldn't be left alone. Mrs. Crumbley's text to Miss Pennock, the stable owner, described plans to bring Ethan with her that night while her husband worked. She specifically mentioned that the boy must not be alone. Both parents had to work that afternoon, and Ethan didn't like missing school, so keeping him in class for the rest of the day may in fact have looked like the most practical option. Alex says, I'm listening to Meg via the Sonos system, and my housekeeper is bopping to your hold music in the kitchen. Well, bop away. It's better to dance while you're cleaning and getting your chores done, isn't it?
Right.
By the way, Alex, I need a housekeeper. Send me one. Man, I've always wanted like on the Brady Bunch, an Alice, you know? Everybody
nanny.
needs an Alice. Yes. Ah, it would be great to go downstairs and have an Alice bustling around in the kitchen, doing dishes and cooking me something fabulous. Wouldn't that be
Back in the
great?
60s when you could afford such trivial things.
Right. Such luxuries. Yes. As someone to and the crazy part about that was Mrs. Brady didn't work. She was a stay-at-home mom, and yet she still had a full-time housekeeper. Yes, please. Yes, please. I need that. Alex, did you already move? Did you move? Are you back in Illinois? I didn't know you had gone yet. Both parents had work that afternoon. Okay. And so Ethan was turned loose yet again into the school. A short time later, his mother texted to ask if he was okay. You know you can talk to us, she wrote to her son. I know, thank you, he replied. I'm sorry for that. I love you. He ducked into a bathroom, pulled out his gun, and headed out into the hallway to murder his schoolmates. The first bullet was fired about 10 minutes after his last text to his mother. It was a crime like countless others, a familiar choreography in a country that has decided it can't do anything about guns. All we can do, it seems, is punish the people we can reach and go to sleep at night hoping that it will somehow help to stem the violence. Now, this is the only thing about this article that I kind of disagree with is that it's not that we've decided we can't do anything about guns. Our country was founded on the right to bear arms, period. It is the Second Amendment of the Constitution. It is not negotiable, not for any reason, including psychos that use guns to hurt people, because psychos will always use guns to hurt people. Bad people will always do this. So if we disarm, we'll be the victims with no defense, period. And half the country thinks like me, and half the country thinks like the New York Times that we need to get rid of all the guns. And if we really were able to get rid of all the guns, let's say we buried we blew them all up. We got every gun in America and we destroyed them all and melted them down. There are still knives and rocks and explosives. And sick people who are intent on murdering will use those tools to do it. There are ropes, and there's all kinds of ways to kill somebody.
The first school tragedy was gasoline. It was in a town about an hour away from here called Bath, the Bath Township massacre.
Oh my goodness. Oh, I think I remember. I heard about that. I read about that. Yeah, it's just, I liked this article though. I liked a lot about it, especially the part about how no one can agree what's causing this. Like, no, we have no idea. And so meanwhile, we're running around just trying to play catch up and punish people. Like now we're starting to punish people who weren't even connected to the crime, because nobody knows what to do. Yeah, don't forget cars, poisons, homemade explosives. There's all kinds of things that people intent on harming someone will use and do it. That will never change because evil exists. Mental illness exists. Violent people exist. So what's better? That you have a fighting chance against some of these psychos? Or that we're all sitting ducks? So it's a difficult thing. I understand it's a difficult thing, but I don't know that going after these parents for this particular thing is going to help at all. I don't think it's going to stop the next shooting. I don't think it's going to improve anybody's parenting. Although maybe we can improve some of our parenting. Maybe we can be more attentive to what is happening online. And at 3:30 today, I will have a BARC representative here to talk to us about that product and what it can do, and see if it would have found any of these upsetting things. By the way, Ethan Crumbley is still, to this day, looking at violent stuff on an iPad in jail. They found him 2 times now getting around the safeguards that the jail had on the iPad he was supposed to be using for school. He's supposed to be getting his GED. And he has been using his access at the jail to look at the violent gore sites of dead people.
Jesus.
There's something wrong with this kid. Like and yet the psychologist only found mild depression. So the psychiatrist that they hired at his to do his Miller hearing or whatever, said that she found medium to severe depression at first, and then after therapy downgraded it to mild depression. So what does that mean? He doesn't have a mental illness? And if he does, because depression, is depression technically a mental illness, or is it a condition? I'm not sure. But if he doesn't have a very severe mental illness, how are his parents, who are not psychologists, supposed to know? I mean, I would argue, though, that if they were more attentive parents, they may have seen the red flags. But the state's burden was to prove they did see the red flags, and they negligently did nothing. And I just don't think they got there. All right. Did we find the jury instructions? Did anybody look for those for me?
I didn't look for it. Judge said that she was sending it to media, but I don't.
Okay, hold on. Let's see if we can find him. Should we watch the closing arguments again? I kind of wanted to. Let's see. Jury. Jury instructions. It doesn't look like anybody has published them yet.
No, I don't see it.
Let me ask AI. Bing is pretty good at this sometimes.
It was the amount of paper that she was holding in her hand was voluminous, and it seemed like jury instructions went far quicker than other times.
Yeah, they weren't that I may listen to them again. I actually think we need to listen to them again if I can't find them written. I was going to read them, but I'm thinking I want to go back and actually listen to them.
Because we got it done in jury came in 15 minutes late, so they did it in about half hour.
Yeah, it was. Yeah, let's go back and listen to those jury instructions. Brad, you want to pull it up and go back? I'm going to get my notebook out. I can't find them published anywhere. If anybody does find them, post it in the locals chat for me, would you? Normally, Bing's AI tells me where to find the actual documents. But I'm not seeing it. Let's see. Can you find the actual jury instructions from the court, Jennifer Crumbley?
I don't know if we can rebroadcast the Zoom feed, Lois, let alone go back and forth. So
we can't go back during a live? We should be able to.
No, a Zoom. Lois says the Zoom has the best audio. And of course it does. But
Oh yeah, no, Zoom is not, you can't go back for that. Wow, I stumped Bing. I stumped AI. It's still searching. It's searching. It's funny.
All right, here we go.
Okay.
Arguments in this case are finished, and I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken a note to return to.
But look at the amount of paper that she's got in her hand. That's at least 30 pages, if not more.
Well, maybe it has. I bet it has the verdict sheets too.
Yeah, it could be the verdict sheets, but and I've noticed that during, especially with written decisions and whatnot, they use that really weird condensed format. Like if you're reading the text language of a law or something, where they have all the lines numbered out and whatnot, it only takes up like 2/3 of an entire page, even though the margins could go significantly bigger.
Mm-hmm.
The true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you in the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you're satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses, are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial of excluded evidence that was offered or stricken testimony that was heard, do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, You should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender or gender identity or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how...
I mean, this is all usual stuff. I'm waiting to get to their specific instructions. We should skip forward through this because this is just general shit. I want to hear the elements.
That either one is guilty. You should only consider the evidence presented in this case.
Yeah, we know all this.
The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must and in fact actually see or hear. For example, if you look outside and see rain falling, that's direct.
Yeah, keep going. We know what the...
Can also be proved by indirect
let me
or
see if I can get
circumstantial
the
evidence. Circumstantial evidence is evidence that
transcript.
normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining.
Yeah, we know what all this means. I want to get to the burden, the state's burden.
Talk to one of the witnesses. There's nothing wrong. This is Edward Wagorowski, who is giving you his opinion of involuntary manslaughter. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness.
Yeah.
Hold on.
In count one,
So annoyed right now.
There. Count one.
Involuntary manslaughter.
All right.
To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, that Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing that act caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Tate Meir's death, the defendant...
Okay, so 1, 2, 3, and 4, or count
only
1 is
four.
going to be 4 counts. It's all the same.
Yeah.
To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count 4, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Justin Schilling. That is,
All right, pause.
Schilling
Pause. Already, they didn't prove this count 1 because, for one, Jennifer Crumbley wasn't the one who stored the firearm. It was her husband. There is proof in Ethan's journal that he didn't know where the gun was and he was looking for it because he said his father hid it. So right there, and there was no law in Michigan that said they needed to store it out of his control or out of his possession.
Right.
So how do you prosecute someone for keeping a gun somewhere were they legally able to keep it?
This is where I would hope one of the lawyers would step in. But if I was a lawyer, or if I was a prosecutor, and you attack it a couple of ways, it's knowingly stored it and this is where the negligence standard comes in, is that you have to know that by storing it in such a way that that Ethan would not be able to access it, because you know that there's a risk and you willfully disregarded the risk of leaving it or storing it in a manner that if
But
he
it sounds
found
like
it,
they didn't store it in a manner where he could easily access it. He didn't know where it was. He said his father hid it and he had to find it.
But-
and the key was hidden in a beer stein somewhere, which he found.
right.
But so they clearly tried to hide it. They tried to keep it locked up.
So
And
it's-
then you, but that's just the first element. The second element was, and in doing so, were grossly negligent. Grossly negligent is not locking a gun up and hiding the key.
Yeah.
The grossly negligent is not an accident. That's two different things. Yeah, Laura is right. This is not the way the law was meant to be applied in any way. This is not gross negligence. Oh, the dog cam. I totally forgot. Oh my God.
I mentioned it before you came on.
Oh, I totally forgot. I'll go set it up. Brad, keep taking notes and listening to this. I do need to hear what the second count is though. So, but she's going to repeat it 4 times. So I should be able to get that done.
Oh, you mean the second element?
Yeah.
Yeah.
Yeah. I should be back by then.
Storing a firearm and its ammunition so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner.
Yeah, it's just the gross
As I
negligence.
explained,
It's the second element is you have to be grossly negligent in doing so. The first element is that the person died as a result of storing a firearm and ammunition so as to allow the firearm and ammunition by their minor child. The second is, and in doing so, were grossly negligent. But then something like this comes down to, well, if there's a key, is there only one key or is there 2 keys? And why is the key kept in the house accessible to the kid when it could be on dad's key ring or mom's key ring, so that it's not being gotten to when elsewhere? And that's where the bigger problem is. And Sunflower brings up a point about the instructions do not say what gross negligence is, and I don't remember if they explained what the gross negligence standard is. But in listening to the defense, I didn't hear them attack the gross negligence standard either, and say because they only brought Jennifer up for closing. They didn't bring any witnesses or anything and say, is storing a firearm in a handgun case or whatnot with a key an appropriate method of storage? And then you could even argue that they were storing it in a way that would be amenable to the gun storage law that was subsequently passed before it was even introduced. I think the defense did a terrible job in defending their client, but I do think that the appeal to emotions that the Shannon did in the closing arguments was better than their whole case against, or their whole, I'll call it defense in chief of Jennifer, talking about parents being busy and whatnot. And that doesn't mean that they were terrible parenting. I have questions. Wrong. There is safe storage laws in Michigan now. They created the safe storage laws because of this case, because of the Ethan Crumbley school shooting. In fact, it goes into effect here shortly. I have questions. No, you can't retroactively charge them on the law. I agree with that. But what you can say is that you can argue that by storing the firearm in a gun safe and hiding the key, that they were doing the things that are prescribed in the now passed law, and say that they would have met the burden of the current or the future law. You're not charging them against it. You're arguing that you would have already met the standard. Think of it this way. If you gave a multiplication test to a class of 4th graders, and everyone does the test, and then say, okay, now that everyone has finished the test, if you got an 80% or higher, you are getting a lollipop. And then the idea is that they would have, you met the standard and you've already done it prior to the announcement of the law or reward, etc.
Okay, hopefully he'll stay there. I gave him his ball treat. It's got the treats in the ball. So hopefully his bed got moved.
Oh.
So I had to move the camera.
Yeah,
It's
he
not
looks like he's hanging out with it.
Yeah, he's deciding to look for the treats. This is funny.
Did you hear that little soliloquy of mine?
No, I wasn't listening.
How dare you?
Sorry.
So the idea is that the second element, because we listened ahead, is just causing the death of the person, and in doing so, acted with gross negligence. So it's just the gross negligence standard, but they didn't explain it. They just went right into the next count.
Well, that's weird because the first one they said it was causing the death by storing the gun improperly.
That's the first count. Or that's the first element.
And the second is just causing the death.
In doing so was grossly negligent.
Okay.
Ammunition, so as to allow access to the firearm and ammunition by her minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner.
That's it.
As I explained earlier in my instruction.
So there wasn't anything else. So, but they don't explain what gross negligence is. I don't think defense argued what gross negligence is, and my whole point was that if I was the defendant counsel, I would argue that by storing it in a locked area with a key hidden elsewhere and say that we were applying what would become the standard for the gun storage law that's about to be made active here in Michigan, and said that it was not gross negligence because we would have been following the law that was passed in response to this issue.
Okay, what's the next one?
Oh.
The prosecutor asserts two different theories to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because she failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because she was grossly negligent. Those theories are two different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter.
You don't even have to prove both?
It's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt.
That's horseshit.
Yeah.
In count one, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty as involved with. The legal duty charge.
Failing to do a legal duty. And they've never explained how she had a duty to those other children.
Yeah.
I know she has a duty to her own child, and that's why I don't understand why they're not charging them with neglect and abuse of their own child. Here, I made a new layout. Look. We can put the Archie Ruckus cam a little bigger since the camera's a little farther away. Oh wait, I forgot to add the screen in there. Hold on. At the screen share. Edit, add item, media slot. Yeah, let's put the court over here. Save. Okay. Update. There we go. Perfect. All right. So now it's just failing to do a legal duty, but I swear I never heard the state explain to me how they had a legal duty to other people's children.
Yeah.
The school did. The school has a legal duty. They are in loco parentis. They are the parents when there are no parents at school. They have a legal duty. I do not think I have any legal duty to another person's kid. And I didn't see where they proved that in the law. Did you?
I didn't see where they proved it in the law, and the defense argued very poorly in their defense in chief. They didn't attack anything of the legal standards. They just tried to defend the conduct of Jennifer in saying that she was a bad mother, and they didn't do anything else.
Yeah, okay, we can keep going. Yeah, I don't think they proved that either.
One imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others.
Okay, stop. Stop. In Michigan, she said parents have they have to exercise reasonable care to prevent their child from harming others. Now that's interesting. So where is that in the statute?
I actually need to bounce out for a meeting, so I will be back.
Okay, I'll see you later. To prevent child from harming others. Okay. Oops, we have to change this now. Why did that disappear like that? Oh, Brad had the whatchamacallit. Okay, so now I have to go and find the live stream. I don't know where we were. Present, share screen, share. And Ruckus Cam needs to be moved. Edit camera 2. Huh. Why is it doing that? Here we go. Save. All right. In Michigan, parents indeed have a duty of reasonable care to prevent their child from causing harm to others. This legal expectation means that parents must take sensible precautions to ensure that their child's actions do not endanger others or create an unreasonable risk of bodily harm. Here are some key points related to this duty. I feel like my head is too small. There we go. Is that better? Okay. Parents are expected to exercise reasonable care and control over their minor child. They should prevent the child from intentionally harming others or engaging in behavior that poses a risk to others. This duty applies when parents have the ability to control their child's actions and are aware of the necessity and opportunity to do so. When a child is in imminent danger, Children's Protective Services must take prompt action to protect the child. Okay. Yeah, please don't use words in the chat that's going to get my channel demonetized, please. Just be careful that you know what YouTube doesn't want you to say so you can find other ways to spell it or get your point across. Strategies include temporary voluntary arrangements. No. Reasonable efforts standard. While reasonable efforts are a legal standard, this is about CPS. Okay, all we have is the reasonable care and control standard. And I'm looking up more about this. Let's see. Is there a punishment attached to this if you don't? Hold on, I'm reading through this. I found this article on Law and Crime. See if it answers my questions. I mean, I think they might have proved this. They might have proved this. Well, maybe not. Well, wait a minute. Do you have to have all three things or just one? Oh, it says to prove gross negligence, the state must prove the following three elements beyond a reasonable doubt. Well, then they didn't do it because they can't prove the first one. The first one is that the defendant knew of the danger to another. That is, the defendant knew there was a situation that required him or her to take ordinary care to avoid injuring another. And I don't think they proved that they knew. I don't think they did. I think they proved, though, that the defendant could have avoided injuring another by using ordinary care. If she had paid even the slightest attention to what her kid was doing and looking at online, I think it could have been avoided. So the second element, I say the state proved that. But the first is not proven. The third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. Again, they can't prove that because if you didn't know the danger was there, there's no way it was apparent. The second one, though, I think they've proven, but you have to have all three. You can't just have one. You have to have all three. All right, what's happening in the chat? Are we having a problem? What's going on in the chat? Ryan, if you're causing problems, we're going to give you a timeout. Mods, you can give him a timeout, okay? Don't cause problems in the chat. Just don't. I don't have time. Ain't nobody got time for that. Just stop it. Look at how good Archie Ruckus is being, staying in his bed. He likes his little treat ball. I put a bunch of little treats in his treat ball. Yeah, Ryan, don't come in my house and cause problems. I will kick you out of my house. So you can have a timeout for now. I've asked you not to do what you're doing. So quit it. I don't have a problem with you guys saying what you want to say and using all the curse words you want to use. But don't use the words that are going to get me yeeted from YouTube, and don't attack one another, okay? All right. And if he comes back after his timeout and does it again, well, then he's gone. Goodbye. The mods know what my rules are, and I trust them to keep them. All right. Moving on. Next, prosecutors have alleged gross negligence or a failure to perform the following legal duty. Here's their verbiage on those allegations according to the charging documents. Failure to exercise reasonable care to control his or her minor child so as to prevent him from intentionally harming others, or from conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he or she has the ability to control his or her child and knowing of the necessity and opportunity to do so. Yeah, I just think if they fail on these things here, the gross negligence, which they failed on 2 of the 3, in my opinion, they need to stop. They didn't do it. Okay, we're still not done in the chat. Okay, what happened? It was an N-word without a hard R. I mean, I don't care about that. Does YouTube care about it? I really don't know. I really don't know. But no, I do not care about that. And anybody who's getting offended by people saying words needs to stop. Don't be offended by words. I just don't want people using words that are going to get me yeeted or demonetized. Rogue Mama, I think probably not. Can you imagine? Do you know how many of those words I actually hear them on all those Ben Shapiro reaction videos? Do you know how many times that word was dropped with a hard R on the reaction videos? I mean, I'm not going to say it, but a bunch of people on YouTube are out there saying it, but they're the right color. They can say it. I'm not allowed. Chat is fighting in the back seat. Don't make me get my slipper. Don't make me come back there. I will pull this chat off the road. I will turn this chat around. Now, everybody get along. Archie Ruckus is being so good. It's funny. All right. Do I think she will be found guilty? Well, it depends on how many woke Karens are on the jury. But this is a really difficult case, you guys. Jennifer Crumbley is a very unlikable person. Period. Yeah, I'm only 4% the right color. That's true. We learned that that I have 4% Senegalese in my DNA. So I'm only 4% the right color, which I do not think entitles me to use that word. So I won't be doing it. And also, I really don't like that word. I think it's really offensive. But I don't care if other people use it. Just don't do it on my channel. Okay. I think Jennifer Crumbley is really unlikable. I think the decisions that she made as a mother are unthinkable to most of us. And not the gun. The gun is not the thing that bothers me. The thing that bothers me is that she had no idea what her son was into. She had no idea what his inner life was like. I know more about K-pop than I ever wanted to know. I know so much about BTS and Stray Kids. I know so much more about all that shit than I ever wanted to know. I don't want to know any of it, but I know it because I have a daughter who's into it, and I need to pay attention to what she's into. Otherwise, how am I going to know what it is she's doing? And his parents had no idea what was going on in his life, in his inner world. And then he had some friends who did know, and yet nobody said a word to his parents. It's a really tough case. I think we could easily look at these parents and be like, you know what? They're negligent in raising their son. I don't think they're negligent in the murders. I think they abused and neglected their son, who then went on to kill others. And one of the reasons is because one of the reasons they didn't catch this is because they just weren't interested in his life. I am totally suffering PTSD. I'm going to tell my daughter that. She's going to laugh out loud. But yeah, I have a kid who just loves K-pop, and it's just everywhere. It's all over my house. And I have to know about it because I have to know what she's into. You have to know. I mean, if you don't know, well, then what are you doing? What are you doing? Why do you have kids if you don't know what they're into? You have to talk to them. You have to find out what they're into. You have to spend time with them. Speaking of spending time with my kids, we did something really fun yesterday. I want to show you. Have you guys ever heard of encaustic painting? A neighbor of mine gave us a encaustic painting kit, and Ferry and I, we broadcasted our painting on Locals yesterday. So if you're a Locals member, you got to see that. MeganFox.locals.com. And this was some wholesome family activity we did yesterday. Let me pull up what it looks like. How do I share this instead? This is so cool. Now, encaustic painting, let me try and make this a little bigger. Edit. There. Okay. Encaustic painting is where you get a pancake griddle. Let me show you the pancake griddle. And you have these wax paints and you melt them at 175 degrees on the griddle. And you use like hog's bristle brushes or natural hair brushes and a wax medium to thin it. Does it ruin the griddle? Well, I think it can be cleaned, but I'm only using it for art. I have another griddle. And this was one that I did. This is the first one that I did. I'd never done encaustic painting before. It was really kind of hard because it dries really fast. So you have to move very quickly, and it builds up with this really cool texture very quickly. And if you don't like something, you can scrape it off and start again. I didn't like my sky at first, so I scraped it all off and I did it again. And so the tools that you use are like scrapers and palette knives, any kind you could use like sticks like to scratch in the wax. And this was Fairies. How cool is this? She did all these different layers of blue. Oh yeah, you could use aluminum foil on the grid. Bye, Squid. Sorry you have to go. Later, Squid. And this was one of the ones I really enjoyed. This one, my little field of poppies, was fun. But yeah, it was really satisfying. Very satisfying art project. Very fun. We had a good time doing that. So we filmed that. We put that on Locals, and it was fun. Check it out. You can watch the replay if you want to. How you doing over there on Rumble? How's the Rumble ghetto going? Okay, everybody's over there. They're all happy in the chat. There's no fighting going on in the Rumble chat. Alex wants to know what the hell is K-pop? Oh, Alex, you don't have a teenager. K-pop is Korean pop music. Look it up. I mean, they're pretty good. I mean, they're not bad. I guess they're better than our pop stars. They're certainly more wholesome. I'll tell you that much. Of all the things that she could be into, I'm not disturbed by it. Are there anything disturbing in those paintings? Better have them analyzed. We were just messing around, to see what does this do? What does this art look like? And I mean, look how cool this is. I should have taken a picture of it from the side so you could see how tall it was standing up. Very cool. So anyway, that was fun. If you're looking for some kind of fun family things to do that don't include gun ranges with your kids, you could maybe get into encaustic painting, because that's a lot of fun, and we had a lot of fun doing this. All right, so getting back to what were we doing? Oh, at 1 o'clock, we are going to be talking to CJ Grisham, an attorney in Texas, who has a client who did a hilarious thing. Hold on. Let's pull this up because you guys are going to laugh. We're going to talk to the attorney who represented this man who got kicked out of a board meeting for swearing. And it's one of the funniest videos that I've ever seen. Now, there will be unbeeped swearing. Here we go.
Make a statement of factual information. Recite exhibit.
Oh, not again. YouTube. For crying out loud. Please stop doing this.
Existing policy advice that this subject may be placed on the agenda for it.
Jason Paul, one of the only people in the room that tells you the truth. By the way, your citizen's comments are bullshit. Everything you just said is not your fault. I can personally affront you because you do whatever I want. You have to listen to me to work for me. You need to remember that way. All right. G. Blanchard, you piece of shit. G. Blanchard, 1240.
Blanchard, you piece of shit. That's how he starts this out.
7, you speak.
Now,
Excuse me?
I just read you.
And you're wrong. You're lying to the public.
I'm not going to put up
I'm not going to put up with
any
you.
defamation of character.
That's not defamation of fact.
I don't care.
You
I'm
have
not
to-
going to put up with no profanity or anything. You either act like an adult and speak right to everybody that's here, and you have the privilege to speak your mind. For 3
Privilege.
minutes.
You work for
I'm
me,
just saying.
boy. You need to
I'm just
remember
saying.
that.
Go ahead.
That's your warning.
Okay, I'm telling you.
Now rewind my clock while I finish my statement.
Go ahead.
Thank you, sir.
Strong opening. That's what my speech teachers always told me I should start with. Coming in hot. This makes me laugh, especially because the county official or whoever, like, I don't even care what this guy's talking about. Like, I don't even care. The county official is so wrong when he says, that's defamation. You can't use defamation. Actually, yes, he can. Yes, he can. He can use, Jules, they're in the South. People call each other boy all the time. That's just a figure of speech. And nobody on that panel appears to be anything other than white. So I think it's fine. But the person speaking, saying, well, that's defamation. Well, here's the good thing about that. You're allowed to defame someone in public. The remedy to defamation is to sue them in civil court. But this guy at this bench has no right to stop him from defaming anybody because it's free speech. The consequence for using defamation, actual defamation, the consequence for that is a lawsuit. But you can't shut somebody up just because you think they might be defaming someone. Defamation is a legal conclusion. So you would have to be a judge and a jury to figure that shit out. Jules, I think he uses the term boy to demean them, which is his right. Because the term boy is basically just like saying, you know nothing.
Chief Blanchard, $1,247 fitted suit you stole from the company. From us. You work for us. On 9/10/23. Terry Scruggs, you lied to
Well, apparently he thinks there's board members here stealing money.
the public. Terry Scruggs on Facebook stated that these personally fitted suits were pre-approved by the council and manager in 2011. Jason Knight's dad was that mayor then. Guess what he said, Terry? Never approved that. Laugh at me all you want. Modifications to the policy manual took place almost 40 days after I complained about him. Y'all modified it. Why did y'all modify it? You know when it was modified before, Terry? Not 2011, I do. 2019, 2014, 2004. You lied to the public. Even with the recent modifications, a Class A uniform is the highest uniform APD has, and it is not a suit, you scumbag.
You
Uniform Class A.
scumbag.
Did you have a dress hat? No, you did not. Long sleeves, did you have that? Yes, you did.
You scumbag. This makes me laugh so hard because they're so upset. Oh, they're so upset. Yes, somebody hit the alarm button. You scumbag.
Yes, trousers, yes, skirts. I mean, maybe. Black belt. I'm talking. It's my turn to talk.
A personal attack? Oh no, it's a personal attack. Whatever shall we do? Someone came to our town hall meeting and launched a personal attack.
I don't give a crap what you say, you piece of shit. Okay, now, there it is.
I don't give a crap what you say, you piece of shit. I really, really, really want to go to a meeting and speak like this, but I'm just much more polite than that. But even when I do it, and I don't use words like this, they still kick me out. You've seen me talk to them, and I don't use words like this, and they still want to have me arrested.
I can talk like that. It's a First Amendment right. See, Blanchard, what First Amendment right did I violate? No, I'm not. He's the cop. You tell me.
I'm not.
What First Amendment right did I violate?
I'm not. You're either going to
I'm
respect
asking
this
you a
place or
question.
you're going to be asked to walk out.
Oh boy.
Am I under duress of arrest?
Oh, stupid YouTube. So of course the cops were coming in they came in as soon as he started using swear words, and now they're going to come and take him away. Oh, come on. Yeah, nobody likes being attacked personally, but if you really can't handle it, then you should not be a politician.
Okay, now, there it is. I can talk like that. It's a First Amendment right. See, Blanchard, what First Amendment right did I violate? No, I'm not. He's the cop. You tell me.
I'm not.
What First Amendment right did I violate?
I'm not. You're either going to
I'm
respect
asking
this
you a
place or
question.
you're going to be asked to walk out.
Am I under duress of arrest?
You're going to go to jail if you.
I'm going to be arrested. Fine. Okay. Here.
His lawyer was sitting right there. Now, this is CJ Fearson. He's going to come on the program at 1 o'clock. That's in half an hour, and talk about this case. So this man's lawyer was sitting right behind him, CJ Fearson. He's coming up to tell this board what's what.
Oh, I can go. Mr. Mayor, City Council, my name is CJ Grisham. I'm a civil rights attorney here in Texas.
Grisham.
And
I got his last name wrong.
what I just
Grisham.
witnessed was a violation of Mr. Followell's rights. Let me read something to you. Arresting someone in retaliation for the exercise of free speech rights is sufficient to chill speech as an understatement. This is Beck v. City of Upland. Arguing, even if done loudly with a profane or offensive language will not, in and of itself, constitute disorderly conduct. That's Payne v. Pauley. Swear words do not provide probable cause for an arrest for disorderly conduct because the words, as a matter of law, are not fighting words. Johnson v. Campbell. I could go on, Mr. Mayor. Your rules of decorum are unconstitutional, and they're setting the city up, you individually, for liability. Now, you will be seeing a letter from me, a demand letter for violating my client's rights just now, because he has the right to say fuck, shit, damn, bitch, cunt, whatever. He has the right to say all of those words. Because
oh, wait, jury's back. Okay, hold on. I'm bringing it up. Hold on. Are they just wandering around? I have a feeling that this jury is going to be back rather quickly. But it looks like we don't have sound yet. So I will continue to monitor this while we play the other thing. I need to close some windows. But this video gets even better.
Because it is a First Amendment right. You can't do anything about it. Let me tell you something. The law
you can't
has
do
long
anything about
established
it.
that arresting an individual for publicly displaying vulgarities violates the First Amendment. That's the Cohen case, 1969. Indeed, the Supreme Court recently held that a public school violated the free speech rights of a cheerleader by suspending her when she said things like, fuck school, fuck softball, fuck cheer, fuck everything. Then there was another, that's Mahoney Area School District, VBL.
She was basically like, fuck this shit, I'm out. And they went after her and kicked her out of school for it.
There's also HSV Steelman saying that a police officer was not entitled to qualified immunity for arresting a plaintiff who said, fuck you. Did you hear that?
Like, wait, did you hear that?
For arresting a plaintiff who said, fuck you. Did you hear that?
I know the jury has a question. I'm listening to it. There's still no sound. They're just milling around. We're gonna, as soon as they start talking, I will bring them back in.
No qualified immunity. So I can say fuck throughout my entire 3 minutes. I can say fuck again, and I can say fuck again, and there's nothing you can do about it because it's called expressive speech. We are allowed to express ourselves. We are allowed to fucking talk about what we think about you. If I think you, Mr. Mayor, are a tyrant, I can say that. If I think the city manager is a piece of shit, I can say that. It's protected. This is the case law. I don't give a shit what you think. The law is right. You escort me out, I'll sue you as well, Mr. Mayor. This is the law right here. And if these chiefs come out here and pull me out of this meeting, you had better read this, chief, because he's telling you to break the law. Yeah.
Oh, yes, you are. Oh, yes, you are. You're telling him to break the law. You bet your ass you're telling him to break the law. Hey, Brad. Brad's back.
Hello.
Hello. Where are you? I can't see.
Hiding.
Oh, I must have screwed up the camera. Where?
You don't need to see me. I'm just the talking head with a goatee.
There you are. All right, here. I'll put you over here. Do you love this guy or what?
I'm completely coming in brand new, so.
Oh, okay. Well, we're watching I'm going to have this man actually come on at 1 o'clock. He's coming on to talk to us about this. Yeah, if Fred Durst was a lawyer. That's a good way to put it. Yes, thank you, Unhung Hero. I appreciate that. Max Bang, I will now request that my attorney wears camo and swears like a champ. So they escorted his client out of a meeting for swearing. And he gets up there and just unloads on them and tells them what the law is. And he's like, you can say fuck you. Did you hear that? I can say fuck you in a meeting.
Now, where did that coward Kerry Scruggs go? Where did the coward Kerry Scruggs go? Is my 3 minutes up?
You're gone.
What am I gone for? What am I gone for?
Violating the rules of the decorum.
No. His rules of decorum violate the law.
Goodbye. You're going to go to jail for disrespect.
Oh, you're going to arrest me? Oh, you're going to arrest me? Okay, so under the threat of arrest, you just violated my right, you piece of shit, cunt motherfucker.
We may have.
You have no qualified immunity.
What?
We may have the jury.
We have a question.
Oh.
Yeah, all right, here. They've turned the volume back on, so we'll put that back in here. But yeah, that lawyer was giving them giving them legal notice and stripping them of their qualified immunity is right.
Oh, neat.
And so yes, there will be a lawsuit. He'll be here to talk to us at 1 o'clock. And I'm hoping we don't have a verdict reading at that time. We think it's just a question. Yeah, we're not even done. The tape isn't even finished. It's hilarious. And he is filing a lawsuit, I think, on his behalf and his client's behalf. Yeah, that was definitely Fox v. Wauwatosa good. For sure. In the words of Law Talk with Mike, it got worse. He is awesome sauce. I love him. CJ Grisham. I think that's how I say it. Grisham. I'll have to ask him. It's spelled a little funny. All right, they turned the sound off again. Should we go back to CJ?
Yeah, I've got it up in the preview window there, so you can.
Oh, excellent! So I can see it. Okay. Well, wait, they're standing, so something's happening.
It is here.
Switch to your stream because mine is gonna buffer. I just know it.
Your Honor, calling people versus Jennifer Crumbley. Karen McDonald on behalf of the people.
Thank you, Mark. Keys on behalf of you.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
We got a question. You can be seated. We got a question from the jury that I thought was really easy to answer. I guess I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. It says a 16.10 and 16.13, two different ways that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.10. So I guess I would say the answer to the first question is yes.
It is, Judge, and I would just ask that the court reread 20.30A, which clearly articulates that. So I think that's why it wasn't just a yes or no response. I think this instruction 20.30A is right on point to the question.
Okay, so can I answer the first question, yes?
Yes, Judge.
And then say, please refer to 20.30A unanimity.
Yes, Judge.
Your Honor, I'm not sure. I'm trying to find 20.30A.
It's right.
God damn it, woman! I'm so tired of you not being able to find anything.
It's the one that talks about alternative theories.
She's wearing a peplum today. I haven't seen one of those since 1986.
It's a non-standard because it's a civil. It's adapted from a civil jury instruction.
Yeah, they're finding her guilty.
Mm-hmm.
Sounds like they are looking for a way to find her guilty of this.
I'm sorry,
20.30A, it's a non-standard jury instruction. Both sides agree to it. It's a unanimity instruction.
I may be wrong. I did see a peplum in the Johnny Depp trial, actually. Camille wore one. Her white suit had a peplum on the jacket, which is a little skirt thing that comes from the bottom of the jacket and flares out. It's a pretty look. It's a pretty suit. They're just not.
So you're wearing
all that
pants and
popular.
having a skirt cloth jutting out.
No, she's wearing a skirt with a little skirt on top, but the skirt is connected to the jacket. I don't know. I don't know how to explain it. It's a style of jacket.
I read the question is that the jury is confused, obviously, about there being two ways to prove the charge. When they ask about one instruction supporting another, I believe that they should reread 20.30A, and then the one theory of the prosecution is 16.13, which describes the legal duty. I believe the second theory by the prosecution is 16.10, which describes the theory. Okay, but I think what supports 16.10 is the definition in 16.18. So when this jury is asking for a question about support, I believe the confusion lies in the fact that,
They didn't ask me that.
well, when they say, I don't see how 20.3A clears up the question they're asking. I believe the jury needs to be instructed to
private
read
chat.
20.3A, and then they need to consider 16.13 or 16.10, and in doing 16.10, understand the definition of gross negligence.
Control F,
negligence is in
16.13.
That's what the defense believes.
They didn't ask that, Judge, and it's not up to us to guess what they're thinking or not. The answer to the question, the first question is clearly yes, and 20.30A is clearly on point, so.
Yeah, the answer is yes. And then I'm going to say, please refer to 20.30A. Unanimity. And I'm also going to say, please consider all instructions as a whole.
Thank you, Judge.
I think they're basically asking, do we have more than one way to find her guilty of this?
Which they do.
And they do.
Thank you, Judge.
All right.
Let's go back, Brad. Go back to the actual question. I want to hear the actual question again, because
The first question.
That's confusion lies in the fact.
Are they bringing the jury in to explain it to them, or are they just sending them?
I think they're just sending a response back.
Your Honor, calling people versus Jennifer Crumbley.
I thought was really easy to answer, I guess. I don't know if there's an agreement about that, but if you don't agree, then we're going to decide on the record how to answer it. The question is whether the standard jury instruction 16.10 and 16.13 are different. It says a 16.10 and 16.13, two different ways that we can conclude that involuntary manslaughter, or a 16.13 a support to 16.10. So I guess I would say the answer to the first question is yes.
It is, Judge, and I would just ask that the court reread.
All right, stop.
20.30A.
I've got 16.10 brought up here. So let's look at it. They want to know if 16.10 and 16.13 are different. And they're saying, no, they are not. Let me see, I'll make this a little bigger. Sorry, Archie. Cut your head off a little here. We'll go over here.
If you click the little bookmarky thing on the left side, you can move that over and get more screen real estate.
The bookmarky thing on the side. Oh,
where
this
the,
thing.
the index is.
Holy crap. Did that help?
That's not what I was doing, but or what I was suggesting.
There. How's that?
That works.
Okay. Involuntary manslaughter. The defendant is charged with the crime of whatever. You may also consider the lesser charge of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death and that person died as a result. And they're alleging gross negligence, so they have to use 3. In doing the act that caused the death, the defendant acted in a grossly negligent manner.
Yep.
Okay, so that was the first element. And then they're asking, is 16.10 and 16.13 the same? And they are not. You can find one not guilty and one guilty. So this is failure to perform legal duty. This was the one where I was like, well, I think they proved one of these, but not all of them. Defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that they had a legal duty, and the legal duty charged is whatever. And second, that the legal duty charged here is that they had a legal duty to keep their son. What are you laughing at? What's happening?
Archie was up
What's
at
he
the
doing?
camera.
Was he?
Yeah.
Oh no, and we missed his face because it was behind the paper, wasn't it?
Yeah.
Oops, sorry. Oh, he hears me talking. Archie Ruckus! Archie Ruckus! Hey! He's
Like,
looking for me.
what?
And he's like, come over here. There he is. What a good boy. What a good boy. What a good boy.
I love the head tilt.
What a good boy. Don't lick the camera. Did you eat all your treats? Are they all gone? Are they all gone? Did you get them all? Archie Ruckus. Oh, good boy.
Speaking of doggies, I gotta go check on mine.
Okay. Look at him. He's like, that's not her. She's not in the camera. All right. So anyway, so I don't think they proved these other things. So the other things that they did not prove were that the defendant knew of the facts that gave rise to that duty. Yeah, she might have known she had a duty to her son, but that she willfully neglected or refused to perform that duty and was grossly negligent to human life. Well, maybe they could prove that. I mean, maybe. And fourth, that the death of the victims was directly caused by defendant's failure to perform this duty. Yeah, I mean, I guess they could find this. Frank, maybe they could. Maybe they could.
I don't know.
Maybe they could find this. I mean, look, why do I feel like this was written differently than the one in the jury instructions, though? So so first, she had a legal duty to the victim or her. Yeah, the victim.
The victim.
See, that's the thing I don't think they can prove. I think she had a legal duty to her son, and that she failed in that legal duty. But I don't know. I don't know.
Going back to the car analogy, is you give your son a car, your car goes and kills someone. You're not negligent or grossly negligent by giving your son a car because he went and killed someone, because he's the one who ultimately did it. Now, it would be different if you left your car unlocked and the kid got the keys, went and drove your car elsewhere, and you didn't secure the keys or do something.
Okay, I never secure my keys. Jesus. Look at him. What is he doing? He's just showing off. He's so pretty. He's so pretty. He's going to give us his butt. Dog butt. Make sure you hit the like and subscribe. If you like doggy videos, don't you dare lick that computer. Don't you dare. Sit down. Good boy.
Oh
Good
my
boy.
God, he's so cute.
Isn't he cute? Doesn't he have amazing eyebrows?
Mhm.
He has eyebrows, this dog. Oh, if he starts
Something outside.
barking, you'll the thing is muted, but you'll still hear him because he's so loud. He must see somebody out there. Look at him. He's so cute. He's only 3 years old.
Oh my
Isn't
God.
isn't he adorable? Yeah, Teresa says, so now we have to lock our car keys up. We've lost our collective minds. Do we need to have safes for our car keys? Look at that pretty boy. Boy, is he giving good face to the camera today. You hear me? I know you do. I know you do. He's like, I can't see her, but I hear her. He likes to stand at that window. This is probably a better spot for the Ruckus cam because he spends more of his time over by the window
Looking
than
around and whatnot.
than anywhere else. So, oh yeah, the vacuuming is hell. There's so much dog hair all over the place, like it's gross. It's gross. All right, let's get back over to.
But yeah, it's going back to what we were talking about. It's hard to try and figure out because if you've done your due diligence in locking it up and making sure that the key isn't plainly accessible, then you would have met your burden for not being negligent.
Wait, say the first part again.
If you've locked the handgun up and
Right.
kept the key out of plain sight, you would have met your burden for not being negligent.
And they did.
Yes. So how is getting to this point, how? You can't be found grossly negligent because you did not willfully disregard.
So they can't find her guilty for the gun thing, but they can find her guilty for failure to perform a legal duty. And that's what they were trying to figure out just now.
But they can't. There is no
Yes,
legal
they
duty.
can. They can because the prosecutor told them they had a legal duty to other people's children, which I don't think they proved. But the jury, that's not going to matter to the jury who wants her to pay for this.
I think it'll be an appeal point, and hopefully she gets a different appeal attorney. But I don't think that's possible, because you cannot have a legal duty to the other kids.
Yeah, I don't know how you have another duty, a duty to someone else's children. She's not a mandated reporter, which wouldn't apply anyway. I think they screwed this up by, if they wanted to go after them criminally, they should have gone after them for child abuse and neglect. And I think they could have got that easily. But what they want to do here is send shockwaves of fear through parents to say that you are now responsible for any horrible thing that your kid might do. Even if we charge them as an adult, you still are responsible. Yeah, I don't know. I don't like this case at all.
Terrible. Did you see Joe posting last night?
No.
So Joe put the stupid immigration bill was posted yesterday, of how
the immigration bill.
Yeah, the $60 billion to Ukraine, $25 billion to Israel, and then $20 billion for local matters. And he posted the meme of the guy walking with his girlfriend, but then turning back and looking at the other girl. He's like, I want to do Crumbley analysis, but the immigration bill is right there.
Don't forget to play the live stream of the court so we don't miss something. I think you're on pause.
Oh, yeah.
And then I want to go. Oh, sorry. I said this was a Texas meeting. No, it's an Arkansas Pass City Council meeting in Arkansas. Arkansas, Texas. What's the difference? I'm sorry. I'm not as informed on this as I should be. I literally just saw this video and I was like, I need this guy to come on this stream because he's so freaking funny. So let's go and watch the rest of this. Oops, that's too big. Let's cut that down. There we go. All right, so they just hauled the attorney out for swearing.
I'm out of the meeting. I can stay right here.
I'm not. I have left the meeting. No, you're gone.
I have left the meeting. I'm not in the meeting anymore.
Please.
I'm not in the meeting anymore.
Goodbye. He's gone.
No, I'm going to stay here quietly.
For disrupting. He doesn't want to listen.
You guys might want to read this case law. You're one of you better read this case law. None of you have qualified immunity.
Sue already.
Okay, in that case, all right, here. Let me get everybody's badge numbers.
You can get it later. Right now, you're gone. Sir, I'm going to be quiet.
You're gone.
Goodbye.
My paper. What the fuck are you doing?
Goodbye. You've been asked to leave. Please leave. Stop
Under
making
what
things
authority?
difficult. The mayor kicked you out of the meeting.
He
Just right
unlawfully
now.
kicked me out of the meeting.
Yes, he unlawfully kicked him out of the meeting. For those of you who missed this, I should really replay his statements because it's hysterical. So his client gets kicked out of the meeting for swearing, and then his lawyer comes up and explains why what they just did is really wrong and illegal. And he does it in a colorful way.
Mr. Mayor, City Council, my name is CJ Grisham. I'm a civil rights attorney here in Texas, and what I just witnessed was a violation of Mr. Followell's.
So it is Texas? Oh, Aransas. I thought that said Arkansas. Aransas past city council. Never mind. It is Texas.
Rights. Let me read something to you. Arresting someone in retaliation for the exercise of free speech rights is sufficient to chill speech as an understatement. This is Beck v. City of Upland. Arguing, even if done loudly with a profane or offensive language will not, in and of itself, constitute disorderly conduct. That's Payne v. Pauley. Swear words do not provide probable cause for an arrest for disorderly conduct because the words, as a matter of law, are not fighting words. Johnson v. Campbell. I could go on, Mr. Mayor. Your rules of decorum are unconstitutional, and they're setting the city up, you individually, for liability. Now, you will be seeing a letter from me, a demand letter for violating my client's rights just now, because he has the right to say fuck, shit, damn, bitch, cunt, whatever. He has the right to say all of those words because it is a First Amendment right. You can't.
Why does this keep doing this to me today? I thought I had it.
Do anything about it. Let me tell you something. The law has long established that arresting an individual for publicly displaying vulgarities violates the First Amendment. That's the Cohen case, 1969. Indeed, the Supreme Court recently held that a public school violated the free speech rights of a cheerleader by suspending.
Who's got the bingo card? Who's got the bingo card? We need to fill in a space. Megan has tech problems.
Instead of 480, go down to like 360 or 144.
All right.
Defending her when she said things like fuck school, fuck softball, fuck cheer, fuck everything. Then there was another, that's Mahoney Area School District VBL. There's also Eachus v. Steelman saying that a police officer was not entitled to qualified immunity for arresting a plaintiff who said fuck you. No qualified immunity. So
Did you hear that?
My entire 3 minutes, I can say fuck again, and I can say fuck again, and there's nothing you can do about it because it's called expressive speech. We are allowed to express ourselves. We are allowed to fucking talk about what we think about you. If I think you, Mr. Mayor, are a tyrant, I can say that. If I think the city manager is a piece of shit, I can say that. It's protected. This is the case law. I don't give a shit what you think. The law is right. You escort me out, I'll sue you as well, Mr. Mayor. This is the law right here. And if these chiefs come out here and pull me out of this meeting, you had better read this, chief, because he's telling you to break the law.
You better read it.
Yeah. Now, where did that coward Kerry Scruggs go? Where did the coward Kerry Scruggs go? Is my 3 minutes up?
You're gone.
What am I gone for? What am I gone for?
Violating the rules of the decorum.
No. His rules of decorum violate the law.
Goodbye. You're going to go to jail for
Oh, you're going to arrest me? Oh, you're going to arrest me? Okay, so under the threat of arrest, you just violated my right, you piece of shit, cunt motherfucker. Read these because you have no qualified immunity. Oh, go file. I'm out of the meeting. I can stay right here. I'm not. I have left the meeting.
No, you're gone.
I have left. I'm not in the meeting anymore. I'm not in the meeting anymore.
Goodbye. He's gone.
No, I'm going to stay here quietly.
For disrupting.
He doesn't want to listen.
You guys might want to read this case law. You're.
God, I love this so much. And he should be with us here in 5 minutes. I hope he got my my message.
One of you better read this case law. None of you have qualified immunity.
Sue already.
Okay, in that case, all right, here. Let me get everybody's badge numbers.
Right now, you're gone. Sir, I'm going to be quiet. You're gone.
Goodbye, my paper. What the fuck are you doing?
Goodbye. You've been asked to leave. Please leave. Stop
Under
making
what
things
authority?
difficult. The mayor kicked you out of the meeting.
You know, YouTube is just being really awful.
Really kicked me out of the meeting.
Then
Then close the fucking door, Big.
Can you pause that?
Close the
Or...
door.
Yeah, close the door, Big.
It's not a
Can I
public
pause
meeting.
it? Yeah. What?
Oh, that was me. Good Lord.
What?
I had some music coming through my headset and I didn't know what the heck it was coming from.
It's coming from one of your windows that were open.
Yeah.
Yeah. So yeah, it's funny. When you alert an officer of the law that like, hey, you're breaking the law, and here's the law, I'm holding it in my hand, and you need to read it before you let some podunk mayor tell you to arrest me and break the law, you're stripping them of their immunity if they go ahead and do it. That's why he did that. That's why he said, you better read this. You better read this before you do this. Oh, look, I just got... Okay. Breaking news. I just got a response from the Broward County Sheriff's Office for my second FOIA in the Tonsil Twins case, where I asked for any phone recordings of Laura Owens that she made to Lieutenant Lacey Crew. And they are saying they have no responsive records. Based upon the information you've provided, the Broward Sheriff's Office Public Information Unit has been unable to identify any records responsive to your request. In order to more thoroughly conduct a search of the regional communication system, the phone number from which a call was made is needed. Ooh, I have that. I have that. I can give that to them because Laura Owens publishes her phone number online on her website.
Whoops.
So I'll try that.
Excuse me, don't touch me. Don't touch me. You are assaulting me right now.
Please walk.
Don't touch me.
Please walk. You're not following commands. Thank you.
Well, I'm not following unlawful commands, motherfucker.
Okay.
All right, so we got Persian. Persian, what's your badge number?
412, sir.
412. Next. Salazar. 430.
I just heard from CJ. He's running a little bit late. He was just, oh, here he is. He's here. He's here.
Next.
This is so good. CJ. CJ, can you hear me? CJ, can you hear me okay? Can you hear me? No, he might not be able to hear me. Let me email him. All right. I'm going to tell him, I see you.
I can hear you now. Can you hear me?
Oh, yep. Awesome. Yes, we can hear you. How are you? Welcome to the program.
Hi, thank you. And I'm so sorry for the quality. This, if you're able to wait 15 minutes, I'll be at an actual computer.
Oh, yeah. If you want us to, sure. We've got 15 minutes. We're just sitting here on Verdict Watch, and we've been watching your video. And, man, it is hilarious. The chat loves you. They think you're a national treasure. Can you please make a tour around all of the public boards and just repeat this process everywhere? Because that would be hysterical.
You know, it's amazing how widespread this problem is. And I can't help but wonder at this point, because ever since the video went viral, I feel like I've gotten emails from all around the country and around the state that it's just not possible that it's accidental that these city councils all around the country are creating identical rules that violate people's First Amendment rights unless there's a push for that. There has to be somebody pulling the strings and forcing this issue. And that's kind of my next goal, is to figure out where's all this coming from, because I don't want to spend the rest of my life suing city councils and boards for violating people's rights. I just want them to stop violating people's rights.
I'd be happy doing that for the rest of my life, to tell you the truth. The chat wanted me to ask you, how the fuck are you? Anyway.
I'm fucking great.
This case is really fucking insane. I gotta tell you.
You know, it's funny, and I don't normally talk like that when I go to a city council meeting, but I felt like it was necessary to get the point across with that particular city council, because you know, if they think here's where the problem is. The problem is, you end up with people like me coming in and saying fuck a million times at a city council meeting, because instead of doing the right thing, you've decided that you're going to try and make it worse. And really, if you had just ignored these people when they're criticizing you, they won't criticize you more forcefully. They won't resort to calling you a piece of shit, because they feel like you're at least listening to them, you know, and so they do nothing. They make the problem worse. And you end up with a guy like me showing up and really making the point.
So one
Yeah.
thing that I would put forward is that because it's lawyers for the city councils that are drafting these rules for how these city meetings are supposed to be done, and they say, well, these city managers are functioning like a judge. Lawyers are not allowed to say "fuck you, judge" or anything like that. So by using the language that are used in standard court, then they believe that this will happen. But when you talk about the layman's persons coming to these city council meetings, they're not lawyers. They're not bound to professional ethics and things like that. So they're
Right.
running up against this problem of free speech in the public sphere.
Well, and you know, I'll also say if I'm in a case, for example, when this case goes to court, if it goes to court, you better believe I'm going to be saying "fuck" in court, because I'm going to be quoting what was said on the stand or at the city council. So
it has to be
what-
all through your complaint. It'll be this is comes now this fucking guy.
I don't know that I'm going to go that far, but yeah, you know, I think it's a very dangerous prospect for city councils to start thinking that, for example, in Killeen, I've got a similar problem in Killeen, where their rules of decorum talk about how the city council should be, you should treat it like you're at church or court. I'm like, whoa, stop. Those are three different things. City council is not a church is not a court, and a court is not a city council. And so this idea that these elected politicians whose entire purpose of existence is to steal your money and to steal your liberty, if they think that they're equivalent to a church, or which a church is dedicated to your divine existence and to making sure that you live a good life, that's not the point of government. A court is to ensure that there's justice and that your rights are protected. That's supposed to be what a city council does, but that's not the point of their existence. A city council is a purely and totally political entity. And for them or anybody to think that they can, that they should be treated as if they're some holy entity or some judicial entity, first of all, that violates the separation of powers, because now you've got an executive branch of government, a city council or a county board or whatever, pretending to be a judiciary. And that destroys our Constitution. So I don't buy into this idea that you have to treat them differently. You know, these are the people that come knocking on your door begging for your votes.
They sure do. They sure do. I've got a question for you about one of the things that you did and said when you were at you turned around and looked at the police and you said, you better read this law, because they're telling you to break it. And what happens if a police officer is notified that they're breaking a law and they break it anyway?
So I am very good or intentional anyway. I'm very intentional about making that point, because once you notify, they're supposed to know anyway. If there's case law on the issue, then a police officer already doesn't have qualified immunity. But let's face it, how many police officers sit down and read case law? You know, they know stuff like Terry v. Ohio. You know, they might know the Miranda case, Miranda v. Arizona, where they got to read you your rights and stuff like that. But when it comes down to what is the case law on any particular issue, even if they've been put on notice about that, they probably never read that stuff. And I'll tell you, most police officers don't even know what Terry v. Ohio is, the way that they go around doing quote unquote Terry searches. And so
I also
by
noticed
doing that,
we didn't get to this part in the tape, but there's a part where you tell them it's Cohen v. California, and they go, well, that's just what you're saying. And you're like, no, it's right here. It's a Supreme Court ruling. And
anybody
you can Google it on your phone, man. Like, you can't, It's not just my opinion, man. This is a ruling.
Well, and that's this idea of, and look, I understand that in any particular case, no matter if it's civil or criminal, you've always got two attorneys arguing different things about the same law. But when the law says, just as it did this was very on point, where the police officer had no qualified immunity because someone told him, fuck you. And that's why I turned around and I directed it straight at the police chief, because I know he's the one that's arresting these people. And I said it to his face. He's the one that got up, and as soon as I started talking, he got up and went behind me. And I thought that was pretty cagey and cowardly to begin with. You know, face me like a man. Don't sneak up behind me when you're going to go to arrest me. You know, because without that badge and that gun, you're nothing but a giant beefcake coward. And so
they did not arrest you, though. They threatened you with arrest and made you leave a meeting under threat of arrest, which is still breaking the law, right?
Yeah, legally, if you surrender your rights out of what's called duress or because you're threatened.
Right.
So in this case, I stopped speaking because I was threatened with arrest, and I would not have stopped speaking had I not been threatened. So that's what's called a constructive arrest. So essentially, he did arrest me. He did violate my rights. He did prevent me from speaking, but I didn't voluntarily stop speaking. And that's what I wanted to make clear when I heard him say, "Oh, you're going to arrest me." Okay, then for that reason, I will leave, only because I have to. It's under duress. Right. And then when I went outside, I showed the, there were like 6 officers out there. You know, it's kind of interesting how many police officers it takes to shut someone up. But I showed the police officers all the case law. And then I said, all right, so now that I've read this to you, now that you all know that none of you have qualified immunity, regardless of what you're told to do, how many of you are going to arrest me if I go back into that meeting? Just raise your hand. If you're going to arrest me if I go back to the meeting, just raise your hand if you're going to do that. Not a single one of them raised their hands. That's why me and Mr. Followell went back in and sat down. And the city manager and the mayor, the city manager and the mayor were like looking at each other, and you could tell they were incredibly confused. Like, wait a minute, I thought we kicked this guy out. What's he doing back in here? And
we didn't get to that part yet. We were right here. I'm going to play it so that they can see this, because this is actually great. This is right where we left off when you joined. Okay. I'll let you concentrate in your driving for a minute, so
I'm almost at my office. I'm sorry. My meeting with the judge lasted longer than I thought.
All right, we'll watch the end of this.
How do you spell that?
Huh?
How do you spell that?
S-T-R-E-I-C-H.
S-T-R-E-I-C-H.
Oh, my stupid YouTube.
442. Next. Baker. A. Baker. 432. Next. W.
H-I-P-K-E-Y. 437.
H-I.
Getting all those badge numbers.
437.
Next. H. Thomas.
CJ, I love you.
435. Next.
You're such
Is
a
that
boss.
And Blanchard.
401. I understand you're not there. I understand.
Guys, I want you to know something.
Yes, sir.
I literally quoted them
Yes, sir.
the case. Oops, there it is. Sorry. I literally quoted them the case law.
I think I forgot my camera was still on.
What you just did is unlawful. I also quoted the quick case law that you lose qualified immunity by arresting me for what you just did. Okay, I literally but you would have arrested me. You threatened to arrest me.
I didn't threaten to arrest.
Your chief threatened to arrest me, and he told
Yes,
you
he
to
did. We
arrest
heard
me
it on
if I
camera.
didn't leave.
Which is under duress.
Which is under duress. That is essentially an arrest. Okay. So
YouTube
none
has
of
a
you have
spinning
qualified
issue.
immunity. If I walk through the store, who's going to arrest me?
If
I need to know.
The official proceedings, sir, you
Yes.
can be in there.
Who will not arrest me if I go through this door?
I want you to go in there and speak, but I want you to speak in a calm.
No, I'm done speaking.
You don't
That's
get
all
to
been
tell
done.
me
What
how
I
to
want to know
speak.
is if I go back in this door,
I hate that he was like, you can go back in there and speak. You just have to do it in a calm way. Says who, motherfucker? Who says I have to talk in a calm way? What do you mean, you absolute asshole? This guy is less than medium smart. You don't have to speak in a calm way at a town hall meeting. Who the hell wrote it into the First Amendment that free speech is only free if you speak calmly, CJ?
And that's exactly why. So I intentionally went and found every case of a protected profanity that I could find, because if you go back, and I don't know if you guys covered this when you were listening, because I didn't hear it live. I only heard it when I went back and listened to their version of the video, the actual live feed. And so when I started going through my profanity lace, shit, bitch, fuck, and then I said cunt, and the lady on the city council, you could hear her go, oh my Lord, have mercy. And I was like, and that's why she left. I had no idea that she had left right after that. But just hearing her kind of gasp and say, "Oh Lord, have mercy,"
She got the vapors, literally clutching her pearls.
I'm like, why are you on the city council if literally the words from a court of record are using this language and saying it's protected, but you're still finding it offensive? We have a problem here. And anyway,
you can be offended. I mean, be offended all you want, but you don't have a right to not be offended in a public meeting, at a public hearing, when free speech is on the menu. You just don't. I actually got thrown out of a meeting and I never used one swear word. CJ, do you know about my case in Wauwatosa? Well, I sued them and I won. Robert Barnes was my attorney. We ended up suing them because they cut me off. My 3 minutes were violated, and my free speech rights were violated because I said their names. These people, they had the same kind of rules that this one does. This is the Wauwatosa School Board. What they said was that I wasn't allowed personal attacks or to address anyone by their names. And so I made sure to call them all by their names because I knew it would trigger them. And I want to play for you how this went because I think you'll get a kick out of it.
Yeah.
Let's see. Let's go Wauwatosa.
While she's pulling that up, you're talking about pulling up case law regarding profanity in the city manager meetings. I would go one step further and bring up Brandenburg via Ohio. I don't know what Ohio's problem is, but they get all the really good case law on free speech.
Actually, I think Brandenburg is one of the ones that I quoted.
Yeah.
Or at least it was on my sheet. I might not have quoted it, but it was on my sheet.
All right, here's what happened to me at the Wauwatosa School Board. These people have a real ego problem. Hello, my name is Megan Fox, and I'll tell you why I'm not going to give you my address. For one, I just read your Wisconsin Rules of Open Meetings Act. It's a law, and the law in Wisconsin is that the public has a right to participate in your meetings, and nowhere in it does it say that anyone has to dox themselves online in order to participate in a public meeting. I want you to know that school boards like yourselves have been sued successfully before in the past for doing this. It's considered an intimidation technique. Now, you can sigh and put your face in your hands, but you need to listen to me when I tell you that you can be sued for what you're doing. You are violating people's rights. And what you did today by cutting off public comment in the beginning of the meeting when you had a full house of people who wanted to speak to you, and you made them wait 2 hours, and most of them had to go home because they had to work jobs tomorrow, or because they had to get kids somewhere, or because they had to go home and get dinner. What you did is violating the public's First Amendment rights to address their public bodies for grievances. It is a violation of the Constitution, and you should each be ashamed. Sharon, you should be ashamed of yourself. Leanne, you should be ashamed of yourself. Michael, you should be ashamed of yourself. And you too, Jenny, and you too, Jessica. And let me tell you something else. When people use names in front of your school board and they come in and they say, I want to talk to you about a specific person on the board, you are not allowed to tell them that their First Amendment right to speak is curtailed in some way because they want to use a name. That is illegal. What you are doing is against the Wisconsin Open Meetings Act. Now, listen, I have 3 minutes, and I know that my time is not up. You are not to interrupt me while I am speaking. This is public comment time, and I'm a member of the public. You can sit there and be as uncomfortable as you want, but I have this 3 minutes. So listen to me, Michael. When you are talking to people, when they come here to see you, you are put into this position, by the way, by the people of this town. They are your first priority.
Surprise. Where are you?
They are your first priority.
Not one fuck word.
They are the
Just
people
continue.
you're responsible
Do you need me to mute this?
Yes.
Why
Thank
would
you.
you why would you mute me?
Okay. Sorry,
my
I couldn't
3
hear
minutes
you,
are not
but,
up. My
Okay.
3
No,
minutes are not up.
At the point where we start
Wow.
respecting individual board members, we devolved.
Well, they're wrong.
If you've already spoken, your time is up on that topic. Anyone?
My time was not up, by the way. They're full
well,
of crap.
Two
Look at them.
things.
They're
First,
so
the
uncomfortable.
chair has the right to cut off comment if the comment is not
What?
aligned with the dignity of the body.
Oh, no, you don't.
So,
oh, no, you.
just to put that out there.
That
So
is not what the First Amendment
if there's
says.
something inappropriate being said,
What was inappropriate?
What was
now that's a
inappropriate?
judgment call. That's true.
What?
But the chair does have authority to do that.
Bullshit.
The chair does not have authority under our rules to cut off a board member. We have no time limits. So I can just keep talking here once you recognize me. But to
Look at how
say
uncomfortable they are.
whether you support me or not in the community, we have an orderly process.
What was unorderly about that? I had
And
3 minutes.
The chair is running the meetings and the chair has certain discretions and
I
that's
could sue him
okay.
for this.
That's probably a good idea.
You should.
I should.
Secondly, about
And I did. And they settled for 10 grand. And they cut me a nice check too. They had to pay my attorney's fees and they settled. And I didn't use one swear word. Not
Are
one.
you able to hear me now?
Yes.
yes.
Oh, there's
Okay.
an echo. There's an echo, unfortunately.
Hang on.
Something just changed. And
How's that?
Much better. There we go.
Okay. Sorry about
Perfect.
that. Yeah. So, I like what you said in there about, because I do this too. I don't give my address when I go to these. And there's actually a case law. It's called the right to anonymity.
Yep.
And I have made that case because I went up north for a client, I guess about a year ago, and they were refusing to let her speak because she would not put her address down. And so I had to go up there and explain to them that, look, that's illegal. You can't do that. This is called citizens' comments, and you can't discriminate against someone based on geography just because they don't live within your predefined area. A citizen is a citizen, and they don't have to put. There's no law that requires you to put that. And I talked exactly about this doxing issue, where if you say something that someone doesn't agree with or they don't like, all they've got to do is listen to your video, and you're giving your address to people.
Mm-hmm.
So, but there's all kinds of case law about the right to anonymity, and I bring that up as well when I'm arguing with these people, because Colleen, one of the things that Colleen tried to do was say that if you weren't a citizen of Colleen, then you can't speak. So what I would do is I would go in there and I started.
They tried that there too. They can't do it anymore.
Well, what I did was I put my name down, and then it said, "Are you a citizen of whatever, Colleen?" I said yes, and then when it said your address, I put homeless.
There you go.
I mean, who knows? Maybe I do live there. I just don't have a house. Maybe, and how what makes me a resident? How long do I have to live here? And where do I have to live? Do I have to live inside? Does a bridge count?
They don't have any right to that information. None, zero. Plus, it's in public and it's probably being streamed somewhere. And if you're someone like me who has a lot of enemies out there, or like Gays Against Groomers, Jamie Michelle, who was also speaking at the same meeting, and they were badgering her to give her address. She's somebody who Antifa is after. She's not giving her address in a public meeting. That's absurd. The public has no obligation to dox themselves because some government board told you to. I always tell people, if they ask you for your address, tell them to fuck right off with that. No, off you fuck. You're not getting my address. There's no requirement for that. We made them change their rules in Wauwatosa so that they couldn't put personal attacks in their rules anymore. You can't. The only thing they can say is you must abide by the laws of disorderly conduct. So if you are breaking the actual disorderly conduct laws of the state, then you may be removed and arrested. Because if it's actual disorderly conduct, but it would have to rise to that level.
And I like to play games, especially when you've got a really left-wing board or a really left-wing city council. And they're like, well, you have to be a resident. Okay, well, I identify as a resident. Now what?
Now what?
Now what? Are you going to deny my identity, you bigot?
That's my identity.
So,
oh my God. All right. So we were right here where you were about to tell them you're going back in. Let's watch the rest of this because it's really good.
Who is going to not arrest me?
Are you going to disrupt the proceeding?
I didn't disrupt the proceeding last time.
If
sounded like you were loud in the hallway, and then we had.
No, I was on the hallway because you were illegally pushing me out of a meeting.
Yeah.
The mayor kicked me out.
Okay. I wasn't there for that. I was there for you getting out of the building.
So you don't know what happened in there. So why are
That's convenient. Well, I wasn't there for that. Well, that's not an
Exactly.
excuse, Lurch. That's not
I
an
wasn't there, but
excuse.
I'm going to take the tyrant side over the citizen side. I wasn't there. I have no idea, but because I'm a tyrant enforcer, I'm going to enforce the tyranny instead of listen to you, the citizen. So it's important that we make sure they understand we are the power.
I think that the jury has another question. Do you know about this case that we're doing verdict watch on, CJ?
I
Do you
don't.
know? It's the Jennifer Crumbley case. She's the mother of the Oxford high school shooter, Ethan Crumbley. And the state has gone after her for unintentional
Involuntary.
manslaughter for the deaths of the 4 students because they claim she didn't secure the gun, but there were no secure gun laws in Michigan at the time. And it turns out they did secure it, and they hid the key. The kid found the key, unlocked the gun safe, took the gun to school, and killed a bunch of kids. The state's going after the parents, and this is the first trial of the 2. This is Jennifer's trial, the mom's trial, and we're in the middle of waiting for the verdict, and it looks like the jury has a second question. So when the judge starts talking, we'll interrupt what we're doing here, and we will listen to what she has to say. But Brad, you can mute this while we're talking.
Mm-hmm. And I do First and Second Amendment. Those are my 2 focuses for what I do for law. And this is a big issue with me. Are these sort of guilt by association type crimes? My kids have had access to firearms since they were 8 years old. They've known how to shoot guns since they were about 6 years old. And the reason for that is I trained them on how to shoot, when to touch a gun, when to not touch a gun. And I could literally, if I wanted to, I didn't do this, but if I wanted to, I could have just left it on my coffee table 24 hours a day. And my kids knew not to touch it unless somebody was breaking in the house. Now, my kids were trained, if somebody's coming in the house and they're trying to hurt you, or they're trying to hurt mommy or daddy or your brother or your sister, you pick up this gun, because obviously I don't want them picking up a 45 or they're going to hurt themselves. But I had a 22 pistol that was specifically for them in an emergency, that if they needed to get it, they were able to access it to protect themselves or their family members. That doesn't mean that I think what they're going to have to prove in negligence is that, because having access to a gun is not a crime. There aren't, at least
what they're, and at the time it wasn't a crime to even have it laying out on the coffee table. They literally could have. It wasn't, though. It was in a case, it was locked, and the key was hidden. Their son found the key, unlocked the case, got the gun, took it to school. There's other issues in this case that are egregious. For instance, the day of the shooting, the school found a drawing he did that was very disturbing, with a gun and blood and a message that said, "Help me, the thoughts won't stop." And they called his parents. The parents came to the school. They did not search his bag, and they would have found the gun. They did not make the parents take him home that day. They said they needed to get him therapy within 48 hours. And they allowed the parents to choose whether they were going to take him home that day or leave him at school. And they decided to let him stay at school because the school counselor said that he didn't think he was a danger to anyone else but himself. And the kid walked out of that meeting and started shooting like an hour later. That was,
and
it
under
happened
that
that day.
standard, I would argue that the school is just as complicit or just as non-complicit as the parent under that standard, because they were just as wrong in not taking that seriously and making sure that he wasn't a threat to himself or others.
Right. It's really bizarre how this even occurred. Now, one thing that's probably a lot different between you and your children and the Crumbleys and their child was that they did not seem to be very involved in his life at all. And that's what's making this very difficult for the jury, because they were shitty parents. They were shitty parents. They were neglectful. You could even say they were abusive. Lots of fighting in front of them, having affairs on each other, swinging, all kinds of garbage that parents shouldn't be doing. Not having enough food in the house, leaving him alone, lots of it to the point where one of the experts testified he was like a feral kid. And they had no knowledge of what he was doing, and he had planned this entire thing in his diary. He had a terrible internet history of watching violent gore, and he was texting friends that he was going to shoot up the school, and nobody said anything. Nobody told his parents. Nobody. But the problem is, his parents were so absent that they had no knowledge of anything he was doing, and yet they want to find them negligent for. They're trying to say they had a duty to these other children at the school, and they failed in their duty to protect those children. I think the school had the duty to the children. And they had a duty to their own child. And I think the state could have gone after him for child abuse and neglect, but they didn't.
I was going to say, if there's anything that they're going to be, that they could possibly, I would say, be guilty of, is that neglect as a parent. Your duty to others does not exist outside of your own property. You have a duty to others on your property. So if those kids are obviously visiting the house, they have a duty to protect those kids. But it's interesting how the school system and the powers that be, they want it both ways, right? They want the parents to be responsible for the safety of other kids in a situation like this, but they don't want parents involved in any other aspect of their education. And they don't want the parents to tell them, no, I don't want pornography in my libraries. No, I don't want communist philosophy against republicanism in our, I don't want civics and all that, so they need to shut up and let the teachers decide that. But by golly, when it comes to the safety of the kids, and I would even argue that the school probably sings a different tune when it comes to a parent visiting the school that has to provide ID, get a badge, sign in, go through metal detector, whatever it is, in order to visit the school. Suddenly it's the school's responsibility to protect the kids. But, when it comes to guns, we're going to shift that standard, and we're now going to broaden what the culpability and responsibility of those parents are. If it's as you say, there's plenty to charge them with child abandonment, neglect.
Right.
I mean, all kinds of.
They should have gone after. That would have been so much easier to find. Although it seems like the jury is going to find her guilty, because they came back earlier with a question, and it was, is this rule 10? What was it, Brad? 16.10 the same as 16.13, or is it two different ways to find negligence? And the answer was, it's two different ways to find negligence. So they're searching for a way to find her negligent. I think what they're going to do is they're going to say not guilty on the gun thing, but guilty on failing her duty to the victims.
Which, if they do, I think the appeal is going to win, because the appeal is going to go through, and they're going to say no,
they
it's
didn't
the
prove
school.
all those elements.
But the other funny thing is, the victims' families are trying to breach the qualified immunity for the school, because the school is operating as a government entity and they get immunity there. So they're trying to breach that to be able to go after the school.
Yeah, the school got immunity. Can you believe? Of course they did. Of course they did. So the parents are trying to find a way to get around the immunity that the school has to sue the school. And really, the school is far more liable for this than those parents, even though they're shitty parents. They're shitty ass parents.
Well, if the parents had said, hey, look, Johnny, here's a gun, but don't go shooting anybody with it, okay? You can take it to school, and, I can see the negligence there. But when you've got a child or anybody that just takes it because the gun is either unsecured or secured in a fashion that someone was able to find a way to get access to it, that doesn't create a third party duty to protect. I don't know of any case law or any standard in American jurisprudence, at least, and even our British common law, that says that we have a duty to third persons outside of our own property.
Right. And here's the other thing, CJ, you'll like this. This is an interesting case. The state charged Ethan Crumbley at the age of 15 as an adult. At the same time, they want to have their cake and eat it too. He's an adult and fully responsible for his crimes, but then they're going to go prosecute his parents because they were responsible for his crimes too.
Right.
That's an interesting
and it's
problem.
unfortunate that the way our justice system works right now is it's most likely going to have to be litigated through the appellate process because when I was coming up through the law, and even before I was a lawyer, I remember one of my lawyers telling me, CJ, the law is whatever a judge says the law is. And therefore, the jury only hears what's in that charge form and what's presented to them. I remember in my case back in 2013, this was just an interference case, but they asked the judge some questions about what certain words mean. That was very important. And the judge was like, well, you figure it out. And when a jury either has no instruction or they have so much instruction that they have no, like in my case, they have no option but to find guilt. So, and I'll boil this down. I don't mean to make this about me. I'm just telling you about how the process is kind of jacked up. I don't want to talk about it.
We want to learn about you. We like hearing about you.
Yeah. So in 2013, I was arrested for carrying a firearm, a rifle, while I was hiking with my son out in the country. This also made national news back in 2013. And what happened was the police officer stopped me. I'm out helping my son get his hiking merit badge, and a police officer shows up, walks up to me, and he says, "What are you doing?" I said, "We're hiking." And then he grabs my rifle and he says, "Is there some reason why you've got this?" I said, "Because I can." And he did not like that answer. And so he tried to disarm me, and I put my hand on naturally. I was a master sergeant in the United States Army at the time, and I just gotten back from Afghanistan a few months prior to that. Oh, there's somebody coming in.
This is the Mrs. Crumbley.
Oh, okay.
They have her in shackles too. They've
oh my
shackled
gosh,
her.
really?
Yes.
This is the worst part of it.
They've been in jail. Her and her husband have been in jail for almost 3 years.
They're not keeping the shackles on in front of the jury, are they? Okay, they're taking them off. Okay.
They take them off, but I mean, this is part of the public humiliation process.
Yes. So anyway, long story short, since it looks like they're getting ready to come in there, what the judge told the jury, because there was a brief moment, it was purely reactionary to me. When the officer tried to take my gun, I instantly put my hand on the barrel and the buttstock. And I said, whoa, what do you think you're doing? And then I immediately took my hands off. Like maybe a second at most was my hand on that gun, because I realized, oh, that's just a common reaction for me, And in basic training, the drill sergeant, when you were getting inspected, the drill sergeants would grab your gun, and if you didn't hold on to that thing, you were doing push-ups.
Yeah.
And you're taught to retain possession of your firearm. So that was just a reaction. And what the judge said to the jury was, not did I interfere with anything, because no reasonable person can say that I interfered with anything through a 1 second touching of my firearm and then putting my hands up immediately.
Right.
But the judge said, if you find that at any time Mr. Grisham touched the gun, you must find him guilty.
Wow.
Oh.
So when you're given those kinds of instructions to a jury, that's why there are so many appeals, because the jury knew that what I did was wrong. They could have sentenced me for up to 6 months, but they only gave me a fine, because they're like, okay, well, he's guilty, but he doesn't deserve to go to jail for it.
Wow.
And so, and then we've also got to start educating
Those are
people
some
on jury
terrible
notification.
jury instructions. My God.
Oh, it's terrible.
All right.
I'm actually
here comes
interested
the
in this. I might
judge.
watch this with you guys.
You should hang out. We're not done talking to you anyway. This shouldn't be long. I think this is just another jury question.
God, you can't hear this judge for nothing.
I know. She whispers.
The question is, can you infer anything from evidence or witnesses that the prosecution did not bring?
No.
Specifically,
nope.
Not bring any shooter or other people who could answer how specifically.
Why would you bring in the shooter?
Why would you? What? Oh, he was supposed to testify.
Do I need to refer them to? Do I need to send them 2.9 or 3.5?
I believe you need to send in 3.2, Your Honor, because a reasonable doubt is defined as a fair, honest doubt growing out of the evidence or lack of evidence, and it appears they're asking about lack of evidence.
You can make inferences from the evidence. You can't make inferences from the lack of evidence, except in certain instances. For example, if a police officer turns off his camera, you can infer that the evidence that would have been on that camera would have helped the
They're
defendant.
asking essentially why the shooter didn't testify or other witnesses, and the defense doesn't have a burden to put any on. So we believe it's important to remind the jury that the burden is on the people and that a reasonable doubt can come from lack of evidence.
Which again, we can't guess what they're thinking, we just answer the questions. I'm sorry, which instructions did you?
I was thinking, well, these are the preliminary instructions 2.9 and or 3.5, is it?
Oh, 2.9 I think would be appropriate here.
I'm sorry, 2.9, what was the other?
3.5, maybe. I don't think it says.
I've got it pulled up. You can look at it when they're done.
Okay. What did she say? 3.2?
That's whatever that means. I'm not familiar with Wisconsin law.
We've got it.
This is Michigan,
It's Michigan,
common
yeah.
jury instructions.
Gotcha.
It seems on point, Judge.
I have no objection to 2.9. I am just making a record that I'm also requesting 3.2.
Do you want 2.9 or 3.5, either of those? I'm trying to keep myself to answering the question that they asked. They have an instruction to get them about this without.
She's not going to give him 3.2. She's not going to point it out.
2.9, although we do have 3.5, so.
Judge, the answer to the question is no, and I think reading 2.9 again and 3.5 are probably appropriate given the question.
That's what I'm gonna do.
Thank you.
Okay, so he agrees.
I'm gonna bring them in, okay?
Thank you, Judge.
I'm sorry.
I'm gonna bring them in.
Oh, she's bringing the jury in. She didn't do that last time. Last time she just sent them back instructions.
So 2.9.
All right, yeah, 2.9 and 3.2.
Let me mute them real quick while they bring them in.
Okay.
So 2.9, considering only evidence and what is evidence. When it is time for you to decide this case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only sworn testimony of witnesses, exhibits admitted into evidence, and anything else I tell you to consider as evidence.
They wanted to know if they could infer anything from witnesses that were supposed to come, but then they ended up not calling. Ethan, the shooter was one of them. And so they wanted to know if they should infer or could infer anything from witnesses who were supposed to be there, but then for whatever reason weren't. And it is weird that the defense only called the defendant to the stand. That was their only witness. And then nobody else. Then she rested her case.
It was pretty awful. She only went over matters of personal life. She didn't do any kind of attack on the legal merits of the case, talking about gross negligence and the legal standards on it.
Explain
It was
any of it.
terrible.
It wasn't good. Okay. God, I wish she would speak into the microphone.
So, you asked, can we infer anything from evidence of witnesses that the prosecution did not bring? The answer is no. And you say specifically not bring in the shooter or other people who can answer how he specifically got the gun. So I'm going to take you back to our first day of trial and read you this instruction that I read you on the first day. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. You also have a copy of 3.5, which I'm going to read to you. You don't have a copy of 2.9. That was read in the beginning of the trial. 3.5 says, when you discuss the case and decide on the verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence, provided
This is
with
3.5.
common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. So I'm hoping that I helped you. All right. So I'll have you return to the jury room. All rise for the jury.
Okay, Brad, you've got 3.5 in front of you because we missed some of it. She's too quiet.
Yeah.
But I mean, the short answer is no.
Yeah.
The short answer is no. You can't infer anything from either witnesses that are not here. And it was interesting. The one thing I didn't catch the last time was, they said, can we infer because the prosecution didn't bring certain witnesses. They actually weren't talking about the defense. And for a minute, I thought they were. I guess the prosecution was going to call Ethan. Oh, hang on a second. I'll be right back, Brad. Take over. Yep.
Yeah, so the biggest thing about this case was the prosecutor decided to try on the criminal negligence standard, which is a higher burden of proof that's needed than the civil one. And so the defense should have been jumping in for joy at them having to make an even larger burden of proof, but they didn't attack much of anything when they were doing it. The defense only called the defendant and had to go through all of the waivers of everything to be able to allow them to speak, and then they decided that they weren't going to bring anyone else, and that was it.
You know, one of the biggest pitfalls that I've noticed with defense attorneys is too often there are two big mistakes that we make. The first one is too often we do not put the defendant on the stand. Mm-hmm. I understand the reasoning behind that, but I've also learned that a jury really wants to hear from their mouths. And the reason they don't do that is reason number two, the mistake number two that a lot of defense attorneys make. And that is that we all too often think, you know what, this is a slam dunk. They can't prove their case. They haven't proven their case. And so I don't really have to do all that much. And if you don't, you know, the only way to win that argument as a defense attorney is when the prosecution is finished with their case and they rest. What a defense attorney who thinks that the state hasn't proven their case yet does or should do is immediately do a motion to strike all of the testimony because they did not prove the elements of the offense. That's the first thing that you do, because if you just go into your defense thinking, oh, okay, we did, you know, they didn't prove their case, so we just have to present a minimal defense, then you've lost your case. Now, if you go and you say that the prosecution has not proven the elements and you move to strike the testimony, then the judge has to go, you know what, you're right, or no, you're wrong. And now you as a defense attorney, if the judge denies your motion, now you as a defense attorney know that, oh, okay, I guess I better prove my case then. It's not a slam dunk like I thought.
And we followed a number of cases going back to another internet commentator who is also a lawyer, Nick Arcada, going back to the crap, I can't think of his name now. The Wisconsin or not the shooter. Oh man, this is gonna bug me. Oh.
Well, while you're thinking about that, Michael Burke makes a great point here. I've always been a little confused about opening and closing statements, and I generally will not make an opening statement because you run the risk of making an open statement and saying something that you may or may not be able to prove later, or you might forget about it, or you might say something that was proven otherwise, and now you look bad to the jury. So my philosophy is never to give an opening statement because it can't be considered anyway.
Right.
And then in my closing statement, I simply want to point out the flaws, because you've got days, sometimes weeks of testimony, and you want to point out and summarize where the defense went right and where the prosecution went wrong to help your client. So I understand the closing statements, but neither of them are evidence. It doesn't matter what I say in closing. It doesn't matter what I say in opening. It actually doesn't even matter what I say during the trial, because nothing I say as an attorney is evidence. And I'm one of the few attorneys that will actually object when an attorney starts doing a narrative before his question, because I object and I say, Your Honor, counsel's testifying. And you don't want to confuse the jury with extraneous information from an attorney. The attorney's job is to ask questions and get the evidence to come out, not to give the evidence.
Yeah, it was the Rittenhouse trial. That's what I was thinking of.
Oh, okay, yeah.
I kept thinking R, and I'm thinking of Ricada, but not Rittenhouse. But yeah, so we've been following trials for some time now, and over the course of following trials, we've discussed about things, and motion to strike testimony, or a motion for summary judgment for not proving the elements has been something that's been spoken of as being like, that's a default. You just do it, because if it gets denied, it gets denied. But if they do grant it, then your job is done. So,
exactly. And you do that twice. You do that at the close of, and this is what, again, they don't do a lot. You do it at the close of the prosecution's case. You just move to strike the testimony for they did not meet the elements. I was a whiz at this in law school. That's how I won several of my cases. But of course, because we're in school, they okay, technically you won, but we're going to continue because we need the education here,
right.
The educational element of going through a trial. And a lot of defense attorneys don't do that. So you do it twice. You do it after they close if of course it's true. I mean, you don't want to make a motion that is wrong, because that's unethical of an attorney. But if they haven't proven the elements, and I always keep a sheet of every single element, and I've got little boxes, and as the prosecution's going through its case, I will check each of those boxes. And if one of those boxes is not checked, I'm moving to strike.
Yeah, it's a great thing to do, because we know that Rittenhouse is another great example. The one defense attorney that we called Lunchbox, he would have questions that he'd want to ask, and every time he'd ask a question, he would check it off very violently. So it was just funny watching him giving his closing and asking questions and whatnot. But yeah, so going back to the this document that I've got pulled up here, this is the criminal jury instructions for 3.5. And all these things in brackets are things that can be excluded or not, or there's something that needs to be filled in for the individual case. But this is used as the framework language that needs to be used in these jury instructions. So I didn't see anything specifically, as you were mentioning here, lawyer statements and arguments are not evidence. Only the testimony elicited is evidence. My comments and rulings and questions are evidence. But Shannon, the defense counsel, wanted to bring up 3.2, which is presumption of evidence, burden of proof, and reasonable doubt. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied by reasonable doubt that she is guilty. Every crime is made up of elements. Prosecutor must prove each element of the crime beyond reasonable doubt. That's what you were saying about the checkboxes. Defendant is not required to prove her innocence or to do anything starred for affirmative defenses, they may have to do something. Affirmative defense would be like stand your ground, things like that. You find
And that's
that
why it's so important. That's why it's so important that a defense attorney, when the prosecution's done, when the state's done with their case, it's we don't have to defend anything. We don't have to prove innocence. They have to prove guilt. And if they haven't done that, why even go through the process of leaving a defense if you can just move the judge to say they haven't proven anything? And you're probably going to lose in most instances, but it's always important to do that because that's an appealable. You've just created another method of appeal for yourself.
I think what Shannon was going for was this third element here. It says reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. Yeah. And they were saying that you can't infer anything from the lack of evidence, but if the lack of evidence is giving you reasonable doubt, wouldn't that fulfill the burden of doing not guilty?
It would. It would, because a jury should make reasonable inferences to the evidence presented. And generally, if there's a lack of evidence, it should be inferred in favor of the defendant.
Right.
Because you can't infer something that doesn't exist against an attorney, against the defendant. But it's like I said, this, and I do this. This is where I think a lot of cases win is, officers love when they're using their body cam and they're harassing someone or they're violating someone's rights, and then a supervisor gets on scene, they immediately push that button to mute their mic. Mm-hmm. I bring that up every time as an inference that they're saying something that is not right. And
it's so funny you're saying this. I was just at dinner with the undersheriff here, and he told me that he had to rewrite all those policies because his guys kept turning off their microphones, and defense attorneys were using it to say, this is when all the bad shit went down. And he said once he did that and they stopped turning off the microphones, they win like 90% of the time because nothing really was happening, but they were using the inference that the appearance of impropriety to make it look like they were.
Yep. I mean, that's how we do it now. And I'm, if there's such a thing, I like to consider myself a more ethical attorney. I'm not going to, I pick and choose my cases. I don't, forgive me for saying this as a defense attorney, I don't defend guilty people. And I know that you're not guilty unless proven, so you're innocent unless proven guilty. I get that. But, if some guy comes to me and he says, I'm looking for an attorney for a DWI, and I'm like, well, were you drunk? Yeah, man. I was like, I blew a 2.1 or I don't know, whatever, or 0.2, and I'm like, well, I'm not going to defend you. Yeah, but they did this wrong and they did that wrong. In my mind, I have a conscience, and I don't want to help someone get off on a DWI on a technicality, and then when that person gets off because I helped him get off on a technicality, and then he goes and drinks and drives again because he didn't learn his lesson and kills somebody. Now I'm like, well, hell, I could have put him in jail, but I like to help people with their rights anyway. I do have a DUI case right now that there's no way it's DUI. The officer lied. He just didn't like the fact that the guy stood up to him. And so he's like, oh, wait, you're slurring your words. And I can't wait to get this guy in court because I'm going to ask him. I'm going to play the entire thing. All right. Just tell me to hit pause when you hear a slurred word, please. And I like to do this thing where I put the video on, when I'm watching the dash cam or the body cam, I put it on 4 times speed because a drunk person's going to be swaying a lot and they're going to look really jerky when you put it on 4 times speed. But this client's just standing still, not moving at all on 4 times speed. You'd think it would be an exaggerated movement. I mean, the officer just completely lied, invented this DWI thing. One cop says, and he used this, I smell alcohol thing. It's like, how am I supposed to bring your nose into evidence?
That's a very good question.
I use this with my wife, and here we go again. I'm about to bring out the classic CJ that you guys know me as from the video, but ever since I've had COVID, I have no sense of smell.
I hated that. I lost mine for like 6 months.
Oh, it's been like 2 years for me now.
I'm so sorry.
It's funny because my wife is like, "Did you fart?" And I'm like, "I don't know. I don't smell anything." So I joke. I'm like, my farts haven't stunk since I got COVID. It's great. It's awesome. So it's the same thing.
There was a video that went around Twitter, I'd say within the last 6 months, of someone who was pulled over, and he cracked the window ever so much so that he could give the license and registration to the officer. And then you just see this officer basically going through his script of different things to say to try and elicit him either getting out of the vehicle or trying to create the presumption that he can basically now go and search the car. He goes, "Do I smell alcohol?" He goes, "The fuck you do." And he goes,
"The fuck you do."
And then he goes, "Do I smell marijuana from the car?" He goes, "No, the fuck you do."
There's that word again.
Yeah.
You know, that's how what's his name just got arrested. Darius Rucker got arrested because of an expired plate, and they claimed that they smelled a strong odor of marijuana. And then they searched him, and they searched the car, and they found psilocybin and a vape, a THC vape.
See, and I know in Texas and many of these states, the smell of marijuana is no longer probable cause because they've legalized hemp,
right,
or anything with 0.3% or less THC. And so because, you know, I mean, heck, if I wanted to smoke oregano, I could do that. It's perfectly legal. I don't know what it would smell like, but the smell of marijuana, at least here in Texas for sure, is no longer probable cause. And if that's what they use as probable cause, because THC 0.3% or less is legal, because hemp is legal, because CBD is legal.
I think Tennessee, it's not legal, and it's not legal there yet. I'm not sure. Let's see, Tennessee.
But does the presence
marijuana.
of THC elicit the smell of marijuana?
No, not burnt marijuana, because they always very specifically say burnt. You know, I smell the odor of burnt marijuana as if you're smoking it. Well, I can smoke oregano or Parmesan. Well, that's cheese.
That's
cocaine.
Yeah, it's still illegal in Tennessee, including medical marijuana. You can't have any of it.
And the other thing is, what I do is, and I got this off Wish, but I've got these little clips that are on my windshield that I put up right above the driver's in the corner, little clips on my windshield. And when I get pulled over, I don't roll down my window at all. I put my driver's license in the clip. I put my insurance in the clip. Everything's in the window, because all I'm required to do, at least in Texas, now every state might be different, but at least in Texas, you only have to present your identification, or you only have to identify yourself. You don't have to hand over anything.
And one of the worst things is if you have your insurance card on your phone and then you give your unlocked phone to a police
bad
officer.
idea.
Absolutely do not do that. I'm not a lawyer, but that is legal advice.
Do not do that. If you are going to use your phone, then you hold it and let him look at it. Don't give it to him. Otherwise, keep a piece of paper in your car. Do not hand him your unlicensed phone, because you never know. He might be looking at your insurance while he's got your phone. And I wouldn't even do what I just said, which is show him the phone. I used to do it this way, but I don't even do that anymore, because I'm worried that while I'm showing him the phone, what if my crack dealer sends me a text saying, "Hey, buddy, I got your rocks ready," while the cop's looking at it?
Mm-hmm.
I don't want the officer to see incriminating information on my phone. And I'm not a drug dealer or anything, but who knows what it is. Hey, buddy, I got that body buried for you. What do you want me to do now? As the cop's looking at your insurance.
It's terrifying.
All right, we can go back now and watch. We still haven't finished the rest of this, and I want to.
It's a long video.
It's so good. Wait, where am I? There we go. I want to watch you guys walk back in, because I want to ask you because you can't see the faces really. And I just want to hear your description of what happened, because this is so funny. This was after CJ was taken out under the threat of arrest. And his client was also taken out on the threat of. Did they actually arrest him, or?
No, nobody was arrested.
Nobody was arrested. Okay.
I think they knew better.
Yeah, they figured it out real quick, I think. What is the deal with this? Come on.
Well, while you're doing that, just so you know, a little bit of an update. This is breaking on your show right now.
Oh, good.
The city attorney for Aransas Pass was fired.
Really? The city attorney was fired. Well, he should be. He should be fired.
Yeah, just a couple days ago. It was just last week.
Do you have the stream up, Megan, on another tab?
Like the live, verdict
court feed.
Yeah, let me turn that off. Maybe that's the problem. I've got some other stuff open too, so I'll turn off the YouTube studio too. Maybe that will help. This YouTube is just screwing with me.
If
There
I
we
go
go.
back in this door,
Yeah.
who is going to not arrest me?
Are you going to disrupt the proceeding?
I didn't disrupt the proceeding last time.
It sounded like you were allowed in the hallway, and then we had.
No, I was out in the hallway because you were illegally pushing me out of a meeting.
Yeah,
The mayor kicked me out.
I wasn't there for that. I was there for you getting out from the building.
So you don't know what happened in there. So why are you saying that I was disrupting the meeting when you have no idea what I was doing in there?
I didn't. Oh, okay.
I didn't.
Disrupting the meeting because the chief said you were disrupting the meeting. That part I heard.
Okay. And the chief said I was disrupting a meeting because I said fuck at the podium. Which this specifically says the word fuck, because I even quoted straight from the case law. Fuck school, fuck cheer, fuck softball, fuck everything. That's Mahoney Area School District v. BL.
Okay.
All right. That her free speech rights were violated
Yeah.
when they suspended her for that.
Okay.
There's the Cohen case where he was at a meeting and he wore a fuck the draft. Same thing.
Okay.
So I said, fuck. The mayor said, I can't say that. I says, well, mayor, I just read you the case law. I can say fuck as much as I want. I can say fuck you. I can say fuck them. I can say piece of shit.
Yeah.
And
yeah. Know that?
Do you expect them
I just
to
read
know
it to
that?
them. I literally just read it to them.
I could print something off the internet that says what I wanted to.
Are you serious?
Yeah.
Is that really your argument?
I could print something off.
When a lawyer comes up here who's an officer of the court and says what the law is, and there's not a city attorney in there.
This isn't a court proceeding, though.
It's not, but this is a
They
public
treat it like
meeting.
it is.
Yeah. It's funny. It's not like a court unless they're trying to say we want you to treat us like a court and stop cussing at us.
Oh my God.
And this idea, well, anybody can print anything out. Okay, well, print something out that shows that Cohen v. California was overturned.
It's so funny. They are so funny.
I shared in the chat just if you want some. There's another issue here in Killeen that is nearly similar. I wasn't. They actually tried to keep me from speaking as well, and they actually ran away. They adjourned instead of listening to me.
Really? They
But-
adjourned? Oh, I've had that happen before where everyone just gets up and walks out.
Yep.
They did that to me in Orland Park once at the library board meeting.
And this is what I saw. I think I saw a comment about where. So this is in Texas, at least we have what's called the Texas Municipal League. And once I started realizing that there's a problem, because this is happening more. At first, I thought it was just happening in Texas. And then when this video that you're showing went kind of viral, I started getting emails and being sent videos from around the country. And I was like, wait a minute. So there's got to be a higher power going on here. But I guess there's some international council of municipal something or other. And so what's happening, I think, is, these communist entities at the highest levels of like the United Nations and the international community are pushing these nations to adopt these policies that are communist policies to shut the people up so that they can rule without interference. And then, of course, they push down these what are called model rules or model procedures, and they get sent to each of the state things. Like in Texas, it's called the Texas Municipal League. There's probably a Michigan Municipal League. I don't know, something similar to that. And then they send it down to their individual cities and say, here is a model rules of decorum. And that's why now your local town of 1,800 people is now being run by an international conglomerate of communists that is pushing these rules of decorum. I mean, we no longer have local governance because you've got international committees that are dictating to the nations, who are dictating to the states, who are dictating to the municipalities how to rule the people at the individual level. That's a big problem.
Yeah, it's a huge problem. And I've noticed that there's been even in our local elections, I have a friend who's really, Shannon Joy, she's really into local politics, and she's a radio host here in New York, in the Rochester area. And she's been reporting that these people who are getting elected to school boards have like major money behind them coming from places that nobody can really identify, which is really unusual in local politics.
It was like Soros backing district attorneys.
Exactly. And it does sound like a conspiracy. I know you get some of you in the chat are like, this is so conspiratorial. Name me a conspiracy in 2024 that hasn't come true, including aliens. Okay. Cause like, you know, there's like aliens now that the government is talking about, which they told us for years did not happen.
I am the least. It's weird that you hear me say, and I know people are talking about, oh, here comes the conspiracies. I'm probably one of the biggest pushers back of all these types of conspiracy things. Like I think the one right now is on Taylor Swift and the powers that be trying
to win the election.
I'm like, you know what, guys, shut up. There's no conspiracy to get Taylor Swift into, or Biden elected through the NFL. It's just okay. Just enjoy the game, okay, if you can, by not having to look at Taylor Swift. I like Taylor Swift. But I push back on these things, but there are some things that when you do the research, because you think, we're designed to think, especially here in the United States, that we have this beautiful government, this beautiful system, not government, but system of law, system of justice. We've got these constitutional protections. These things can't be possibly happening here. And I represent 3 J6 candidate or defendants right now.
Wow.
And I would not have thought the kind of stuff that our government was capable of had I not been with those 3. Now, I will also say when I was in the military, I was a counterintelligence special agent. Okay. So a lot of people think that I'm a part of the system anyway, just because my job was espionage, sedition, treason, all that kind of stuff. As a counterintelligence special agent, I had access to a lot of classified information. I helped recruit people to spy on their own country for the United States. So I've seen what the government can do. And even I'm surprised at the stuff that I'm learning that I never even knew existed with other agencies, because I was just in the DOD. I worked with the FBI. I worked with the CIA. I worked with the ATF, which is why I think I am who I am today, because I see how big the government has gotten and how it can be used to silence people. Military intelligence is an oxymoron. That's why I went into counterintelligence. I was a counterintelligence agent. And so this idea of, the TML does exist, the Texas Municipal League. I think it's called the National Committee on Municipal Governance or something like that. There is a United States national entity that works with entities like the TML, and they push down what's called best practices or model codes. You'll notice that a lot of city councils, when they adopt a code of ordinances, they're very similar to every other code of ordinance, because these are model codes that are sent down. These trials that you cover, we have what's called model jury instructions. There is, when I go to a case and we go to a trial, you start with a template that is created at the national level that is a model jury instruction for the charge that you're being charged with. If there are circumstances like self-defense, or if there are circumstances like Fourth Amendment violations, there are model jury instructions for that. And then, the judge, the attorneys take those model jury instructions that the judge has already, and good attorneys will argue over them, and they will skew them and make them better so that they're more justice oriented. But if you don't think that there is a higher power like the United Nations or some international organization that is controlling all of the member states that are involved in that, I've been asleep for a long time. So I used to think, way back in the day, the Patriot Act was a great thing.
Me too. Me too. Boy, did I learn my lesson. Holy crap.
And I'll tell you why, because I was in the intelligence community, And the only part that I was concerned about was the fact that, okay, this is great because now the intel that I have, I can share with the FBI, the CIA, and we're going to come to a bigger picture. Where, you know, so a 9/11 doesn't
The
happen.
intelligence sharing, that's how they got us. They said, oh, we weren't sharing stuff before, but now this will let us share all the information. Sure.
Right. But now you see how all that's being abused. And not only that, all the other stuff in the Patriot Act that's been used against the citizenry.
Like being able to hold people without a trial for 2 years or whatever it is, however long, indefinitely, however long they want to. They're absolutely doing that. Brad's got the video now, so it won't stop and start. We can finally finish this. Let's see the rest of it.
Seek redress, do I not? I have a right to criticize elected officials. He has a right to. Now, I'm not going to sue on my behalf.
Okay.
I'm going to sue on his behalf.
Okay.
So I need to know, I guess, even more appropriately, if Mr. Followell goes back in there, is he going to be arrested?
I don't believe that he doesn't have a criminal trespass. He was.
Well, let's try it then. Let's see if we can just go sit down.
All right.
And just don't say a word.
All right.
This is so great. Everybody needs to go to their board meetings with their own lawyer.
Now pay attention to their faces. I can't remember if I showed them or not, but pay attention to their faces.
I don't think
when
we
we go
can
in there.
see them. I
It
don't
must
think
be
we
on the
can see
live
their
feed that you saw it.
It's like they're fuzzy.
Yeah.
And you guys are so far away, we can't see their faces.
Yeah, so the rest of it's kind of boring. Nothing happens for the rest of the video.
Well, okay, so Brad, you can stop that. But I love that you walked back in and sat down and nobody said jack. Like they didn't say anything. They didn't try to stop you. It's like somebody gave them the memo. Like now you're in trouble because you did something bad.
And you know, the only reason I did that was a power play because I want these people to understand, at least in, you know, we have an Article 1, the people are the power in the state of Texas. And our Constitution is the same way. You know, the preamble, we the people are establishing this, do ordain and establish this Constitution. And so I wanted to make sure that they understood that absent the threat of arrest, I'm going to do whatever I want and you can't fucking do a thing about it.
It's so good.
And I, you know, and I loved, so if you go back and you watch, I guess if you just look up Aranza's past city council meetings on YouTube and they're there, and then you just go back to that particular video and you can watch their faces when we walk back in. You see the city manager looking at the city mayor and the city mayor looking over at the chief of police. And it's just, you know, you can see that their brains are scrambled. Both brain cells were confused.
Rogue Mama says, I swear the client looks like the Undertaker. He does. He kind of does.
That dude is a beast. Jason is a beast. He's obviously he's a bodybuilder. He owns his own gym. He's such a great guy. The way I learned about him was that I saw a video he did where they unlawfully, so he's a very big critic. And so what they started doing was they started using code enforcement against him, and they did a warrantless search into his gym, and they started creating all these bogus code violations and all that. And as a matter of fact, another update for you is last week I went down and argued our motion to suppress because they had to suppress all the evidence on these code things because they did this warrantless search against him. And, you know, I'm in there arguing and the prosecutor's like, oh no, they had this and that. And anyway, we won and got that case dismissed because they did that warrantless search. And that's how I even came to know Jason, because of the way that the police and the fire department were now being used by the city manager to go after Mr. Followell in retaliation. And so, when I saw his first initial video,
they've pissed him off. They've pissed him off. Yeah.
Oh yeah.
Yeah. Mm-hmm.
Is
he in any litigation? Is he in any litigation for that?
I'm working on the lawsuit right now. So we are suing the city both for the Fourth Amendment violations as well as the First Amendment violations. We're going to go into malicious prosecution because they knew better. You know, Jason fought the case pro se on his own at the municipal level, and he got the the local attorney, or not the local judge, the justice of the peace, to dismiss the case because it was a Fourth Amendment violation. Well, the city was like, this guy's, as you know, most municipal court judges aren't necessarily attorneys. The justices of the peace don't always have to be attorneys. And so they're like, oh, well, we can win this at the county level. You know, this guy's, if he brings up this argument, he's not going to know how to argue it. And so I came into the case and defended him at the county level where the city appealed to. And what's funny is they were so smug and they thought that they were so right. They didn't even bring any witnesses to the hearing. And so I just put Jason Followell on there because he's like, oh, you know, he's got all this rubbish in the back and this and that, and it's blocking a sidewalk. And so I bring Jason up and I bring out all the evidence about, okay, so, you know, here's the picture that they're using as probable cause of rubbish. What is this thing that's curled up on the ground? Oh, that's a garden hose. And how is it on the ground? It's rolled up like I keep it. So it's not just thrown out there. It doesn't look like it's been tossed or abandoned, right? You know, when we go through this whole thing, and the guy talks about a carpet that's out there that's supposedly blocking or obstructing the sidewalk, you know, and Jason's like, he's like, so would you agree that this is obstructing the sidewalk? And he said, no, that's not a sidewalk. And the state was so adamant that they were right because they've gotten away with this crap for so long that they didn't even bring a witness in to say that it was obstruction. And the attorney tried to essentially put all these words in there. He tried to testify. And of course I objected. I said, Your Honor, the counsel's testifying. He's not allowed to testify. And so he couldn't say anything anymore other than question the only witness, which was the defense witness. And the defense witness obviously isn't going to testify to his side. So anyway, it was, so that was fun. So now that we've beat them in court on Fourth Amendment issues, once with an attorney, once without an attorney. Now we're going to start. I'm just drafting the lawsuit. I'm doing the Colleen lawsuit right now, which I shared the link in. That's the one that I'm doing right now. I've got like we've got 5 plaintiffs on that case because they keep doing the exact same thing. You know, when someone gets up there and tries to discuss an agenda item and they're being critical of city council members, they shut them down and they tell them you're off topic, or you can't criticize us, or you're not allowed to mention this person or that person. And every single time they do that is a violation of their rights. And so it's going to be about a 60-page complaint, replete with pictures and funny anecdotes and all that kind of stuff.
You have a YouTube channel. I am putting the link in the chat right now on both Rumble, YouTube, and my locals, meganfox.locals.com. Make sure you get over and subscribe to CJ on YouTube. What do you do over there on your YouTube channel?
I don't do as much as I used to. The channel, if you look at it historically, was a Second Amendment channel. I'm the founder of Open Carry Texas. And after my first bogus arrest, I started Open Carry Texas because we weren't allowed to open carry in Texas. You could carry your AR-15 anywhere, but if you showed your pistol, then you were committing a crime. And we also didn't think that you should have to have a government permission slip to exercise a fundamental right. So we were fighting for constitutional carry. So most of my stuff is Second Amendment related. Now that I'm an attorney, I try to put more stuff up there. Most of it's live, but I just haven't had time to do a whole lot. So my videos are very sporadic. I don't have like a weekly podcast. I don't have anything that you just kind of got to sub and then get notifications, because I do it like you do. I don't really do prepared videos because I want people to see that I know what I'm talking about. I don't have to edit my way to a good video. And I want people to understand it's genuine when I'm talking about a subject. This is something I care about, not something I'm just trying to make money off of. And so my videos.
I like your website too. Your website on YouTube, the link says isubadcops.com.
Yeah. I've got several. I've got I Sue Bad Cops, Texas 2A Attorney, Lawyer for Liberty. All of those go to the same place. But yeah, I Sue Bad Cops is the one that I think people will remember best.
That's ISueBadCops.com. It's perfect. I love it. I sue bad boards. I should buy ISueBadBoards.com.
Or I sue
but-
bad government.
Yeah, bad government. And it's a booming business, CJ. You really cannot go wrong because everywhere you go and to any of these government boards, you're going to find people behaving badly. There's all kinds of opportunities. So thank you so much for being here today. I
Thank
sure
you.
appreciate you. And
Yeah,
it was
thanks for the
great to
time.
meet you. Hopefully you can come back sometime. We do a lot of legal coverage here, so maybe you want to pop in sometime and hang out on some live streams when we're doing these court coverage. You're fun to have.
Yeah, I'd love to if I could find the time to do that. As you can see, I was even late to this one because I was in with a judge, and I actually just had another client walk in the door, so this is perfect timing.
Perfect timing.
Thank you so much for the opportunity, and if you ever have anything that you want, me to fucking talk about, then I'll do it.
The chat, I put up a poll that says CJ's comments to the board were great or fucking great. Fucking great is winning by 87%. Thanks for
Megan.
fucking dropping by, CJ.
It's been a fucking pleasure. Thank you so much.
Great fucking day. We'll
All
see
right,
you
take
again
care.
soon. Bye-bye.
Bye.
Oh, now fuck off. Oh, no, he's great. God, I love him. That was one of the best public comments I've ever seen in my whole damn life. So good. All right, Brad had to go. He had some stuff he had to take care of. But he left up his camera, thank goodness, for the live stream because YouTube is really giving me problems right now. The Archie Ruckus cam I had taken down because he's nowhere to be found. I don't know where he is. So when he comes back, I'll see him when he comes back and we'll put him back up there. All right. What a great fucking guest. That's absolutely a great fucking guest. Danny B, that was fucking great. Oh, it was good times. All right, let's hit the super chats. Elizabeth, thanks for the $10. Some parents don't even know when their kid's birthday is. As long as child support is paid, they're legally fine. Can we start holding these absent parents accountable for their kids' actions? It's a slippery slope, Elizabeth. It is a slippery slope, and I don't know where the line is. Vince Clore, though, I haven't seen you in a while. Thanks for the super chat. Says, if you own a gun and have teens, I'd be worried because a normal teen could open a gun lockbox in less than an hour if they're determined. Yeah, I guess that's true. I mean, life is risk, Your Highness. Life is risk. Lacey Ann, thanks for the super sticker. I appreciate that. Smudge the Cat became a new member. Oops, I accidentally deleted your new membership, but welcome to the Fox Den. I just deleted the thing on accident. I unstarred it. Unhung Hero, thanks for the super chat. If you can identify by any gender, you can identify as a resident. Well, I believe that to be the case as well, and I'm sure, and CJ does too. Jules wanted me to know that Judge Carroll issued a new order on the stay of execution. The bond must be $75 million. So that means he did not stay the execution. That means they must pay. And she sent me the document. So maybe we'll go over that. Hold on a second. I'm looking at my lips are dry. I need my new lip gloss that's on my Amazon store. If you guys want to go there in the link tree, you can get a link to it. It's this e.l.f. stuff. I really like it. It keeps my lips from being dry. And it has it's paraben free. I really like it. It's on the Amazon store. So is the lip stain that I'm wearing underneath of it that I really like. I cannot get enough of that stuff. Master Sergeant, gangster for sure. I liked that comment, so I started. And Octavia says, we're here for your power play, CJ. Yes, definitely. We liked all of that. Christy Pooh says, that's why people don't speak out. The corrupt officials use garbage to destroy you. That's true in a lot of cases. A lot of cases. That is true. All right. Duncan Idaho, thanks for the super chat, says, dang it, I accidentally voted great in the poll before I read the option of really great. That wasn't the other option. It was fucking great. We're practicing our free speech today, children. Gather round and use your F words. Okay. Yeah, we needed more upbeat trial to watch. This trial is depressing. It is depressing, but it's also really important. It's like, It's a very interesting case, and it's going to set precedent. So I'm sorry. I'm sorry that it is as depressing as it is, but you'll get over it. All right. Don't forget to sign up at meganfox.locals.com because there's all kinds of stuff going on over there, including wax art. That is a lot of fun. I am going to go over to my email now because Jules sent me the new document in the Kowalski case. Maybe we'll go over that while we're waiting for the jury to come back with a verdict. Waiting for them to come back with a fucking verdict in the state of Michigan versus those fucking Crumbleys. And hold, please. Marco says, since you said it, fuck, fuckity fuck. Use your fucking words, chat. Yeah, okay. I'm going to get the execution document. Just, you're distracting me. Hold, please. The lip stain is bay free. It's in my Amazon store. And if you click my link and you buy it through my link, my influencer link, I make a part of the proceeds. So you want to go to my link tree, which is in the description of every video I ever do. And you click on there and then you go to the Amazon store. It's easy. You can do it. Chop, chop. All right. Chat, stop fucking distracting her. It's not fucking funny, chat. You know what is funny though? CJ Grisham is funny. All right. What do we have here? Amended order granting unopposed motion for stay of execution pending review. Oh, so they granted it? I guess I didn't understand Jules's message. Well, let's read it. The defendant has filed an unopposed motion requesting that this court enter an amended order of stay of execution pending review of the judgment in the Second District Court of Appeal. The parties have agreed that, in the light of Section 45.045 Florida statutes, including the statute's requirement for an adjustment based on the Consumer Price Index compiled by the United States Department of Labor, that a $75 million bond will serve as good and sufficient bond for this appeal. Accordingly, this court orders a stay of execution of the judgment in this case will commence with the posting. Oh, but they still have to post the surety bond. Well, they hate that. That sucks for them. They have to post a surety bond in the total amount of $75 million by the defendant with the clerk of the circuit and approved. Oh, you know what? I just realized I forgot to send Dr. Corcoran a link to the show. He's going to pop on maybe if he has time. Hold on, because he is having Nick Whitney on his show tonight to discuss a possible new case against Dr. Sally Smith. You remember Sally Smith, right?
My name is Dr. Sally Smith, and I am always right about everything. I'm right about child abuse, and pretty much every parent I've ever met is a child abuser.
You remember her, right? Well, Nick Whitney has maybe a new lawsuit against Dr. Sally Smith, and they will be talking about that tonight on Dr. Joe's channel. And let me throw him over the link just in case he wants to come on here, since we are talking about, let me text him too. I feel stupid that I totally forgot to do that. I was supposed to do that like way earlier, but this is good timing. Check email for link to stream. Now is good for next hour. I'm talking Kowalski's. All right. So anyway, he's going to have that. He can give us a couple details on that. Oh, look who's back in front of the camera. Look at this. Look at this. He just came up to the camera and took a nice little stretch. Hey, buddy. How's my good boy? Where's my good boy? Where's my good boy? He hears me, but he's too lazy to get up and actually make faces at the camera. So it's too bad he sits with his face facing away from the camera. Because, yeah, you're doing it wrong, buddy. You're doing it wrong. Okay. All right, let's see. The stay will expire the day after a notice of appeal is due to be filed in this court if the defendant does not file a timely notice of appeal. This stay will not stay proceedings in this court on matters over which this court has reserved jurisdiction in its judgment, or on matters for which this court has concurrent jurisdiction with the Second District Court of Appeal or any reviewing court. The duration of the stay will be specified in Rule 9.310E. So, yeah, this was always going to happen, but the question was, what was the surety bond amount going to be? So, to my knowledge, this means that they have to turn over $75 million in a surety bond, like so that the court knows that the money is there to give to the victim if the appeal is denied. All right. Yeah, and it was going to be 50, so he increased it from 50 to 75. Thank you, Jules. Appreciate that. So yeah, I really want to know about this case that Nick Whitney has. I had asked Nick to come on. He was going to come on after it's my fault. I didn't follow up with him. He was going to come on after the hearing with what's his name? Juror number 1, Paul. Rogue Mama, a member for 2 months, says, fluffing fabulous. YouTube censored me. Oh my God. A lot of people got a lot of fucks out on the YouTube chat that didn't get censored. Fan-freaking-tastic. All right. Let me open this. Is this a different one? No, I think, Jules, you sent me the same document twice. That's okay. That's all right. All right. So I think that's pretty much it. Does this mean interest doesn't keep accumulating when they appeal? No, it does not. Interest keeps accumulating. It is accumulating every second of every day. And in fact, Recovery Addict has a counter. And let me go over and see if I can find it. Let's see. Kowalski interest counter. Is it live all the time? Like, is he just running a live count? Because it is live. Where is it? I think the link is on my phone. Hold on. Anybody on Locals have that link? You got the live interest counter? Hold, please. Watch Archie Ruckus look out the window for a minute. Zuckerberg is in front of Congress today in the Senate. Should we watch some of that? Oh, look who it is. Just in time to save me. It's Dr. Goodhair.
Hey,
How are you?
I'm good, Megan. How are you?
I'm fantastic. Thanks for being here. Tell me all about what's going on. Let me move the dog cam down here so we can. There we go. Archie Ruckus has his own camera now.
Oh, that is so funny. That is so funny. Oh my God. Yeah. So the last, actually, one of the last. I always try to jump in and catch up to what you're doing, and I got to be honest with you. When I tuned in and saw you going through your hair care products, that I thought this was more than coincidental. So
It's been a while, you know?
It has indeed. We stay in touch frequently through text messaging, but
That's true.
not enough FaceTime, that's for sure. How are you
That's
doing?
true. I'm good. I'm good. My hair, I'm not having a good hair day today though. I'm not feeling it. I slept on it and I didn't do it and I had to wear it up the other night so it dried weird. So this
You
needs to be
know,
redone.
I feel the same way. I mean, I slept on it.
It's not great. It's just not
Oh,
great.
goodness.
But tell me about this. So you've got Nick Whitney coming on your show again.
Yeah,
Hasn't he
yeah.
been? He still
It's only
hasn't
this.
been on my show.
It's only the second time, and he
Oh,
was.
sure. Well, you tell him that I said he's supposed to come on this show.
You know what? Nick is
It's
a
my fault.
very generous guest. He really tries to make himself available, and yeah, I'm super excited to have him on this evening. You know, Meg and I had just a lousy January, and
I know.
I've been so tied up with other things, including the flu and bronchitis, but also a couple of just as you were doing, attending a celebration of life. I've done that as well, and but the good news is I literally tore out the page, the January calendar, and we're into February, and got some really exciting stuff coming up, including tonight with Nick. That'll be 6 o'clock Eastern on my YouTube channel, CMO Dr. Joe. Nick is going to be getting us caught up on everything that's kind of happening behind the scenes since the December 15th hearing, the January 2nd orders, the January 3rd interview with Paul. I'm really trying to get away from calling him Juror One because
I know.
having had the opportunity to meet him finally, there's so much more to that guy. So you know, it's almost depersonalizing to call him Juror One, but it is a pretty great nickname after all. But
Well, that's
there's
how
so much
everybody knows him. Everybody
for
knows
sure.
him by juror number one, just because
Yeah,
it just became like a meme almost, you know.
yeah.
But
But I
yeah,
think but I think that
I found the thing. I found the thing. Thank goodness. I found
the counter.
the counter.
Yeah,
Yes,
yeah.
I was trying to find the counter. Here's where we're at.
Isn't
Uh,
that awesome?
yeah, this is so great.
Scott really went above and beyond when he put this up, and I think it's going up 60 cents every second, which is hysterical, right?
It's
But look at that.
fantastic.
But look at that. $784,000 in interest just since the judgment was put in.
What is wrong? Somebody needs to send this to J Hatch's board of directors so that they can see this in live real time and ask themselves, is it worth it
Yeah,
to
for sure.
us to not only continue, you know, owing this much money every day, but also destroying our reputation as being this institution that keeps going after these people, even after the people have spoken. This is not a great appealable case that they have. It's a bullshit case.
Well,
Excuse
and you
my
know
language, but it's
it's
a
all right.
bad.
I actually heard worse out of you earlier when you were interviewing the guy from Texas. Holy crap! You were dropping
Well,
F-bombs like my Irish mother used to drop.
oh well, that was part of the program. You know, we had
Yeah.
it's Free Speech Monday.
There
I
you
think
go.
I just
There you go.
made that up.
No, I actually thought that his presentation to the Aransas City Commission was one for the record books.
Wasn't that great?
Oh my gosh.
Sometimes they need to be reminded, you know,
Yeah.
that what is their purpose, and their
Yeah.
purpose is to sit there and shut up and listen on
Yeah.
one day a month. They only have to do it for a couple hours, one day a month.
Yeah.
And the way they behave, you would think that you're asking them to walk on hot coals.
Yeah.
And it's just sit there and be quiet and listen.
Yeah. Well, and I think that there's so much of a sense that, you know, hey, I'm at the front of the room, so I'm up here and you're back there,
Right.
you know. And
Yes.
and you know, the reality is, and I think he pointed it out, is they work for us, right? We pay their salaries, they work for us. They are you know, they are there to execute the will of the people. And that gets lost all the time. But it's unfortunate, the side effect of the system that we've built. Wasn't the way that the founders built it. We built it that way. We've amended.
Isn't that terrible? There's
Yeah.
something wrong with us.
Yeah.
Tell me, Joe, what can you tell me about the possible new case that Nick is working on that involves Dr. Sally Smith?
Yeah. So really there's kind of two different phases to how I expect the conversation to go with Nick tonight. First, we'll be talking about, getting everybody caught up, right? Including this $75 million bond that Judge Carroll formalized today. Full disclosure, that was the discussion is something that the appeals attorneys representing the Kowalski family have been engaged in. So that's why it's termed unopposed, right? So, but the second part of the conversation with Nick tonight is really fascinating. So there is a woman who I've had the opportunity to speak with that approached Nick, and Stephanie spent 8+ years convicted of manslaughter and spent the first 5+ years of that term in maximum security penitentiary.
Wait, was this the daycare death?
Yeah.
Oh my God, I know about this case.
Yeah.
I was researching this case, and Sally Smith was their star witness.
Yep. Offered no science, no evidence, just opinion, as best as I can tell. And I have not yet had an opportunity to review all of it, but the way that it was portrayed in filings from the Innocence Project and the Exoneration Project, it really seems like she was convicted based on an opinion. And so, and overthrown, to kind of even in the moment, she was exonerated because of ineffective counsel during the trial. But excuse me one sec, that can wait. But but her attorney never even pushed back on this theory. And so the Stephanie had a baby that she ran a daycare for 15 years. And she had a baby that she had never seen before. She took care of this baby for one day, and the baby ended up dying shortly after the parents picked her up. And they said at first that it was shaken baby syndrome or child abuse, but there was no bruising, there was no nothing to support that. So they changed the theory and said, oh, well, this happened from repetitive dropping on a soft surface like a mattress, right? But then the physics doesn't support that. So it was really, I mean, unfortunate it doesn't even begin to tell the story. But so she had really given up because they had an evidentiary hearing that lasted 4 days to go through all of this new calculations and physics and what have you. And the judge said, "Yeah, no, I'm not convinced," and sent her back to prison. And so,
oh wow.
Yeah, so now she's out thanks to the Innocence Project and the Exoneration Project that took her case, got it to the Second District Court of Appeals. She got and now the question is, what can she do about it? And she's coming up against she would love to see some consequences for Dr. Smith, but the statute of limitations expires, I think, in July, and it's
in July.
Oh
No! Is there a way to get well, if you get it filed before July, you're in.
Correct. Yeah.
I guess it just depends. Oh, what they need to do is, well, maybe I should text Greg privately because I don't want to give Sally Smith any ideas. But but I'll just say this: Sally Smith has been talking to press. And I think that might not be a wise thing for her to be doing because there's not just Stephanie's case. but we have the Kirchner's case,
The Kirchner's, sure.
which Greg texted me the other night. He wants to talk more about that. There's been
Yeah.
some developments. I told him to get back to me with what his schedule is like. So we're going to have Kirchner developments, and that involves Dr. Sally Smith. To whoever it was in the chat, somebody said, I'm not obsessed with Sally Smith. I want to move on. Let me tell you something about Sally Smith. We ain't done with her yet.
Yeah.
Okay. You can move on, but I'm not ready to move on because Sally Smith has been a part of causing some serious trauma to many families. If you have read the USA Today coverage of Sally Smith, Dr. Sally Smith, and her behavior and what she has done, we are definitely not done with Sally
And Sally
Smith.
Smith is just one of the experts, right? I mean, what's shocking to me, and Megan, I had zero visibility into this until getting involved with the Kowalski family and the trial. But you've been looking at this for 2 decades, and it's remarkable the stories that you hear. You see within the Take Care of Maya documentary, there are half a dozen stories of other people who have been through similar situation. And then beyond the documentary, there is story after story after story. The other part of Stephanie's story that's so tragic is, she had a 13 and a 15-year-old child.
Oh no.
When she was accused, right? Those children now have made her a grandmother. So she's missed that whole stage of her children's lives. Her 19-year marriage did not withstand the stress of the trial and all of the findings, right? So her life is upside down, as is the life of many, many family members. So, hopefully there's a lot of reunification going on and a lot of catching up. But I will likely be interviewing Stephanie later in February as well. But Nick's going to talk about that quite a bit this evening too. So.
And that's at 6 p.m. on your channel.
6 p.m. on @CMO Dr. Joe on the YouTube channel. Yeah, looking forward to having. Nick always draws a crowd, and
I know. I wish you would come over here on this channel. It's really my fault. I was supposed to follow up with him after Paul's interview in court, and I forgot.
Yeah.
So
well,
it's my fault.
This is your reminder.
I know.
Yeah, no, he's a great gentleman, and he's always a popular guest. So looking forward to having a crowd, and I will tell you that since the first time that he was on, I've gotten much better at being able to field questions from the audience.
I've always thought you did a wonderful job. You're a pro though. You're just a pro at everything you try.
Thanks.
You're a
the
pro.
best. You're
I've
kind.
been super impressed by the quality of your interviews, and I'm actually a person who doesn't have a whole lot of time to watch other people's content.
Yeah.
And I haven't missed one of your interviews.
Thank you. I don't have the salty language that Megan Fox Writer does, but I'm doing my best.
No one expects you to. No one expects you to. But I do have a question about your recent thumbnail. Hold on, I gotta bring it up here. Can you see this? Let's see. Present, share screen. What am I doing here? Who did this Dr. Good Hair logo? Dr. Joe. Who did? Oh my God, I love it. I saw it. I started laughing out loud.
So that is our friend Sally, who does many of the memes for Megan Fox.
Oh, Sally, sure.
Yeah. She, my daughter was home from college over the holidays, and she told me that my current thumbnails are just not what YouTube is looking for. And so, Sally is such a talented artist, and she threw that together in like an hour. But she came up with the Dr. Joe. She also has a version that says Dr. Good Hair, but she came up with
so
that
good.
probably a
And
month
it's
or two
amazing
ago.
how much it looks like your hair. It's perfect.
I'm telling you, she's a very talented artist.
And this
So,
looks like a really interesting interview too. Tell us about
yeah.
this interview because this looks like something I should not miss either.
Yeah. So Fred is, I actually worked with Fred probably 15 years ago, and he is an RN who has been a nurse leader at hospitals, in health systems, in state health systems. And so he's a guy that really understands how nursing needs to pull from different areas in order to be highly effective at the patient's bedside. He and I actually have had lots of conversations around culture, because when he and I worked together, we went to hospitals to help them fix what was broken. They didn't call us when things were running well. And so
Right.
Fred really understands nursing culture from experience and as a leader. And so we're going to talk about, Judge Carroll made such a big deal about the IJ and the cultural element of it, and even ordered that, when the IJ documents get turned over, dating back to 2012, because that's really when the culture likely pivoted when the new CEO came in. So we're going to talk about the impact of culture, and when you realize that the culture is bad, how do you protect yourself? What do you do about it? So I'm really excited about
This is
this
going to be a
conversation on
conversation
Thursday.
everyone has been waiting for. Everyone's
Well,
been waiting for this. This is what they wanted to hear from you. And I
yeah,
think that not that what you've done is not what they wanted to hear either, but
yeah,
this particular topic, I know that all through the trial, that's all I heard from people
yeah,
was I've suffered bad care and I don't know how do you advocate
right,
for yourself when you're up against this huge machine? You
yeah,
know? It's a
yeah,
real issue.
and quite candidly, I've really kind of stayed tied to the trial for content, but 24 is when I want to pivot to the bigger issues, and really the whole concept of advocacy. How do I stand up for myself? Because unfortunately, too many of us just take what we're told and keep moving along, right? And when it's your health, it's too damn important to
Right.
simply accept the answer, right? And so this conversation with Fred will be the first of many that we will have really across all of 24, that hopefully will build a better patient from all of the folks that are dialed in and listening.
I can't wait to hear this. This is
Thanks.
Thursday at 6 p.m.
Thursday at 6.
And then tonight, Nick Whitney will be on with Joe at 6. I may just redirect you guys over there because I don't know how long we're going to be here.
Verdict
We may
watch.
be, yeah, we're on verdict watch. This
Yeah.
could be a while. I actually thought they were going to come back maybe today because it wasn't a very long trial. It was
Yeah.
only 2 weeks. It was supposed to go 3 weeks. There was only one witness for the defense. And it's like, it's a very small jury instructions. So I'm expecting them to come back pretty quickly. I wouldn't be surprised if we had a verdict today. We just didn't get any information though on whether the judge is going to let them stay through dinner or send them home. We don't know. And I'll tell you this, if there is a dinner thing and like they're staying, I'm probably going to kill the stream, redirect you over to Dr. Joe, and then because I need to go take care of dinner and stuff for my family. And if the verdict comes back, I'll pop back on and we will
Fair
watch
enough.
it. But I mean, I've already been here for 6 hours. So
Yeah. Well, and I think the challenge for this jury is that they've got to be unanimous, and it's 12 members, right?
yes,
Yeah. So
it's the
I mean,
highest burden of proof there is. It's criminal.
yeah,
And
but but I
it's tough.
think that listen, we all want somebody to be responsible. I don't know that they convinced all 12 members of the jury that the mom is responsible in this case.
I think they
And
would have had a much easier time criminalizing her treatment of her son. I think
yeah,
they could have gotten 12 people to say this is neglectful and abusive to your
yeah,
son.
yeah.
Saying that she had a duty of care though to somebody else's children is a very high bar to me.
That is, yeah.
I don't know
It
how
was
I have a duty of care to children who are not my own. As a Christian, yes, I have a duty of care to everyone around me.
But it's a moral duty, not a
That's
legal
a moral
duty.
duty, not a
Yep.
legal duty, and there's
Yep.
a difference.
Yep.
There's a difference.
Yeah. Yeah.
So yeah, speaking of, by the way, speaking of how long I've been here today, I'm about to ring the shame bell because this is unacceptable.
Shame.
$55.98 is like, how much is that an hour? I can't do that math that fast, but it's bad. It's really bad. It's like, how many hours I've been here? 55 divided by 6 hours. Oh, Lord Jesus, it's $9 an hour. That's how much I'm worth to you? Is that how much?
That was minimum wage 5 years ago.
We're trying to get to medium wage, Joe. Medium wage. There's
also
minimum
trying to
wage, and then there's medium wage.
Yeah, right.
This will not do, folks. I cannot stick around here and entertain you for hours and hours and hours on end and not even make medium wage. There's somebody has got to do something. Look, how about Cash App and Venmo? If you don't want to do super stickers or super chats, I get it. Because Google takes a whole bunch of it. So you can always go to PayPal. You can go, it's scrolling across the bottom of the screen. You can go to Venmo. A couple of bucks my way would help me sit here for another 3 hours, because that's about how much time we have left. Another 3 hours. And you want me to do this for $55?
So everybody jump on, not only get Megan some financial relief, get her back here tonight, get her back here tomorrow and day after day, and also hit that like button, hit that subscribe button as well. So she does amazing work almost every single day. So
I'm working on it. And I may even start doing a podcast if I can figure it out.
In all your spare time?
In all my spare time. Yeah. Oh, look at Archie is I was looking at the YouTube studio and it's behind, and Archie Ruckus just stuck his face in the camera. But I'm like, wait, why is he doing that over there but not over here? It's because it's behind. Lois, thank you for the Cash App. Says I sent $5 for you for the fuckery. Don't read till Joe is gone. Oops.
My ears.
Let's see. We've got a couple of super chats that came in. We got Unhung Hero says, fuck. Guest mods get the benefit of swearing in super chats. Excellent. Callie Sandy RN, thanks for the $20. Love you, Megan and
Everybody's
Dr. Joe.
stepping up for Megan Fox. Way to go.
Ashley says here now. Be quiet.
Love it.
Anything you say, Ashley. When you're sending in the super chats, you get to boss me around.
So funny.
I know.
Well, hey, I've got to jump over and finish some prep. I actually have to send the link to Nick, but I will harass him tonight about getting onto your show. How's that?
Oh, please do. That would
Absolutely.
be fun. My favorite memory of Nick, seriously, my favorite memory is Greg calling me from the car, and he's driving and Nick's in the passenger seat, held captive. And Greg goes, well, I had to call you. I'm on speakerphone. He goes, I had to call you because I've been complaining at Nick. It was after a bad day in court. I've been whining to Nick, and he's ready to throw himself out of a moving car. And he suggested that I call you so he could put his headphones in and stop listening to me.
They have such a dynamic relationship, and they could not be more polar opposite in so many ways. But they're so smart and so committed, and they're just right. What was the movie that What a Righteous Dude?
Yeah.
A Righteous Dude. Yeah.
I forget that movie, but I know what you're talking
about. Was it Airplane?
About. That's going to drive me crazy.
Airplane? Yeah.
No, I think it was Ferris Bueller. Yeah, the secretary.
Yeah.
The secretary was like
she was Mrs. Marv Mendenhall on the David Letterman show. Yeah.
Yep.
What a righteous dude.
What a righteous dude. All right, Dr. Joe, Dr. Goodhair, everybody tune in tonight, 6 p.m. Nick Whitney's going to be on with him. There's going to be a lot of new stuff, a lot of new information on a possible new lawsuit with Sally Smith and other things, updates on the Kowalski case. I will be directing you guys over to Joe's stream after this. So I expect to see you there.
I want to see the Fox Den well represented. And
if a verdict comes in, you send me a chat, and I send everybody right back. All right?
Yeah. Okay. Sounds good.
All right. Super. Hope to see the Foxes on CMO Dr. Joe tonight. And Megan, thanks for thanks for my daily quota of F-bombs. I'm grateful.
You got your week's quota today.
True that. All right, Megan, thanks very much. Good to see you.
You too.
Bye-bye.
All right, let's get bye-bye. Let's get Dr. Joe's channel up here and we'll get it redirected. There we go. All right, Dr. Joe. It's just me and Archie Ruckus, and he left me too. I see that there are Cash Apps to get to. Hang on one second. I am looking for Joe Corcoran to direct you to, so I don't forget to do this later. At CMO Joe, right? At CMO. CMO. Why is it not coming up? It's so weird. Dr. Joe. There it is. Okay. Got it. Redirected. Okay. All right. Cash Apps. Let me pull up my phone. You guys are so funny. Oh, this is excellent. I now have enough Cash Apps that I can afford to go get, I can afford my massage that I booked, hoping that I would have enough money to pay for it. Excellent. Excellent work, folks. Why can't I get to the, there we go. All right. Christy, thanks for the Cash App. Oh, wow. $55 for matching your current total. That's so sweet. Thank you so much, Christy. I appreciate that. Let's see. And we got Lois. I got Lois. Okay. Who else did I miss? Ooh, dun, 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 dun. And I missed something, didn't I? Who did I miss? I think I have to update the locals chat. All right, at 3:30, coming up at 3:30, we have a half an hour to kill. At 3:30, we have a representative from BARC coming on to talk to us about internet safety and what can be done to maybe avoid situations like Jennifer Crumbley found herself in with her son, whose internet behavior she had no idea about until it was too late. So that's going to be pretty interesting. Right now, I'm going to remove the Archie Ruckus cam because I have to go downstairs for a minute and make sure I go take him out. I'm going to have to take a break. So you do your squats. When we come back, the show is not over. Do not leave. Do not go anywhere. Just entertain yourselves until I come back. But I got to go take care of the dog, let him out, check the fire, make sure it's still going so it doesn't burn out. Otherwise, Mr. Fox gets annoyed with me. And I've been sitting here for a while, so I need to make sure I do that. So you guys do your squats. Do not say goodbye. The show is not over. Hold on. I have to change the banner. Create banner. Do not leave. Megan is letting the dog out. Be right back. Do your squats. All right. I will be back.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile? 2 squats! Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair, get off the couch, No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit.
All right, all right, all right. So how many did we lose? 100 of you? 100 of you don't follow directions. Well, that's a problem. You know what you're going to miss? You're going to miss me opening more makeup from Amazon. So they lost my original order, and I had to reorder this stuff. All right, what do we have here? This is great because I didn't put on anything but lipstick today, so I can actually try it out. All right, what do we got? What do we got? What do we got? This. Hang on. I swear I thought I heard a kid come home, but I walked around and looked and I didn't see said kid. All right. Yeah, she's here. All right. This is some kind of miraculous face cream. I don't know. I haven't tried it yet. Oops. Grifter Wannabe says, now I'm leaving. You can't leave. There's no leaving. You're in. You're stuck. Okay. So this is something called collagen, retinol, and hyaluronic acid. I don't know. It's supposed to be for us oldies, you know, to stop the inevitable. What? How does this work? Oh, there's probably like a. I'm having trouble. No. Okay. It's like a pump of some kind. You're supposed to like push that. Oh, there we go. You're supposed to push that and get like the perfect amount. Oh, it's very cold because it's been sitting in my mailbox in 30 degrees. It's never a bad time to moisturize. And my face is clean. I'm not wearing any makeup except my lips. So that's good. All right. It doesn't smell too, it doesn't like have a really pungent smell. So that's good. I don't like it and it's not burning my face or anything. Wait, I spoke too soon. It's a little tingly. It's a little tingly. And there goes all the men in the chat, says Unhung Hero. Listen, the 20%, we appreciate and love you, and you need to just stay and deal with it, okay? This is going to be a whole, like, I don't know, just a couple minutes. God, my hair looks terrible today. Looks really bad. Maybe I should put it up in a ponytail. All right. So I have these e.l.f. cream blushes. One is called Bahamas, and the other one is Tahiti, I think. Is it Tahiti? Yeah. I think we're going to go with Tahiti because I'm wearing a pinker shade of lipstick. Paraben-free, made with argan oil and vitamin E. I don't wear powder makeup because my skin is too dry for that. I only wear cream makeup. Let's see how I like it. Ooh, wait a minute. It doesn't feel like anything on my face. Hello. There we go. Okay, kind of have to break through the surface of it. A little color in my cheeks would help. There we go. I can't really see because I'm not wearing my glasses. Did I get it on evenly? This is what I like about cream makeup. You can just put it on with your fingers. Excellent. That's better. Do my girls get into my makeup? Not if they want to live. Not if they want to not if they want to survive. They do not. No, we don't share makeup. That's unhygienic. They have stolen some of my makeup before, though. All right, what time is it? 3:16. Well, thank you for putting the Amazon store up. All of this stuff that I just opened up, this is all in the Amazon store as well. So I don't actually know if I'm going to like this yet, but it went viral on TikTok, and so I thought I would try it. Okay. We have 15 minutes. Why don't we get over onto Bark and actually see what it is that they do? And David says, Megan will drown them if they get into her makeup. Well, that's always a possibility. You heard it here. You heard me say it live. Let's get over to Bark so that you guys can see what it is that Bark does. Somebody made the comment in the chat. that if I haven't been concerned about what my kids are looking at online until now, it's too late if I have teenagers. But here's where I disagree with that. I've always been concerned about what they're looking at online. And I use as many of the parental controls as that I have at my disposal. What I have not done, well, I had something, and I can't remember if it was Bark or something else. I had something, but I didn't like the way it worked. It just wasn't great for us. And my kids are pretty trustworthy. My teenagers, my teen girls, girls are a little less worrisome than boys, I think, in a lot of ways when it comes to the internet and internet use. It's just not really. I mean, I know a lot more girls now are getting into the porn and stuff than ever before, but it isn't a natural compulsion for women to be into that. And both of my girls are very, what's the word? I'm looking for the word. Oh, by the way, I'm wearing my t-shirt. Oh, for fuck's sake. This is a great t-shirt. If you want one, they're in the merch store. You should go check them out. There's sweatshirts, t-shirts, all kinds of stuff. All right, let's share this instead. Enchiladas unbreaded. Thanks for the super chat. Says, since Dr. Goodhair told me to. Excellent. We should have him on more often. He's good for business. Okay, here we go. Add to stage. Parental controls reimagined. So I looked up a bunch of articles about which apps are the best for parent safety and kid safety on the internet, and Bark came up as one of the best, or the best, according to almost all of the articles that I read, like in the industry magazines and stuff. Oh yeah, I know, Christy Poo. This is a whole thing. This is a problem. So when I did install the thing on my daughter's phone, because I got her when they get them when they're 12, when they start spending more time out of the house. When I did try and do that, she was really upset with me. She was like, why do you need to do this? Like, what did I do? And I was like, honey, it's not about what you did, because you didn't do anything. It's about what other people do. And about what other people can do. And what if someone is like cyberbullying you or sending you inappropriate text messages and you get scared and you don't tell me, something like that. But yeah, she was really offended. So I kind of understood. So Christy says, if you thought your kids hated your parenting before, wait till you start looking at all their texts and crap. Yeah, it's a hard topic. But anyway, so Bark gives you parental controls on kid devices. You can track location, which I already do through Apple. Apple allows us to track their location. I find that that's a safety issue. My rule is you always have to have that turned on. And if you don't have it turned on, I'm taking your phone. Manage screen time. I can do that on Apple. Monitor content. That's something I cannot do on Apple. Would I use it on my 18-year-old? No, I would not. No, she's 18. She's 18. I mean, it's too late now. I mean, I could. It's my phone. But no, I have not. But then again, my 18-year-old has never given me any reason not to trust her. Never. I've never found her watching anything. In fact, she tells me when one of the other kids might be looking at something they shouldn't be. So she's kind of on top of that too. Like she tells me like, well, and I don't mean they're looking at stuff that they know is bad, like YouTube videos or whatever. My oldest daughter will be like, no, not that one. And she'll just tell them and they listen to her. So she's kind of on my side on that one. And I've just never had to, she shares everything with me. I'm on her Instagram and we share reels and stuff. And, we don't have that issue. Getting alerts 24/7 and also blocking websites. Now, I can block websites through Apple. So the only thing that I can't do is monitor content and get alerts. The other things I can do with Apple. Now, I can set safety like filters on the internet through Apple. So it's on safe search all the time for the kids. And I do have that enabled. There's been a couple of times Yeah, she's my enforcer. That's exactly right. That's true. She would laugh because that's true. But she cares about her siblings and she doesn't want them, she knows kids at school who've gone down scary roads and stuff. But I mean, I think after watching this trial, are we being irresponsible if we don't have these things? I can block websites through Apple. They have that ability where you can block specific websites. For a while, I had YouTube blocked for my son because he was not listening and he was watching things I didn't want him to watch. So I blocked it for like a couple of years. He didn't have access to YouTube. I've just recently given him back access to a couple of channels, but I check constantly to see what the history is to make sure he's actually watching what I asked him to watch. Oh, Red Storm, I just got your tip. I finally just saw it. Thank you so much for the tip on locals. It didn't show up in the chat for some reason. It showed up on a different screen. So I can block certain websites through Apple, and I can set the internet search to safe search. But safe search doesn't necessarily keep them 100% safe. There's definitely still ways around that. Not that I think a 9-year-old would know what those are. And so far, I don't think he's come across anything horrifying. All right, let's see how it works. Bark monitors text, email, YouTube. Yeah, I could use a YouTube monitor. And 30 plus apps and social media platforms for signs of issues like cyberbullying, sexual content, online predators, depression, suicidal ideation, threats of violence, and more. See, now all of these things would have given Ethan Crumbley's parents a heads up. They would have known what he was looking at if they had had something like this. But then again, it's like, well, it's not free. And in today's economy, like, do people have the budget to add yet another monthly bill? With content monitoring, you can get email and text alerts when Bark detects potential issues, so you can talk to your child and make sure everything's okay. It connects to 30 platforms, 30 or more, to monitor text messages, emails, and social activity for signs of harmful interactions and content. Let's see which ones. All right, so I have an iOS device, so let's see. AOL Mail, Comcast, Gmail, Outlook, Yahoo. So it's not letting you read their email. It's got AI scanning all this stuff, and it sends you an alert when it finds something that is concerning. So it's not like you're opening up their email and reading it. Dropbox, Facebook, Flickr, Google Drive, GroupMe, Kik, whatever that is, Instagram, LiveMe, OneDrive, Pinterest, Reddit, Slack, Spotify, Tumblr, Twitter, WhatsApp, YouTube, Discord. Oh, Discord. Oh, it restricts Discord. Wait, what does that mean, restricted? No, they have no coverage of Discord on iOS. And that's a problem. So you can buy a Bark phone. So there's either an app you can put on the device you have, or a phone you can buy through them. Oh, this is interesting. This is good questions we can ask the representative when she comes, when she gets here. What, again?
Phrasing?
These are questions we can ask her. So there's a difference between the app and the Bark phone. So Bark software comes built into a sleek phone along with parent-focused features like app and contact approval. That I can get through Apple. I have app approval, real-time location tracking, and more. So it looks like in order to... TikTok doesn't allow monitoring. Does that surprise anyone? TikTok is a Chinese spy app that is geared intentionally to harm children, in my opinion. Skype can't do on iOS, and Snapchat. Ooh, they don't allow it either. Snapchat doesn't allow any service to monitor its content. That's, you know what? That's negligent, Snapchat. Do you know how many horror stories I've heard about Snapchat? I have heard so many horror stories about Snapchat. It is negligent that they don't allow these apps to monitor for parents. Do you see how the technology, the companies fight us? They fight us. They don't want us to be able to do this. Yeah, TikTok monitors you. Why can't we monitor them? This really bothers me. Of all the things, how dare they say we can't monitor what's going on their app when kids are sending literal CP through Snapchat, committing felonies, and they're saying parents can't. How are we supposed to keep our kids from doing this shit if we're not allowed to monitor it? So Snapchat, TikTok, Discord, add those to the list of apps your children should never have. Because any company that does not allow a third-party app to monitor it for child safety should not be given money. You should not be giving your money to or business to them at all. Did I miss your gifted 5 memberships? Thank you. I don't know if I missed it or not, but thank you for those gifted 5 memberships. I appreciate that. This is, yeah, the whole purpose of Snapchat is to delete the evidence. But you know what? Kids aren't supposed to be. If we are going to be held responsible for all these things that these kids can get into these days, then these companies have no business keeping us from being able to monitor them. I know we missed this today. They were just in front of Congress. They asked if they were aware they were used for sexting, and they started to reply with, "We originally named it Peekaboo, not helping your case." Oh my gosh. Let's see. I think somebody was trying to tell me. Oh yeah, I have some clips of this. So maybe we can play some clips. Of Josh. Apparently Josh Hawley gave a very good grilling. Let's see. Josh Hawley. So this happened, I guess, today. Oh, these assholes. Just what I want to ruin my day. Watching elected officials.
Turn over to you. Thank you, Mr. Chairman. Mr. Zuckerberg, let me start with you. Did I hear you say in your opening statement that there's no link between mental health and social media use?
Senator, what I said is I think it's important to look at the science. I know people widely talk about this as if that is something that's already been proven. And I think that the bulk of the scientific evidence does not support that.
Well, really, let me just remind you of some of the science from your own company. Instagram studied the effect of your platform on teenagers. Let me just read you some quotes from the Wall Street Journal's report on this. Company researchers found that Instagram is harmful for a sizable percentage of teenagers, most notably teenage girls. Here's a quote from your own study. Quote, "We make body image issues worse for 1 in 3 teen girls." Here's another quote. "Teens blamed Instagram," this is your study, "for increases in the rate of anxiety and depression. This reaction was unprompted and consistent across all groups." That's your study.
Senator, we try to understand the feedback and how people feel about the services we can improve.
Wait a minute, your own study says that you make life worse for 1 in 3 teenage girls. You increase anxiety and depression. That's what it says. And you're here testifying to us in public that there's no link. You've been doing this for years. For years, you've been coming in public and testifying under oath that there's absolutely no link. Your product is wonderful. The science is nascent, full speed ahead, while internally, you know full well your product is a disaster for teenagers.
Senator,
and yet
that's
you
not
keep
true.
right on doing what you're doing.
Yeah,
right?
That's not true. That's not true.
Let me show you some other facts I know that you're familiar with. Wait a minute. That's not a question. That's not a question. Those are facts.
Nobody asked you a
Mr.
question.
Zuckerberg.
Shut
That's
up.
not a question.
Those aren't facts.
Let me show you some more facts.
Sit down.
Here's some information from a whistleblower who came before the Senate and testified under oath in public. He worked for you. It's a senior executive. Here's what he showed he found when he studied your products. So, for example, this is girls between the ages of 13 and 15 years old. 37% of them reported that they had been exposed to nudity on the platform unwanted in the last 7 days. 24% said that they had experienced unwanted sexual advances. They've been propositioned in the last 7 days. 17% said they had encountered self-harm content pushed at them in the last 7 days. Now, I know you're familiar with these stats because he sent you an email where he lined it all out. I mean, we've got a copy of it right here. My question is, who did you fire for this?
Oh,
Who got fired because of that?
let me guess.
Senator, we study all this
Nobody.
because it's important and we want to improve our services.
Well, you just told
And
me
I
a
think
second
that
ago
the-
you studied it, that there was no linkage. Who did you
Senator,
fire?
Yeah, I said you mischaracterized.
37% of teenage girls between 13 and 15 were exposed to unwanted nudity in a week on
Disgusting.
Instagram. You knew about it. Who did you fire?
Senator, this is why we're building all.
Who
these
did you
different
fire?
Tools. Senator, I don't think that's.
Who did you fire?
I'm not going to answer that. That's.
Because you
I mean,
didn't
this is-
fire anybody.
right? You didn't take any
Senator,
significant.
No, he didn't. He didn't fire anybody. And coming to the program now from Bark is Tatiana Jordan. Tatiana, thank you so much for being here. I appreciate you.
Yeah, thank you for having me and thank you for covering this.
Yeah, I'm very concerned. I'm a parent. I've got 2 teenagers and a 9-year-old son. My girls, I've got an 18-year-old and a 14-year-old. My girls are okay. They've managed to get through it this far without any major problems. But I'm very concerned about my son. I'm very concerned about this stuff. And I'm watching this. We're watching this trial, right? Where Ethan Crumbley's mother, Jennifer Crumbley, is on trial now and it's very scary for parents. She's being charged criminally, can go to prison for the deaths of 4 children that her son killed because she missed the signs. She didn't see them. She didn't know that he was on these gore websites. He was sending texts about shooting up the school to friends that she didn't hear about. What do we do, Tatiana? What do we do?
It's so hard. It is so hard. But the bottom line is that you cannot give your children unmonitored, unfiltered access to the internet, whether that's through smart TVs in the home or smartphones or gaming consoles, or even through devices that their school gives them to bring home and do schoolwork. It is our job as parents to keep our kids safe, not only in real life with seatbelts and sunscreen, but also online. And so not only should you use the filters and screen time controls that come built in free to a lot of the tech that you have in your home, but that's why we exist as a company at Bark, is to help find those exact points of danger with our algorithm and then surface them directly to parents, so that if your child is encountering that sort of problematic, graphic, disturbing content, you can get alert ahead of time before it escalates to a tragedy.
Yeah, I was thinking about this. Like, I feel like I'm on top of these things with my kids because I'm always in their face about everything and asking them what they're seeing and asking them what they're looking at. But the truth is that I'm not taking their phones on a regular basis. I don't go through their text messages because it feels like an invasion of privacy.
Right.
And they haven't given me any reason to suspect they've done anything wrong. So a part of me is like, oh, do I really want to go there with teenagers who are already there's
Friction.
a friction. Yes. Right. I mean, I've always been a proponent of, well, look, we need to work on our relationship and make sure that we are in a good place where they feel like they can talk to me and we talk about stuff all the time. But there's something about that let me see your phone thing that is really, and I've done it a couple of times, but it's really upsetting to them and it's upsetting to me too. So I was just explaining to the audience before you came here, I was looking at the Bark website and kind of what you guys do. And it seems like it doesn't really, I'm not reading their email and I'm not reading their text messages. It looks like there's an AI kind of scrolling through tell me how it works.
Yeah, thank you for highlighting that because it is a unique situation that we're all in as parents, parenting in a time that has never existed, at least with humans living on this planet, right? So there is that balance and that friction of we want you to become a responsible digital native, but we also know that there's bad things out there. So the intentionality behind Bark is that we don't think parents need to be picking up their kids' devices and looking through everything, not only because it incites friction, it's also incredibly time consuming and also incredibly ineffective because a lot of times you as the parent don't even know where to look. You might not know how to find the hidden folders and the
Right.
vault apps and the, all of those things. So our artificial intelligence analyzes the content and context of all of the connected pieces of accounts and connected tech that you have. And then when it finds a danger, it will send you a snippet. So, for example, if my son is either being bullied or bullying someone in a text thread, it's not going to send me the entire text thread to read the novel of what kids are saying. It is going to send me maybe one or two blurbs from that text thread specifically highlighting what was said that indicated cyberbullying or hate speech or violence or threat. And so then you can take that snippet of knowledge and say, hey, I cannot see everything. Bark doesn't allow me to see everything, but I see that this is a problem. And it's important for the parent to remain calm, right? Although it's very hard to remain calm, but remain calm and try to address it as calmly as you can because good kids make bad choices. And I'm right there with you. I have a 15-year-old. It is not easy.
It's really not. It's not easy, and it's a really difficult balance, right? I feel like I've gotten lucky with my 18-year-old. She's made it through to adulthood, and she, like I was telling the chat earlier, she's my enforcer. She tells me when the other ones are getting into something they shouldn't be, and so I feel like I have a lot of trust with her, and I never had to do this. But when I saw this trial and I'm seeing all these things that she missed, it really strikes fear into my heart. Like, what if I miss something? What if, and it is my responsibility. But then there's another part of me. I'm watching this thing with Facebook and Mark Zuckerberg and our leaders. They know this is a problem. The companies know this is a problem. And I go on Bark and I'm looking at all the different apps you guys can monitor. And what do I find? TikTok, Snapchat, and Discord, the three worst ones, don't allow you to monitor what's going on their apps. That to me is criminal. And that's what they should be talking about at the Senate right now, is hauling them into it to say, you have no right to do this, to keep this information from parents of minors who are using your apps. Discord is one of the worst places on the internet.
There's so much to unpack there. Yes, with iOS devices, those three platforms don't voluntarily give Bark API access to analyze the content. Thankfully, with the Bark phone, which is an Android phone, we can have a lot more monitoring, including full monitoring of Snapchat and some other entities. So that's helpful. But yes, something that was really telling from the hearings last week was that only 2 of the 5 CEOs appeared voluntarily. 3 of them had to be subpoenaed, and those 3 were Evan Spiegel of Snapchat and Jason Citron, CEO of Discord, and then Linda Yaccarino of X, formerly Twitter. That's a really bad look when you're being called to testify around child online safety.
It is a bad look, and I'm surprised that Twitter didn't come voluntarily, especially because Elon Musk said his very first priority was going to be child safety. So why didn't he send Linda there voluntarily? That's upsetting.
It is just the tip of the upsetting iceberg. I mean, again, there are 4 hours and I think 4 minutes of so many moments where you're just like, how is this possible? And did anybody is anybody else hearing this and seeing this? What world are we living in? Ridiculous.
Because on one hand, they want to tell us, I mean, I'm a big proponent of free speech and no censorship, okay, for adults.
Yeah.
We're talking about our children who we are now going to be criminally responsible for. If I'm going to be criminally held liable for what is happening on my child's phone, then you better give me the tools to monitor it properly. You better not stand in my way, because if the government isn't holding me responsible, well, I better be able to do it then. And I've already had problems trying to use some of these things where I don't remember which program it was because it was a while ago, but I tried to install it on my daughter's phone and it messed up everything and she couldn't use anything. And it was very upsetting, and I couldn't get tech support to help me, and I had to just delete the whole thing and just use Apple's tools. We're an Apple family, and I see that Apple, I guess maybe, I don't know what their issue is, that they don't allow a lot of this stuff, but Apple's safety tools are okay, but they don't give me what I really want, and what I really want is to be able to see YouTube history. That's what I really want.
Well, you know, that's actually a Google problem. Excuse me, I'm gonna take a quick sip of water because
No,
I'm
you're
getting over something. It's like the cold that won't go away for like a month.
Everybody is having this now.
Yes.
Everybody. In fact, Dr. Joe Corcoran, who was just here before you, same thing. He texted me this morning. He said, "I'm still coughing stuff up. It's been like 2 months. It's insane." So, gosh, no worries. Take whatever breaks you need. I can fill in the holes. Don't worry.
But, you know, Apple's controls have a known bug that has existed for over a year. The Wall Street Journal reported on it.
Oh, you're okay. It's all right. It's poor thing. This is so bad. It's going around. And my little one just got diagnosed with strep today. So
Oh,
yay me. Yay me.
yeah.
He's home for at least 2 days. It's
It's
terrible.
yeah. I'm not a fan of winter. Just
Yeah, right.
give me the spring, the summer, the fall. Not a fan of the winter. But anyway, yeah, so Apple makes it hard for third-party platforms and parents to do their job, but doesn't have adequate existing built-in parental controls. Not to mention that every time they release a new feature, a new iOS update, there comes really cool new things for adults who need privacy, but problematic things for children who don't need full privacy yet. So that's
Right.
Apple. Google's a whole nother bag. Google thinks that at age 13, your child is now an adult and can manage their own, digital life. Another
What?
problem. Yeah, I mean, and when you look at the terms for Google
That's
Family
insane.
Link, it's completely ridiculous. It's just, I'm honestly so angry. I'm so angry that I didn't either have a child 10 years before I did
Right.
or 10 years after, because this specific time in human history, these children are going to be the most negatively impacted by tech. And it's so sad.
Because we can't get them to do their job. We can't get them to protect kids at all. And I understand. I do understand the freedom of speech issues and concerns.
Yeah.
But children have never had those rights until they reach the age of maturity. They literally don't have constitutional rights for the most part. Children don't, especially when you're holding their parents criminally responsible for their actions online or their actions in the real world. They don't have these things yet. So if the government is going to come down on these parents like the Crumbleys, who admittedly are not great parents, they're very absent parents. They were not paying attention.
Ugh.
But if they can come down on them, who's to say they can't come down on us, even if we are paying attention? And these companies are not helping us. I'm wondering if there's a way I believe that the government should just be telling these companies, you have to partner with safety, child safety. Like, I think it should come with the internet. If I buy the internet, I don't want to buy the violence and the porn I don't want to buy that. I want to buy this particular thing here and this particular thing there. And if I say I don't want this in my house, I don't think they should give it to me.
Yeah, it
But
should
it's like they're
arrive safe.
forcing it on me.
Yeah, no, cars don't arrive without seatbelts anymore.
Right.
The internet shouldn't arrive without built-in filters and parental controls. Give adults the ability to unlock and access whatever mature, extreme content they
Right.
want to, but at least let it arrive safe, whether it's a smartphone, the internet, a smart television, a watch, whatever. It's ludicrous that this is where we are right now. And we have to continue to raise awareness and advocate for our children's physical and mental health.
And we're paying these internet companies huge amounts of money, right?
Oh,
Very
yeah.
large amounts of money for this service that they're giving us, while they are refusing to actually stop the dangerous content that's coming into my house. And I feel like that's a problem, because then I have to go and spend more money on a service like Bark, which is, it's not that bad, but it's still another monthly or yearly fee that now I feel like that should have been their responsibility in the first place, and now it's on me to do it. I don't get it.
Yeah, I mean, there's a lot to unpack in terms of what doesn't make sense currently with our current environment. But you mentioned something about parents should have the right to be able to utilize technology that exists currently, and it should be a law. And there's actually a proposed bill called Sammy's Law, that's in honor of Sammy Chapman, a boy who died because of a pill he purchased off Snapchat. It was delivered to his home just like a
Oh
pizza,
God.
and it had fentanyl in it.
Oh my God.
Yeah, and so if anybody wants to do anything, you should Google Sammy's Law or just go to sammyslaw.org and sign the petition, and make sure that your local legislator knows that this is the way. This is the way to give parents the digital right to do their job. And I'm dropping a link here in our private chat.
Because it does seem like it's so difficult to do the thing. Like, I went on Apple. I'm trying, because my son has a iPad, right? And I'm trying to set up all the parental controls. And it is not easy. It is difficult.
It's very nuanced, yeah.
And also, it doesn't do all the things that you really need it to do. You can turn on a safe search. Okay, fine. But you can get around a safe search. I mean, I've tested it myself. There are actual websites that put porn under Disney names so that
Ugh.
children so that they will accidentally encounter it. How sick is that? So that would get right past the safe search. And your poor 8-year-old, just goes to look up Aladdin or whatever and finds porn. It's not okay. Here's the so this bill looks like, hold on, let me put this up here. Add to stage. So this is Sammy Chapman, and this is the bill that they want, that they are trying to get passed. Is this a federal or a certain state?
I believe, and I'm not a legal expert in any way, shape, or form, so don't quote me, but I believe the efforts are at the state level currently, but hopefully rolling up to become federal.
It looks like they want you to ask Congress, so that would mean they're looking toward federal, because it doesn't say the name of a state here, and and you can be anybody who can sign this. Now, guys, I haven't read the language of this bill. It might be problematic in some areas, and we'd have to read through it to make sure. One of the things, though, that I did see that I thought was a good idea was the ability to, alerting parents. I mean, if it's for minors and you're alerting them to what your minor is doing, but I know that a lot of people would have privacy concerns with that. They don't want their internet service provider monitoring their activity online, which I kind of understand.
Totally
But
get
couldn't you opt in?
That's what this is about, is give parents the option. You don't have to opt into it, but you should at least have the option.
Right. So Bark, it looks like to me, I was looking up all the reason I called you guys was because in all the tech magazines that I was reading, Bark comes up as being like the #1 monitoring app that's out there. I think one of the things I like about it the most is that you're not just reading their text messages and invading their privacy. You're not going to be reading about their crush, and you're not going to be, because that feels like, it just feels invasive. It feels like picking up a diary, and I don't want to do that unless I absolutely have to.
It's
Because
heavy-handed.
I want my kids to think I trust them and know that, I'm on their side, not that I'm breathing down their neck and being their jail guard,
Exactly. Like, there are definitely some parents out there that opt for technology that mirrors everything or logs every keystroke. And I'm here to tell you that that is not going to build a healthy long-term relationship with your child. Now, as a parent, you've got to do what you've got to do to make sure your child is healthy. And we know kids don't always or often tell us things, but there's a balance. And that's where I think Bark does well. And that's why we are rated so highly, because we are looking for the dangers that any child arguably would say, you know what, you're right. My parent probably should know about that. I don't love it, but they should probably know about that. Um,
Right.
so but it is a balance. It is absolutely a balance.
McCrae, thanks for the super chat and the question. This is a great question. My kid used to have a secret Instagram account. She said she deleted it, but I have no idea how to know. But she's 17, so I guess there's nothing I can do.
Interesting. So with Bark, you can connect your children's devices and accounts up until they're 18. So it's not too late at 17. It's close, but it's not too late. And also, our algorithm is really good at picking up on secondary and tertiary accounts, because when you go to create an account, there's a push notification, an email, a text, etc., and our algorithm can detect that and say, hey, it looks like your child has created another Instagram account. Time to talk to them about that. Now, if she's already deleted it, and there's no record of it, then hopefully it's gone, and that's RIP Instagram account. But it's a game of whack-a-mole. There's always something, right? Always something to manage and monitor. And at the end of the day, it comes down to your relationship with your child. Do they know that they can come to you without fear or retribution with any hard thing, and know that you love them unconditionally? And even if you don't agree with what they did, and even though there might be consequences, you will navigate it together. That's the most important thing.
Yeah, and I also think in the Crumbley case, I think Ethan Crumbley was desperately trying to get his parents' attention, and they never, for whatever reason, didn't give it to him. And I think that had they paid more attention to him, they would have seen the red flags. They would not have missed them. I personally don't think that she is criminally negligent in this case, because I don't think she knew. You have to prove that she knew these things were going on, and the evidence shows me she didn't know. She was totally, and that's what got me thinking about this. I'm like, well, how do we make sure that we do know? How do we make sure that we don't miss something? Ronan's got a good question. Not trying to sound negative, just curious. Is Bark's algorithm open for scrutiny, or is it kept secret? Understandable if it's proprietary, etc.
That's a really interesting question. It depends what you mean by open for scrutiny. It's something that our data scientists built internally, so it's not like we're not just like tapping into OpenAI's ChatGPT to help us analyze children's accounts. That wouldn't be secure, and it's just not ideal. So we have our own proprietary algorithm that's based off of years of data points, understanding the very intricate nuances of how children speak. And so, and we're always open to how it can be better. In fact, with every Bark alert that is sent at the bottom, there's a very direct question that says, was this helpful? And if you say no, it helps to train our algorithm to make sure we are as accurate and helpful as possible. We want your feedback, because we certainly don't want to be alerting you to things that you don't need to know about. And we definitely want to make sure we catch all the things that are problematic.
Yeah, this is really interesting, and I think could be very helpful for people, because it's not really an option to take all devices away from your kids. It's really not. It's not an option. They use them in school for their schoolwork. They use them in, to socialize now. Hardly anybody. We live out in the middle of rural New York, in the middle of nowhere. We don't have close neighbors that the kids can go out and play with. If
Ugh.
there's and that's unfortunate, but that's just the way. And even when you do live in a close neighborhood where houses are close by, the kids are not outside. I lived in a neighborhood like that. They don't go out and just play with one another. So it's like, if your kids don't have any tech, well, then they don't like, they're not involved, and they don't get invited to things, and they don't have a social group. So it's very hard to know what to do. So I see here you can block certain websites, you can block apps. One of the most handy things that Apple allows me to do that I've noticed that I like is the being able to approve the apps when my kids
Yes.
ask for them.
Yeah.
I think that that's a really good thing, because then I can look into the app and see if it's appropriate or not, and I can say yes or no. And I just like to know what it is they're spending their time on.
That's a very important aspect of digital parenting, is making sure you have app approval enabled, whether your children have iPhones or Android phones. If you have the Bark phone, that's automatic. The parent has to either approve or deny access to all the apps. But that's a critical window into what are they interested in? Is this appropriate? What do I need to talk to them about? How can I explain to them why it's rated, 17 plus and not good for a 12-year-old?
I know, I can't believe some of these apps too. I see the commercials for them when I'm playing my stupid games, and I think, what is this nonsense? Like, why would you be advertising this to kids that are playing? Like, I play kid games. I play like time management games a lot, or sorting games, and they're like an all ages kind of game. And yet on an all ages game, they're showing me advertisements for 17 plus apps,
Oh,
which
yeah.
that bothers me too. It's like, I don't want my kids to see those ads.
Yeah, I mean, unfortunately, there's no regulatory body for App Store ratings and the
Mhm.
in-app content that comes about in apps that are free, right? The ad networks, etc. It really is the wild, wild west. It's the WWW, the World Wide Web, wild, wild west.
Yeah, and that's scary. It's scary. So you guys need to get over to Bark. Go to www.bark.us, and you can find out more about their service. And there are a lot of different services, but this one just kept coming up over and over again as number one. And I did notice when I looked at the features, it just has more features than most monitoring apps. Also, what is tech support like? How easy or difficult is it to get a hold of somebody, like if something like what happened to me happens, where all of a sudden this thing you downloaded on your phone is now locking up everything, and you can't get it to work properly? Is there a way to contact somebody?
There absolutely is. We have an amazing customer support team. So essentially, you would either just go to our contact us page or go into your Parent Bark app and go to the contact button or the support button, and you'd get connected with a support agent. And we have a variety of ways that we collaborate with customers, whether it's email, chat bot, phone call, Zoom meeting to screen share and troubleshoot. It's well, we want to make sure that your family is set up for success. So we definitely have a bunch of levels of support.
This is a great comment. Bark is like the Swiss Army knife of my parenting toolbox. That's a good comment.
I love that. And those are all real, by the way. Like, I know sometimes you go to websites and you're like, okay, there's no way that those are real testimonials. Like, I have the spreadsheet and the timestamp of like where it came from. Like, these are real parents that have given us this feedback, and I'm so thankful for them.
Yeah, I think when we're talking about the mental health of our kids, and we know for a fact that when they spend time on social media apps, TikTok in particular, I hate TikTok. Please delete TikTok from your phones. Please do it now. Do not pass go. Just delete TikTok. But kids are actually led down these algorithms on purpose, down these dark holes, and it is affecting their mental health. It is not disputable, despite what Mark Zuckerberg wants you to believe.
Mm.
These social media apps are negatively impacting our kids. And there's no way to stop it from happening if they have the app on their phone, unless you know what they're looking at and you can talk to them about it. If you start to see, I feel like Bark gives you the opportunity to see if they're starting to get into some topic like eating disorders, for instance, right? You get some kind of notice that would say, your kid looked up eating cotton balls to stay thin or something, so that you could
Oh.
have that conversation.
Yeah, that's another critical part of our strategy to help families is early intervention is key. It is so much better than, you know, traumatic events and rehabilitation. Like there's if you can catch things early, there's a much stronger likelihood for a better outcome. Um, and unfortunately, so many parents just don't realize there's a problem until a tragedy has occurred or their child is
Like
really, really
this one.
struggling. Yeah.
And it's really horrific because if somebody had just asked more questions or had something like this on his phone, they would have known. There's no way what he was looking up on that phone would have sent off red flags at any software monitoring system like you wouldn't believe. Gore, violence, all of that stuff wouldn't get past the algorithm there, I don't think.
No, I mean our tech has successfully thwarted potential school shooting and bombing threats. Like we have heard back from law enforcement saying your tech saved lives. Your tech prevented this from becoming, you know, a mass massacre. So it's chilling when we hear that, and it's heartbreaking when we know that children in other instances uh, had very strong digital warning signs that something was about to happen and their parents were not using Bark. It's
Okay, so this is a good question because I saw it come up a couple of times.
Yeah.
It says, but do you get a notification if they say they're over 18? Kids lie all the time when they set up,
Interesting.
when they set up an
Yes.
app.
Yeah, that's a great question. I need to go back to our data science team because we have a lot of categories that we alert parents to, but I don't know if lying about your age is one of them. Now, I will say that if, let's say there's a text conversation between a child and an adult, and the adult's like, "How old are you?" And the child's like, "I'm 18." You know, that I think would probably fall under our predatory conversation warning.
Mhm.
But the specific act of signing up for an app and lying to the app about your year of birth, that might not trigger a bark alert, but you know what? After today, after my talk with our engineering team, we might roll that out.
Oh, look, see chat, you're solving problems all over the place.
Yeah.
This is how it gets done,
Yeah.
talking to parents is a great thing to do because my chat is so smart. They always have really good things to say and like trying to poke holes and stuff. So
Yeah.
you'll have to
Thank
let me
you.
know. You'll have to let me know later if what you find out for that. Grifter Wannabe says, and thank you for the super chat. Does Bark turn over data to law enforcement without a warrant? Do they notify you if they are given a warrant, especially if the parent can be liable? That's a good question.
That's a great question. I honestly have no idea because I am not, you know, if there is an emergency alert, I am not the one that makes that call to law enforcement, nor am I, you know, in our legal department. If like I literally don't want to blow smoke, like could not tell you the right answer to that,
Sure.
but I'm happy to find it out if I'm able to
Yeah,
disclose it.
that would
I
be
mean,
great. I would think that they need a subpoena. I mean, my limited understanding of how it works is that they would most likely need a subpoena from a judge. Would they have to notify parents? That I don't know. I don't that maybe not. If they got a subpoena from if a judge issued a warrant, I would imagine that the answer is no, they wouldn't give it out without a warrant. But if they did get a warrant, they'd have to comply with that warrant. Um, and I don't know. But if Titania, if you could find that out, that would be great. We
yeah, I
would
mean,
love
we've
to
been
know
in
that.
business. Yeah, we've been in business since July of 2015 and have the most stringent level of security and practices. So we will not be operating like willy nilly. You know, like we're compliant. And at the end of the day, you know, a lot of tech companies think that they own your data, and at Bark, we believe you own your data. We have a responsibility to you to analyze your data for safety concerns because you've trusted us to do so, but it belongs to you, and you do with it what you feel you need to because it's yours. So, um, yeah, a lot to unpack there, but I'm sorry I don't have the answer to that question yet.
Well, that's okay. I'd love to have you back on sometime because this trial may continue for another couple days. So, perhaps you can come back and, with some answers to those, and that would be great, because we do have a lot of parents in the chat. We have a lot of parents in the audience who are really concerned about this case in particular and what it means for the rest of us. We need
Absolutely.
to
I mean,
know.
think about it. I'm sorry. I just toggled over to the comments. Willy Nilly, the lip singer. Oh my gosh. Y'all are funny. But like, think about back in the day. If you were, I don't know how old you are, but I'm 43, and there were high school parties where children would drink, and if they got caught by police, their parents could be put in jail. In fact, I have friends whose parents were in jail because of a house party. The parents were asleep. They didn't even know their kids were there because they were quiet. So it's like, it evolves, right? It evolves.
Yeah,
And
that's
it isn't.
true. You can be held liable for your kids for underage drinking if it's happening on your property. That's absolutely true.
Yeah.
Here's another good one. How does the psychiatrist link work? Is it a pre-recorded message? Do you talk to someone live? That I didn't even see on here. What are we looking at?
Yeah, so we don't have a live link to a psychiatrist and app. We do offer real-time recommendations for what to do next, talking points, hotlines, websites, that sort of thing. In some cases, we did partner with Talkspace Therapy to offer people a discount if their child needs to talk to a virtual therapist. So not a live link to a psychiatrist and app, but it's a wonderful idea. It's certainly needed in that moment of crisis. So again, your viewers are giving us some really great product feedback.
Yeah, they really do. They're very good. You could use them to bounce ideas off of anytime. They're very good at coming up with these questions, mostly because almost everybody here is a parent and has faced these issues. And we know parents we're terrified. We're just terrified today. This is no way to live. I sometimes wish I was Amish because I feel like we would not have these problems if we were just raising barns and, dealing with chickens all day.
Yeah, and puzzles and books. Puzzles, books, dolls made out of corn husks.
Yes. Yes.
Hey, I'm with you. Let's
do.
go back.
Let's go back. Everybody pack up. We're going back because this is just too hard. It's too hard. Thank you so much for being here, Titania. I appreciate you. And please do bring our questions back to Bark. And if you have any answers for me, let me know. And you're welcome to come back on any time and talk to the chat. We would love that.
Awesome. Well, thank you for having me. Thank you all for watching and listening. And I pray that your children stay safe and you have the wisdom and knowledge in order to do so.
Thank you so much. Take care.
You too. Bye-bye.
What a sweetheart. I love that. And I think that we should maybe just all take a look at whether it's Bark or something else, something that you feel is better for your family. I think we need to take a look at it and see if we can start to implement some of these things, because the more I read about the Ethan Crumbley case, the more I felt like this was all avoidable. It was totally avoidable. And we need to protect our kids. First and foremost, we need to protect our kids. We also need to protect ourselves from an overreaching state. And we do have a duty. We have a moral duty and a legal obligation to control the children in our household. So let's make sure that we're doing the best job that we possibly can on that. I may talk to Titania about testing out the product, because I think I might want to try putting it on Hangry's iPad. I think I'll start out with him, and I'm gonna talk to her about testing it out perhaps and see how it goes, and maybe I can report back to you guys and see if it makes my job any easier as a parent to see how it works. So I'll have that conversation and we'll see what happens there. Maybe I can get a promo code and get you guys a discount. I'll ask her. I'll ask. But I think that this is something we need to seriously consider. I've been putting it off. I mean, I have known for a long time, I feel like it's the right thing to do to have a monitoring software of some kind. And I have but I've been putting it off and putting it off. And now I have 2 almost grown children and a 9-year-old. So that has access to stuff. So why am I putting this off? Okay. I thought court was coming back soon because I saw the camera move, but apparently they are not. It is now 4:11. I'm starving to death. I've eaten nothing all day. Oh, I also forgot to take my pill. That's weird. Oh, wait, did I? Gosh, I hate it when I can't remember if I took my stuff or not. All right. I think this is what we're going to do. I need a break. It's been a very long day. It's been 7.5 hours. So I think what we're going to do is I am going to end the stream. See, people keep walking past the camera and I think they're coming back. And then I get all excited and then nothing happens. Should I just leave the stream going? I'm going to leave the stream going. I'm going to take a break. If court comes back, court's going to come back at some point to tell us whether or not they are staying for the day or they have a verdict. So what would the chat like me to do? Do you want me to leave you with hold music or would you like it to be silent? Because I need to go and take a break. I have some things I need to do. I need to get dinner started. I need to get some laundry done. But I think I'll just leave it live and I can come back and check on you and check on the court stream. You want it silent. Okay. All right. Sounds good. So I will monitor on my phone. No hold music. Everyone's like, don't you dare put hold music on. Judge is a strict 5 p.m., but this may be different. Joe isn't live until 6. I know. That's why I'm going to keep it going. But I need to take a break. So if you guys want to hop off and go do other things, that's fine. I'm just going to leave the stream going. I am going to change the banner so that you guys know where I am. Megan is making dinner and doing laundry. We'll be back when court resumes. Stay tuned. All right. So you guys know why I will be absent. I'm just going to turn off the camera and leave you guys to it. And I will be back when court comes back. Sound good? All right. All right. Do your squats. It's time to do squats again. And after squats, there will be silence. And I'm going to go do my stuff. And maybe I'll chat with you in the chat some too when I'm able to. All right. Where's my thing? Where's the squats? There you are.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile? Do squats! Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair. Get off the couch. No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit.
I've decided to turn the ruckus cam back on because he's prancing around with his treat ball. He keeps on facing away from the camera, doesn't he? I give him the treat ball, and he turns his back to the camera. Dang it, Archie. Archie Ruckus. wants to face the wall. I don't know what happened. Hold on. I need to switch this.
I'll tell you what happened. My son happened.
Oh.
We just got back from the pediatric dentist, and he was sitting with me and started pushing buttons and picking up my mouse, and I'm like, dang it, now you're messing with all the layouts and whatnot, dude. Like, I'm trying to fix it when he's pushing buttons again, and I'm like, no, you're getting down.
All right, how did I have it set? No. Now I can't make it work.
Yeah, I'm trying to figure out, because it
What
said it was like
happened?
1, 2, 3.
Oh, when you came in, you replaced camera 2. That's what happened. Okay, I know what happened. So now I'm fixing it to make the doggo cam bigger and you smaller. There we go. All right. Wait, where are you now? Where'd you go? Brad?
There.
There you are. Okay. I don't know what's happening right now, but I'm going to eat my lunch. See you later.
Yep.
Your Honor, calling People versus Jennifer Crumbley, case number 2297990FH.
Thank you, Marquise, on behalf of people.
Thank you, Shannon Smith, on behalf of Jennifer Crumbley, who sits to my left.
All right, we made contact with the jury, so they want to stay till 4:45, and they probably want to come back tomorrow. But unless there's an objection, I might release two of the other 5 sequestered jurors and tell them that they're sequestered at their home. Do you object to that?
Not at all.
No.
No objection.
And then puzzles and Sudoku and that they're probably losing their minds. So I was going to release 2 or 3 and have them go about their business, but they would still be sequestered. So they would still be subject to sequestration of the court and not be permitted to be spoken to by anyone, right? Okay. All right. Any preference, 2, 3?
If that's so reliable, Your Honor, I'd say 3. Can we approach her?
Sure.
What's happening? I'm just waiting to hear what's happening. I can barely hear the audio. Brad, are you there? Brad? Is the audio cranked all the way up, Brad? It was on a second ago, now it's off. Yeah, I think if we do not have a verdict today, it's good news for the defendant. I don't think they're leaving. Well, it's 4:30. They only have a half hour before court's usually closed. Here we go.
Good afternoon, you may be seated. I know you guys have all had an exciting day. You've completed puzzles, done Sudoku. I heard one of you was sleeping on the floor. I won't name names or offend any of you. I'm so sorry. Hopefully you realize the reason behind it. Okay, so here, the 12 of you have not come to a verdict yet, so they're going to be returning tomorrow.
No verdict.
What happens, and in the event that one of those jurors was indisposed, we would need one of you to fill in for them, and they would be instructed to start deliberations all the way over again. So that's the reason for it. That being said, I'm going to dismiss 3 of you by blind draw today. Actually, I shouldn't use the word dismiss. I'm going to have 3 of you not return tomorrow, but you're still sequestered. Understand what I'm saying? So some of these people sitting out here would love to talk to you, but they are not allowed to talk to you when you're not allowed to talk to them. And it's the same as every day when you leave here, you're still sequestered. I just think that you would prefer to be doing your laundry or going to work or doing whatever it is, but I still have to trust you to not discuss the case. All right? Are there any questions about that? but I'm gonna have two of you come back. I think you've already ordered your lunch, so I'm hoping the three of you ordered something you like. No? No. Yeah.
My question is, if we're one of the three that go home and spend the day at home tomorrow, how do you know will you call us as soon and let us know it's due the following day?
Absolutely. I feel bad enough that I feel like I kidnapped you. Okay, so I feel bad enough that you're here. I know that you know why. Okay, because you know, when this is all over, I'll tell you stories about strange things that happen and jurors and, you know, just life happens. So, as you know, this is a very long, emotional and frankly expensive process. To start over would be devastating for everyone in the room. So, I appreciate you. I feel bad, but I would feel worse if we didn't have enough jurors to finish deliberations. Okay, so three of you, I'm going to pick three numbers by blind draw, and then you can exit, and they're going to take you down to your car. And we have your phone numbers. You are still sequestered, all of you, and the other two have to return back in the morning. Okay. And I'm going to tell you again that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. So do not go on social media, don't post anything, don't go on Facebook, don't do research, don't discuss the case with anyone, whether you're at home or at work or here spending the day with me again. All right. So I'm going to pick three of you by blind draw. The other two have to return at 9 o'clock in the morning. Right.
At least we're not starting at 8:30. That was brutal. Starting at 9 a.m. tomorrow, folks. Sending three of them home. I don't know what's the deal with the sending the three home. Why doesn't she just send everybody home? I don't really understand what's going on right now.
17. You can be sequestered at home.
So they can sequester at home. Why not all of them sequester at home? They're just alternates.
And juror, let's see, 10. 10. You can be sequestered at home. All right. You can bring things with you. You're 9 and 15. Jurors can see 9 and 15. I mean, obviously you can't bring a newspaper or something like that. You still can't research the case. But if you have work, you can finish my crocheting for me. If you know how to crochet, you know, anything like that. I know it has to be really boring, but I think you understand the purpose. You can't talk to anybody. Again, a lot of people here would love to talk to you, but none of you are allowed to talk to the press or discuss the case with anyone. All right? And we do have your phone numbers. So I'm going to release you to go back to Judge Anderson's jury room, and then you're going to be escorted out of the building, and then the two remaining jurors, if you could come here at 9 o'clock tomorrow morning. All right? Any questions about that? Okay. We appreciate you. Thank you for understanding.
All rise for the jury.
Okay, now I'm going to read another jury, and if you can, I'll be seated.
She's letting them go at 4:45 because they have indicated to her that they aren't going to be done today. They must be far enough away from a verdict and from agreeing that they know darn well it ain't happening tonight. Perhaps they want to go home and change into nicer looking clothes before it's over. Perhaps one of them will put on a bow tie. We don't have anyone in the courtroom, so we don't know. Oh yeah, it's even earlier there. Where is this again? Michigan. No, Michigan's on Eastern Standard Time. Same time. I know it's hard. It's difficult because Illinois is right next to Michigan and it's on Central, but Michigan is Eastern Standard, so it is 4:45. But most likely the jury has just told the judge we ain't going to be done tonight. Where's that lady from the Murdaugh trial telling them they can't leave, get smoke breaks, eat, go to the bathroom until they find her guilty? Damn. That was cold. That was good.
All right, so I'm going to have you come back tomorrow morning. What time are you doing? 9 o'clock?
Do we like 9? 9 is good.
9 o'clock? Okay, you're going to return tomorrow at 9 o'clock. We appreciate your efforts. We appreciate you taking this seriously. This is very serious, as you know. And I need to tell you that during the trial, do not read, listen to, watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they will give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media, don't post, don't go on Facebook, don't do research, don't discuss the case with anyone. All right? Any questions about the schedule? We'll be kind of at your will. So get a good night's sleep, maybe sleeping on it will help you, right? Stay healthy. We appreciate you. And we'll see you at 9 o'clock, right?
All right, for the jury.
All right, they're going home. No verdict today in the Jennifer Crumbley case. Please make sure that you do go and clickety-click on the pinned, on YouTube. I have my article pinned. I did write an article about this case, about my changing, thoughts on it. Let's hear if the lawyers have anything to do. I don't think they do. Prosecution has to be feeling pretty terrible about this no verdict. I think they thought they were going to get a quick one. That doesn't mean, though, they're going to find her not guilty. It really doesn't. You just can't tell. Although it's usually true
Yes, thank you.
that it's better for the defendant to have a longer deliberation time. Rumble, don't forget to click on the article I'm dropping in the chat and share on all your social media. It's free. It costs you nothing. Lord, have mercy on that woman's hair. Lord Jesus, be a fence and a brush and some shampoo. Somebody send Mrs. Crumbley some hygiene products in that jail. What are they doing in the... Yeah, does this woman have access to a shower? It's concerning. It's very concerning the way she looks. Is this something that do we need to do an investigation into the Michigan penitentiary system? Because damn, she needs my Amazon store. Stat. Shannon, you really need to bring your client in some products to help, because this is... It doesn't seem fair. Oh, Squid, what do you think about the cream activator? Do you like it? The curl activator?
The last year I bought
probably being housed in the county jail, to tell you the truth. Obviously, she's stressed the fuck out. Yeah, I mean, and it can, I mean, her hair, this is a different woman than the woman who went into jail. Again, it's like, how much punishment do these people need to have? Will she ever be able to get a job again? You know, she's going to have to, even if she changes her name, that's public record. You know, anybody could look it up and find out who she is. Oh, God. Okay. Sorry about that. Spawn just got home. I had to say hello. All right. So court's over for the day. I'm going back downstairs and I'm going to enjoy the rest of my lunch. But before we do that, let's watch the rest of this clip with Josh Hawley at the Senate hearing, because I was getting a kick out of that and I wanted to finish it. So I might as well finish it with you. Let's put that up here.
It's appropriate to talk about like
It's not
individual HR
appropriate.
decisions.
Do you know who's sitting behind you? You've got families from across the nation whose children are either severely harmed or gone, and you don't think it's appropriate to talk about steps that you took? The fact that you didn't fire a single person? Let me ask you this. Have you compensated any of the victims?
Sorry?
Have you compensated any of the victims? These girls, have you compensated them?
I don't believe so.
Why not? Don't you think they deserve some compensation for what your platform has done? Help with counseling services, help with
perhaps
dealing with the issues that your service has caused?
Our job is to make sure that we build tools to help keep people safe.
Are you
across
going
our
to
platform.
compensate them?
Senator, our job and what we take seriously is making sure that we build industry-leading tools to find harmful
To make
content,
money.
take it off the services,
To make money.
and to build tools.
What tools has he built that has kept anybody safe? What tools? You know what he did build? He built an election rigging system. Uh-oh. Oh, no, you didn't. Oh, no.
Quiet, quiet, quiet.
We're not allowed to talk about that. But that's what he did. He spent a lot of time donating a whole bunch of money to sway people's opinions in an election that I remember about. Wasn't too long ago. Oh, yes, he did.
I can't deal with this. I'm going to nuke America.
How much of that time and money could he have spent on making his product safer for kids?
That empower parents.
So you
that
didn't
help
take any
working-
action. You didn't
That's
take
not
any
true,
action.
Senator.
You didn't fire anybody. You haven't.
Empower parents. I don't feel very empowered by Facebook. I quit using my Facebook page because they're so bad. And they're the king of censorship. But what are they? They're not censoring the bad stuff. They're not censoring the violence. They're not censoring any of that in the porn. They're not censoring that. They're censoring me at PJ Media. They're censoring the people who want to write about the truth about COVID protocols, the truth about COVID lockdowns, and the truth about Anthony Fauci. Well, he's spending a whole lot of time and money keeping us from being able to tell you that. But how much money and time is he spending to keep dangerous shit away from kids? Zero. Nothing. I don't believe him for 1 second.
Haven't compensated a
That's
single
not-
victim.
that's
Let
not
me
what I
ask you
said.
this. Let me ask you this. There's families of victims here today. Have you apologized to the victims? Would you like to
Would
do
you
so
like
now?
to do so?
They're here. You're on national
Damn.
television. Would you like now to apologize to the victims who have been harmed by your product? Show them the pictures.
Damn.
Would you like to apologize for what you've done to these good people?
I'm sorry for everything that you have all gone through. Terrible. No one should have to go through the things that your families have suffered. And this is why we invest so much and are going to continue doing industry-leading efforts to make sure that no one has to go through the types of things that your families have had to suffer.
Wait a minute.
You know,
Hold up.
Why, Mr. Zuckerberg?
Hold up.
Why
I need
should
to hear that again. Was that sincere? What did he say? I'm sorry that you feel that you've been harmed.
I'm sorry for everything that you've all gone through. It's terrible. No one should have to go through.
I'm sorry for everything you've all gone through. No one should have to go through
That your families have
things
suffered.
that you've
And
suffered.
this is why we invest so much and are going to continue doing industry-leading efforts to make sure that no one has to go through the types of things that your families have had to suffer.
Not good enough. Lock him up. Lock him up right now.
Go fuck yourself. But go fuck yourself.
And frankly, I'm really disappointed in Elon Musk that he did not send that woman to this thing. And, I understand that they know they're walking into a trap. They know they are walking into a political grandstanding moment. I get it. But you did this. You built this thing that gave our kids mental disorders. You did this. You're a part of it. Elon, not really a part of it. I mean, he just bought Twitter. He's not a part of it. He's only had, what's it been, a year? So he has the plausible deniability to say, we're working as hard as we can. These people that I bought it from are a bunch of fucktards, and we're trying to fix the shit that they did wrong. So he should have showed up voluntarily. Zuck, on the other hand, has been in charge of Facebook forever, from the beginning.
Why, Mr. Zuckerberg, why should your company not be sued for this? Why is it that you can claim, you hide behind a liability shield, you can't be held accountable? Shouldn't you be held accountable personally? Will you take personal responsibility?
Senator, I think I've already answered this. I mean, these
Well,
are
try
serious
this again.
issues.
Will you take personal responsibility?
Senator, I view my job and the job of our company as building the best tools that we can to keep our community safe.
Well, you're failing at
and
that.
Well, Senator, we're doing an industry-leading effort. We build AI tools
nonsense. Your product is killing people. Will you personally commit to compensating the victims? You're a billionaire. Will you commit to compensating the victims? Will you set up a compensation fund with your
I
money?
think these are
With your money.
complicated- Senator, these are complicated
Yes, no,
issues.
that's not a complicated question, though. That's
Senator,
a yes or no.
this is-
Will you set up a victims compensation fund
No, he
with your
won't.
money? The money you made on these families sitting behind you? Yes or no?
Senator, I don't think that's my job is to
Sounds
make
like
sure
a
we
no.
build good tools. My
Sounds
job
like a
is to
no.
make
Sounds
sure
like a
that-
no.
Your job is to be responsible for what your company has done. You've made billions of dollars on the people sitting behind them. Are you here? You've done nothing to help them. You've done nothing to compensate them. You've done nothing to put it right. You could do so here today, and you should. You should, Mr. Zucker.
Look, here's the thing. Josh Hawley is an asshole too. Okay? Like, he's right in this instance, but all those people sitting up there on that dais, they're just as big assholes as Mark Zuckerberg. I hate to say it, but it's true. All of these Senate hearings, all of them, and if they're on television, you better best believe that these people are there to get their 15 minutes on television and to get the sound bites and the news clips. They don't give a shit about your kids. Josh Hawley doesn't give a shit about your kids. He gives a shit about his war chest. He gives a shit about his re-election campaign. He doesn't give a shit about your kids. This is just one more way for him to get his face on TV. None of these assholes sitting on that dais up there are going to make Mark Zuckerberg do a damn thing. Just watch and see. It's been a week. Has Mark Zuckerberg been let out of his house in handcuffs to be under indictment by the Department of Justice? No. Who are they indicting? Oh, that's right, Donald Trump. For what? Having classified documents he had every right to have? I mean, it's absurd. So if you think that these people are going to help us, they are not. They are not. IT Goatee, what do you have? What is this?
Did that take away anyway?
What do you have on this page? What are you watching?
I was just saying as to form, I'm going to overrule this.
IT Goatee, are you there?
Mr. Matthews.
Okay, well, apparently Brad is watching something else. I don't know what he's watching. What is this?
of the fact
Morgan
that
and Morgan.
the
What is
Crip
this
Walk
trial?
start as a gang identifier.
All right, I can't start watching another trial. However, I'm just going to say those people, Josh Hawley, all those assholes, they're not going to do anything to help us. So we have to figure it out on our own. We have to figure it out on our own. Oh, that's the RICO case. Oh.
Seen outside of the use of the gang itself.
No,
Are
it
you
can't
familiar with
be.
Mechanicsville?
No, they're talking about gangs. That's got to be something else. That's not the RICO case. That's not Trump's case. That's Young Thug. Yeah. No, they're not going to help. They're not going to help us. They're in it to help themselves. And they like to pull Mark Zuckerberg up there, and he deserves to be there, and he deserves all the beatdown Holly gave him. But you know what they're not going to do? They're not going to put him in handcuffs and haul him off and let him stand in front of a judge. You can't even sue Facebook. You know how many people have tried to sue Facebook for allowing CP to trend on Facebook and stuff like that? Do you know how many times people have tried? Do you think it works ever? No. No. What's this?
You and the companies before us, I know you don't mean it to be so, but you have blood on your hands.
You're a billionaire. Will you commit to compensating the victims? Will you set up a compensation fund with
Senator,
your
I
money?
think these are
With your money.
complicated- Senator, these are complicated.
Yes, no, that's not a complicated question. No, that's a
Senator,
yes or no.
this is-
Will you set up a victims compensation?
I mean, it's fun for us to watch Zuckerberg get grilled. But these guys have no intention of doing anything about it. And if they had any kind of balls, like the Democrats do, they would indict him for this. They would indict him for the child abuse and child endangerment and anything else they could think of. They would indict him, put him in handcuffs, and put him on trial. Who cares if it's a show trial? That's what we do now. Show trials. That's what we do. Check out what's going on in Georgia. It's all a show. But Republicans are not serious about winning. If they were serious about winning, they'd be doing the exact same thing that Democrats do. They'd be playing dirty. They'd be rolling around in the mud, but they don't because they're useless pieces of shit. They're spineless, ballless pieces of shit. Yeah, Josh Hawley, I'm talking to you. You're a spineless, ballless piece of shit. You only have balls when the cameras are on. You talk a good game and then you do absolutely fucking nothing. They're not going to do anything. Does Nick do Congress shaming? Not as well as I do. These pieces of garbage sit there and they preach at you. They preach at you and all they're so high and mighty with their, look what you did. Look what you did to these families and look what you did to these children. Well, if it's that bad, if this guy here is responsible for the blood of children, well, then where are the handcuffs and where is the DOJ? Where's the indictment? Where's the show trial? I don't believe you. You sit on a throne of lies. Fuck off, Josh Hawley. You're doing nothing for no one. Absolutely nothing for anybody. All of this is like conservatives kill me. Oh my God. Republican watchers, fans kill me. They all send me these clips and they're like, oh my God, wait till you see what Josh Hawley did today. And I'm like, oh yeah, what did that fucking liar do? Great. Oh, he got up on the stage and he yelled at somebody. Oh no, I'm sure Mark Zuckerberg is shaking all the way back to his mansion as they do absolutely nothing. And I don't know if the right answer is to arrest him and put him in jail, but it would be better than doing nothing. Put him on trial at least. Let's see the evidence. Let's get the discovery. Let's see what he knew and when he knew it. What did he know? And when did he know it? Did we end the watch? Yeah, it's the jury went home. I've been trying to talk to you, but you're not there. I don't know. Yeah, at least let's get the discovery. Let's see what these people actually did. Instead they pull him in front of the Senate and they're like, what did you do? What have you done? And he's like, nothing. And they're like, well, how dare you, sir? but they're not subpoenaing any records. They're not getting any discovery. They don't know what he hit. And then he just goes back to his mansion. He gets on his yacht and he spends the winter in the Seychelles with the Amazon creep. And it, this is a joke. This is a show. It's a show. It's pointless. It means nothing. And yeah, we like to watch it. We like to watch this shit, but what does it actually do?
Would you like now to
Here, we're going to get to
apologize
see a different angle of him apologizing.
And this is why we invested so much and are going to continue doing industry-leading efforts to make sure that no one has to go through the types of things that your families have had to suffer.
Why, Mr. Zuckerberg, why should your company not be sued for this? Why,
Mr. Hawley, should you not be held accountable for not holding him accountable? Who's going to sue him? Us? We have to go get the lawyers? We have to pay the hundreds of thousands of dollars to get the lawyers to sue this guy? Why don't you do something about it? Why don't you put the weight of the government behind it? Why don't you put the weight of the DOJ behind it? If you really think he did something criminal, then why the hell are you asking us to sue him in civil court? Why aren't you going after him for crimes against humanity or whatever the fuck you're trying to say he did? And I believe he probably did it. But you're going to have to go and figure it out. Maybe you should appoint a special prosecutor. Gee, who has the power to do that? Oh, Josh Hawley does. You know what else this fucking guy did? He ignored my investigation into his state's judiciary corruption. He's from Missouri. This guy is a Missouri senator. Did he care one bit that 31 judges recused themselves from a lawsuit that I blew out of the water? Because I caught the chief judge, committing a major, well, what do you call it? It's not a crime. It would be an impropriety by sending emails to the defendant promising to help her. What do you call that? The entire judiciary had to recuse itself from a case that I reported. What did this guy do? Absolutely fucking nothing. Wouldn't even return my calls. You're a disgrace, Josh Hawley. And maybe your aides didn't give you my messages, but I can tell you that I called and I stopped by your office. You weren't there. You didn't care. You didn't have anything to say about the parents who are being railroaded in the Missouri family court system right under your nose. You don't give a shit. You don't care about kids because the kids in Missouri are being raped by abusive parents and the system, the CPS foster care system, and you don't give a shit. You have court-appointed psychologists who are accusing women, mothers, protective mothers, of having borderline personality disorder so the judges can take the kids from the mom and give them to sex-abusing fathers. You've got sodomizers like Charles Haynes. You guys let him out of prison. This man abused his kids, drove one of his children to suicide, and you guys don't care. So no, I don't have any bit of respect for this man. None. Zero. He's a piece of shit. He does nothing. He cares about no one. This is all a show. This is a show. Just let you know. This is a big fucking show. And we are the intended audience, and they want us to clap and cheer and say, oh, look at what a hero Josh Hawley is. He's no hero. Trust me. He's no hero. Is that a victim there behind Hawley? I don't know. His face is pretty sad. Could be an aide. I don't know. Yeah. Isn't it the parents' fault for not monitoring their kids? Yeah, because you know what they're really doing? So it's funny. He gets up there on the show stage and he's pointing his finger at Mark Zuckerberg. Meanwhile, his government, the government he works for, is prosecuting the Crumbleys for not monitoring their kid. Why aren't they prosecuting the guy with the Gore website? Like, maybe they should be doing that. It seems just as worthwhile as prosecuting the families. How come that guy with the Gore website doesn't have an age verification thing on his website? How come children are able to access that? Why can children access that? Maybe somebody should be asking that question. Why is a Gore website with real violence hosted on internet service providers that are being beamed into your house without you having any control over what's there? I don't know, but I'm getting pretty sick of these people. Before you come after us, maybe you should go after the people actually giving the actually hurting the kids and corrupting them psychologically. As being modemed directly into my house. I didn't ask them for that shit. I don't want gore in my house. I don't want violence in my house. I didn't ask for that. But it's my fault if my kid, oh, I get it. It's my fault though if my kids access it. It's my fault because I need to know everything about everybody and what they're doing at all times, right? Fuck. I hate this. Rogue Mama says, do you remember in 2020 when people were protesting outside of Holly's house and he was so appalled? He was going on and on about how he had a new baby and his wife was scared. Yeah, grow up, Josh. None of these people are going to help us. And maybe I'm black-pilled, but I've come to the realization none of these people care about you and your kids. None of them care whether you go to jail for their fuck-ups or for Mark Zuckerberg's fuck-ups. They're all in it together. How much you want to bet that Josh Hawley at one time, or maybe in the future, has been or will be at a cocktail party with Mark Zuckerberg? How much you want to bet? Jeez. Pill of color, please. That was good timing. No way. The judge let Sarah Boone's latest attorney quit for real? I didn't think the judge was going to allow that. I didn't think the judge was going to allow that. Yeah. Remember when Megan was going to end the stream and then she got angry? And here we are.
You will pay for what you've done. And I pray that God send angels to visit vengeance
upon thee. Vengeance upon thee, Josh Hawley. You absolute faker. You faking loser. You know damn well there are things you can do. You can impeach a judge. You can do things. But you didn't lift a finger to help me and those victims in Missouri. You didn't care. So fuck you. You can fuck right off with all of it. Oh, I have some audio, by the way, some exclusive audio from that cocktail party that I believe that Josh Hawley and Mark Zuckerberg were probably at together.
Oh, I'll see you at the feast tonight. Oh, we'll have lots of blood and semen. Oh, good.
There you go. That's where they were. That's what they were doing. And they'll be doing it again soon together. For certain. Brad, Titania was from Bark, the web, app that you can download to monitor your kids' devices. She came and talked to us about their product. And hopefully she'll get back to us with those questions we have. And maybe I can get a promo code for you guys if you want to test it out. I'm thinking I might test it out for 14 days. No, that was not Nick. That was Alex Jones, the great Alex Jones. Well, Joe goes live at 6. So maybe I need to keep you guys here until 6. But if I'm going to do that, I need to go get my laundry and do some folding. So listen to this asshole while I do that.
That you can claim, you hide behind a liability shield. You can't be held accountable. Shouldn't you be held accountable personally? Will you take personal responsibility?
Senator, I think I've already answered this. I mean, these
Well,
are
try
serious
this again.
issues.
Will you take personal responsibility?
Senator, I view my job and the job of our company as building the best tools that we can to keep our community safe.
Well, you're failing at
and
that.
Well, Senator, we're doing an industry-leading effort. We build AI tools
nonsense. Your product is killing people. Will you personally commit to compensating the victims? You're a billionaire. Will you commit to compensating the victims? Will you set up a compensation fund with
Senator,
your
I
money?
think these are
With your money.
Senator, these are complicated
Yes, no,
issues.
that's not a complicated question, though. That's a
Senator,
yes or no.
this is-
Will you set up a victims' compensation fund with your money, the money you made on these families sitting behind you? Yes or no?
Senator, I don't think that that's my job is to
Sounds
make
like
sure
a
we build
no.
good tools. My
Sounds
job
like a
is
no.
to make sure that
Your job is to be responsible for what your company has done. You've made billions of dollars on the people sitting behind them. Are you here? You've done nothing to help them. You've done nothing to compensate them. You've done nothing to put it right. You could do so here today, and you should. You should, Mr. Zuckerberg.
Mr. Zuckerberg, you and the companies before us, I know you don't mean it to be so, but you have blood on your hands.
Yeah, they love to talk a good game, don't they? Oh, we still have the spinning thing going on. Son of a gun. How much has Mr. Hawley made from the people behind him? Yeah, I don't know. Probably lots. Oh, that's a problem. Hold on. Oh, my stand-up desk got caught. Okay. All right. Yeah, I mean, look, this is the big problem, right, Furby Slayer? All of these regulations they claim they want to put on big tech, they're not really after them. They're after you. You can't trust anything these people do or want to do to you because this is all about doing it to you. And yeah, I am chugging a beer. Yes, why? Yes, I am. It's all about what they're doing, what they want to do to you. Because if they truly wanted to go after these people, they would have done it already. All right, I see that YouTube is not going to play. And I think that's because my desk accidentally unplugged my Orbi internet booster. So it probably has to reboot or something. Because we're lucky I still am on the screen. There we go.
You have a product. You have a product that's
Listen
killing
to those
people.
idiots clapping.
When we had cigarettes killing people, we did something about it, maybe not enough. You're going to talk about guns, we have the ATF. Nothing here. There's not a damn thing anybody.
You're darn right. Zuckerberg lines their pockets. You know how much money? How much money he has given to their
They
campaigns?
can do about it. You can't be sued. Now, Senator Blumenthal.
Yeah, this is so ridiculous. I've got it set down to the lowest setting. It's at
And
140.
Blackburn, who've been like
Let's try this.
like the dynamic duo here, have found emails from your company where they warned you about this stuff, and you decided not to hire 45.
Yeah, I know Lindsey Graham is worse than Josh Hawley. He's just as bad. Squid
people
Pro Quo, your
that could
hair looks
do a better
amazing.
job of policing this.
Whoa.
So the bottom.
Squid's been using my hair products. And if you're in the locals chat, you would see her hair. That's a big difference from the last time I saw it, Squid. Oh my gosh, it looks so curly. I told you. Your hair looks awesome. You know what? I don't know if Rumble has these problems or if it's just YouTube. I can share the pic. Okay, cool. I'm going to.
Line is you can't be sued. You should be.
Okay, so Squid here, Squid Pro Quo. You're so cute. Her hair looks amazing. Look at how much curlier your hair is than it was in the last picture. Look at the definition. It's freaking fantastic. It looks so good. See, this is what happens when you listen to me about hair products. Look how good. Fantastic. Did you just which ones did you tell me which ones you used? Did you use all of them or just the activator or what?
And these emails would be great for punitive damages. But the courtroom's closed to every American abused by all the companies in front of me. Of all the people in America, we.
Damn, Lindsay. It is an outrage that you can't sue these companies. You can't sue them for anything they've done. It's impossible. For one, they'll out-litigate you. For
Could get
two,
blanket liability protection too. This would be the last group I would pick. It is now time to repeal Section 230.
well, I don't know.
When a Boeing plane lost a door in mid-flight several weeks ago, nobody questioned the decision to ground a fleet of over 700 planes. So why aren't we taking the same type of decisive action on the danger of these platforms when we know these kids are dying? We have bills that have passed through this incredibly diverse committee when it comes to our political views, that have passed through this committee, and they should go to the floor.
Zuckerberg. All right, so Squid used the Cantu activator, the Echo Gel, the mousse, and then hair oil when it was dry. That looks awesome. It looks really good. It looks so defined and shiny and healthy. Oh my gosh, I can't wait till you get your hair cut. It's going to be even better. Are you getting layers?
Yes,
That's what you
there
need.
are
You
a
need
lot that
layers.
is slipping through. It appears that you're trying to be the premier
Oh, Marsha Blackburn. She's another one. She does a lot of talking. I really want to like Marsha Blackburn. But again,
trafficking.
It's a lot of
Of
site
talking.
course not, Senator.
in this country.
Senator, that's ridiculous.
No, it
Senator,
is not ridiculous.
Of
You
course
want
we
to
don't
turn
want
around
this.
and
We
tell
don't want
these
this
people
content
that,
on our platforms. And we,
why don't you
Then
take
why don't
it?
you take it off? Oh, you don't want the content there, but you don't take it down. Yet you take down my articles sure fast enough. I can't even get my articles will not trend on Facebook, and they used to. They used to do it all the time, and I know for a fact I'm not a worse writer than I was before. I may be getting better every day. And yet my articles can't go anywhere on Facebook. They've got that shit locked down. But can they lock down child trafficking? Oh, it's too hard. It's too hard for Mark Zuckerberg. I don't want that content. Well, I've seen exactly what you do when you don't want content on your platform, Mark.
Down.
we do take
We
it down.
are here discussing.
We do
We
more
need
work to
you
take it
all
down
to
than-
work
than-
with
than-
us.
Bullshit. They're spending more time taking down political ideas they don't like than they are illegal material. There's no way that they are doing what they're saying that they're doing. Sorry, they're not. They're spending time fixing elections and changing people's minds about who they think they should vote for. I can't do this anymore. Brad, you have to fix my computer. I don't know what's going on. Maybe it's my broadband. I don't know. How do I do a
No,
broadband
you're
test?
not. You are not.
He's
and
not.
The problem is we've been working on this. Senator Welch is over there. We've been working on this stuff for a decade. You have an army of lawyers and lobbyists that have fought us on this every step of the way. You work with Net Choice, the Cato Institute, Taxpayers Protection Alliance.
Damn it, YouTube. I'm getting tired of this.
And Chamber of Progress to actually fight our bipartisan legislation to keep kids safe online. So are you going to stop funding these groups? Are you going to stop lobbying against this and come to the table and work with us? Yes or no?
Senator, we have a.
Yes or no?
Of course, we'll work with you on the legislation.
Okay,
I mean,
the
it's
door
been hard
is
to-
open. We've got all these bills. You need to come to the table. Each and every one of you need to come to the table, and you need to work with us. Kids are dying.
Let me point to this, Mr. Chu. There was a report recently that
Who's this guy?
compared hashtags on Instagram to
Oh, he's
hashtags on
Instagram?
TikTok.
TikTok.
And what trended, and the differences were striking. So, for something like hashtag Taylor Swift or hashtag Trump, researchers found roughly 2 Instagram posts for every one on TikTok. That's not a dramatic difference. That difference jumps to 8-1 for the hashtag Uyghur. And it jumps to 30-1 for the hashtag Tibet. And it jumps to 57-1 to the hashtag Tiananmen Square. And it jumps to 174-1 for the hashtag Hong Kong protest. Why is it that on Instagram, people can put up a hashtag Hong Kong protest 174 times compared to TikTok? What censorship is TikTok doing at the request
Oh, shit, I shouldn't have touched it.
of the Chinese government?
Yeah, good question.
Senator, that analysis
explain
is
that
flawed.
differential.
The analysis is
None.
flawed. It's been debunked by other experts.
Yeah, I don't know if I believe a guy named Mr. Chu about what's going on in China. Is he Chinese? Is he, or am I being racist? If I am being racist, it's not deliberately racist. Um, maybe
external
he's not
sources like the
Chinese.
Cato Institute. Fundamentally, a few things happen here. Not all videos carry hashtags. That's the first thing. The second thing is that you cannot selectively choose a few words within a certain time
Why the
period.
difference between Taylor Swift and Tiananmen Square? What happened at Tiananmen Square?
Senator, there was a massive protest during that time. But what I'm trying to say is our users can freely come and post this
Why
content.
would there be no difference on Taylor Swift, or a minimal difference and a massive difference on Tiananmen Square or Hong Kong?
Senator, could you wrap up, please?
Senator, our algorithm does not suppress any content simply based on
To
this.
answer
It
that
doesn't.
question, why
Yeah.
is there a difference?
Like I said, I think this analysis is flawed. You're selectively choosing some words over some periods. We haven't been around as
There
long
is
as
an
other apps.
obvious difference. 174-1 for Hong Kong compared to Taylor Swift is dramatic.
Mr. Spiegel, there are
All right,
a
wait.
number of parents whose children
I
have
have
been
something
able
to
to
say about
access
Ted Cruz.
illegal drugs on.
I have something to say about Ted Cruz. So let's take a look at his record, shall we? Because I like to do this when idiots get up and wax on about how right they are and all the try to make you think they're doing things. And Ted Cruz is a guy that I used to admire. But then you go and you look at his record. Here's his enacted legislation. Cruz was the primary sponsor of 16 bills that were enacted, and the most recent include Testing, Rapid Analysis, and Narcotic Quality Research Act of 2023. Yeah, that's a slush fund. That's a bunch of money that went to a bunch of researchers, like probably billions of our tax dollars to pay for some monkeys on meth bullshit.
Billions and billions and billions and billions and billions and billions and
And then he had a bill to designate the facility of the United States Postal Service located at 5302 Galveston Road in Houston, Texas, as the Vanessa Guillen Post Office Building. Well, who's Vanessa Guillen? I bet she's a politician. Let's look her up. Vanessa Guillen. Who's she? She's a soldier. Okay, this time it wasn't a politician. It's a soldier. The last post office that he named was after a career politician. But again, she's at least a soldier who lost her life at Fort Hood. Okay, well, do we need legislation for that, though? It feels like a waste of time. Can't you just slap a plaque on the front? You know, like, do we need legislation to do this? Yes, she was a victim at Fort Hood. But I just want you to see what Ted Cruz is actually doing. And that might be a nice thing to name a post office after a murder victim, but what does it do for the country? What does it do for our country that is in such serious trouble? Like, we are in such serious trouble in this country. We may lose our republic, and this is what Ted Cruz is doing. Senate Bill 5053, a bill to provide for the meaningful participation of Taiwan in the International Civil Aviation Organization. What the actual fuck is this? Civil Aviation Program for the Taiwanese. I haven't even read this yet. I read this about once a year. This is this year's first reading through Ted Cruz's many accomplishments in the Senate. Senate Bill 4779, ISS Extension Act of 2022. I don't have a clue what that is, and I bet it's something ridiculous. Let's see. A bill to extend the use of and set forth priorities for the International Space Station. Okay. Really important stuff. Really something else that costs more money. Okay. Senate Bill 26. I mean, is there anything in here about internet safety? All these protecting these kids he's so worried about? Is there anything here about I don't know, illegal immigration that's just, destroying our border and destroying our law enforcement? Anything? Not yet. Senate Bill 2611, a bill to designate high priority corridors on the national highway system and for other purposes. Great. Senate Bill 4744, Republic of Texas Legation Memorial Act. Oh, this should be good. This is yet more ribbon cutting. A bill to authorize the Daughters of the Republic of Texas to establish the Republic of Texas Legation Memorial as a commemorative work in the District of Columbia, and to build a statue. More money. More money. What the fuck, Ted? What are you doing? What are you doing, Ted? Nothing. He's doing nothing. Do you see that this is nothing? This is a big list of nothing. Hi, I'm Vanna White. Let me show you all the nothing that Ted Cruz is doing. Senate Bill 1441, Protecting Europe's Energy Security Act of 2019. Oh, he's protecting Europe. He's protecting Europe's energy. What are we doing about protecting our energy grids from terror attacks, Ted? What are we doing to protect our grids from attacks? Anything? Are you doing anything about? No. He's protecting Europe's energy grids, not ours here in America. An American senator is protecting Europe's energy. I don't think I need to go on. There are more, but I think that we can safely say that Senator Ted Cruz has done jack shit. Jack shit. And I'm supposed to think because he gets on TV and wags his finger in the face of Mark Zuckerberg that he's some kind of hero? Nah. I just don't.
Your platform. What do you say to those parents?
Well, Senator, we are devastated that we cannot.
To the
prevent-
parents. What do you say to those parents, Mr. Spiegel?
I'm so sorry that we have not been able to prevent these tragedies.
Everyone knows that kids who spend a lot of time, too much time on your platforms are at risk. And it's not just the mental health issues. I mean, let me ask you a question. Is your platform safe for kids?
I believe it is, but there's an
Hold on a
important
second.
difference between
Let me
correlation and causation.
Because we're not going to be able to get anywhere. We want to work in a productive, open, honest, and collaborative way with the private sector to pass legislation that will protect Americans, that will protect American children above all, and that will allow businesses to thrive in this country. If we don't start with an open, honest, candid, realistic assessment.
Laws aren't going to fix this, sir. I don't know who this is. I feel like I should know who this is. His name is on the tip of my tongue, and I can't figure out what it is. But their answer to everything is always laws. But in this case, if what they are saying is true, and these companies have on purpose and with full knowledge, that's Ossoff. Well, at least Senator Ossoff, that's why I knew who he was. At least Senator Ossoff has been helping our family, the Hernandez family in his state. At least we can say that Senator Ossoff has at the very least listened. He has at the very least listened to the people in his state who have asked him to pay attention to the Hernandez case, and he has launched an investigation into foster care. I will give him that. So he may not be as bad as the rest of them, because at least he's doing something in his state for one of his people by at least listening. And maybe he made a phone call or two, but he definitely talked to the Hernandez representatives and at least let them know he understands what's happening. But if these people have done what it is that the senators think they've done, which is contribute to the deaths of children, why aren't they on trial like the Crumbleys? If the state can make the argument that Jennifer Crumbley and her husband are negligent in homicides because they didn't monitor their kid on the internet, then how come these internet moguls can provide that kind of content that can lead to this kind of shit to minors without legal criminal consequences? I don't understand it. Stop spinning. I'm going to shame YouTube. Stop
Assessment of the
spinning.
issues.
There we go.
can't
It
do that.
worked.
Who will support
Well, it worked for like
the
2
Kids
seconds.
Online Safety Act? Yes or no, Mr. Citron?
What's the Kids Online Safety Act? That's probably a terrible bill. Let's see.
There are parts of the act that we think are great.
No,
and
it's a yes or no question. I'm going to be running out of time, so I'm assuming the answer is no if you can't answer yes.
we very much think that the national privacy
That's a
standard would be
no.
great.
Mr. Siegel?
Senator, we strongly support the Kids Online Safety Act, and we've already implemented many of its core provisions.
Thank you. I welcome that support along with Microsoft.
That means it's
support.
pretty terrible,
Mr. Chu.
probably.
Senator, with some changes, we can support it.
Well, in its present form, do you support it? Yes or no?
We are aware that some groups have raised some concerns. It's important to understand.
I'll take that as a no. Ms. Yacarino.
Senator, we support COSA and will continue to make sure that it accelerates and make sure it continues to offer community for teens that are seeking that voice.
Mr. Zuckerberg.
Senator, we support the age-appropriate content standards, but would have some
Yes
suggestions
or no,
on how to
Mr.
implement it.
Zuckerberg? Do you support the Kids Online Safety Act?
Senator, I
It's a
think
measure
these are
that is
nuanced
public,
things.
and
Yes and
I'm
no.
just asking whether.
All right, let's actually look at it. Let's look at the act, shall we? We have a few more minutes until Dr. Joe's stream. So we might as well read through this and see if it does have concerns in it. I will right off the bat going to tell you that anything written by our politicians has concerns, probably for freedom. This bill sets out requirements to protect minors from online harms. The requirements apply to covered platforms, which are applications or services, example, social networks that connect to the internet and are likely to be used by minors. However, the bill exempts internet service providers. Why? Why are internet service providers exempted? Email services, educational institutions, and other specified entities from the requirements. Oh, educational institutions are exempted? Is that so our educational institutions can keep showing kids porn during school? Because that's what they're doing. They call it sex education, but they're showing them porn sites. Covered platforms must take reasonable measures in the design and operation of products or services used by minors to prevent and mitigate certain harms that may arise from that use. Example, sexual exploitation and online bullying. I guess I would have to be told what those measures, define those reasonable measures. Additionally, covered platforms must provide, 1, minors with certain safeguards, such as settings that restrict access to minors' personal data. That seems reasonable. And parents or guardians with tools to supervise minors' use of a platform, such as control of privacy and account settings. I like that. I will say that Facebook does have some of these for their children's messaging app. I get notifications. My son uses it to talk to his cousin, and that's it. They have like a video thing, and they can play games together online there. And I do get notifications whenever he's online, and I get notifications if anything. Like one time, I think he got into a little fight with his cousin, and Facebook did notify me that there were some words used that they didn't like. That was kind of like what she was talking about with bark. So that was, I guess, helpful, but it also kind of freaked me out. Like, who's listening to this? Is it all being monitored, and where does it go? And I don't really trust Facebook, so not sure. Provide parents or guardians with tools to supervise minors' use of a platform, such as control of privacy and account settings. I think that's very reasonable too. Covered platforms must also disclose specified information, including details regarding the use of personalized recommendation systems and individual-specific advertising to minors. They absolutely should have to do that. They should have to open up their algorithms about how they are recommending things to minors. And they need to allow parents, guardians, minors, and schools to report certain harms. Well, there is a report function on Facebook. I know that. There's one on Instagram. I don't know about the others. There is one on Twitter. You can report. Refrain from facilitating advertising of age-restricted products or services to minors. Yeah. Why can't they do that? I don't see why that's such a big deal. They know who's a minor and who's not. It's kind of like when we were talking about those apps, the in-app ads. If my kid is playing a 12 and under app, there should not be any advertisement for any app that's above 12. If my kid is restricted to 4 and under, then no ad should be for anything but 4 and under. And yet they do these like 17 and up on the 9 and 10, 11 and 12 apps. That's not okay, and that needs to stop. And I think they're doing it on purpose. They want to corrupt your kids. They make money doing it. Yeah, and why can't they have an ad-free experience for kids? I pay them enough money. I pay them so much money. Stop putting commercials in front of my kids. It drives me fucking crazy. Refrain. Annually report on foreseeable risks of harm to minors from using the platform. I don't see what's wrong with that. I think they should do that. Additionally, the bill requires large, based on specified revenue, employment, or user criteria, large websites, internet applications, and search engines, including social network sites, to meet certain requirements before using algorithms that prioritize information furnished to the user based on user-specific data. Interesting. For example, such platforms must 1, provide users with notice that the website uses such algorithms. I don't see a problem with that. And 2, make available a version of the platform that uses algorithms that do not prioritize information based on user data. You know, I can see that they would fight that because that is how they make their money. Their platforms are free to use. So when the platform is free, you are the product. And so they want you. And frankly, I don't always think that targeted ads are such a bad thing. Targeted ads are actually better than ads I have no interest in. I mean, because I have been searching, you know, when you do your search history, you search for, let's say, my e.l.f. makeup that I like so much that you can find on my Amazon store. I've been searching a lot of this stuff and looking at different colors. So now when I'm on Facebook or any of these things, these same sorts of products will come up. Well, I'm more likely to buy those products because I'm interested in them. I don't really see the problem there. I don't see why they would need to change that. I prefer targeted ads over the alternative, which would be ads that they have no idea whether I'm interested in or not. The bill provides for enforcement through the Federal Trade Commission in states. They look, they need way more oversight, and government oversight is never the answer. I know, but they don't even have any. And why should I live in a place in a country that oversees my every damn move, and these people get to run around and harm kids without anybody looking over their shoulder? If I have to put up with big government up my ass all the time, I want them equally up Mark Zuckerberg's ass too. Or leave everybody alone. Okay? It can't be an in-between. You can't be up my ass all day long and not be anywhere near Mark Zuckerberg's. That's not fair. So either get off all of our asses or be up there equally. Does that make sense? If the government is going to fuck me, they need to also fuck Zuckerberg. Okay? Like, that's the way it should go. Further, the bill requires the commission to seek to contract with the National Academy of Sciences to study the risk of harm to minors by the use of social media and other online platforms. Well, that's just more money for the National Academy of Science. Who knows if their studies are accurate or not. The bill establishes a council, so more overlords, on implementing the bill. It also requires guidance for market and product research focused on minors and an evaluation of options to verify a user's age. Yes, age verification would be great. That is something that needs to happen. age verification for accessing anything of an adult nature online. That needs to be a thing. If you're going to access porn, show your damn driver's license, period. It will also cut back on the access of illegal material like that, because you're not going to show your driver's license to access illegal content, are you? So you won't be able to access it then, or you'll have to go on the dark web and do whatever it is they do there. All right, get all your swearing out now, because I am going to redirect you over to Dr. Joe Corcoran's stream, and you know how he feels about civility over there. When you're in somebody else's house, I expect you to act appropriately, and not give all the F words and F bombs in his chat. We got it all out today, though, I think. Hey, I like this. Folks, Megan has been streaming her butt off today. Let's show we appreciate her work by sending super chats. If you can't super chat, let's hit the like. It's free. Well, it is free, and you have approximately 10 minutes to get your last super chats in of the day. Rumble rants, locals tips, cash apps, Venmo, PayPal. It's all there. It's all there. What are we at now? Are we at it's not great. It's been 9 hours. I think we're up to $100, which is okay. But for 9 hours, did we increase the minimum wage at least? I can't do division in my head, which is probably why I only deserve minimum wage. Let's see. Divided by 9. Wait. $11 an hour? We're still not up to minimum wage in New York. I think it's $14 an hour in New York. All right. What are we doing here? Let me get rid of this. Stop sharing. Can I pay you through TikTok? Are you just trying to set me off on a TikTok rant? You know damn well I'm not on TikTok, and none of you ought to be on TikTok either. It's a Chinese spy app, and as you can see, they do not care to restrict that shit for kids. All those kids are getting sucked down these TikTok rabbit holes of hell, and that is not something that I want any of you involved in. I want you to do wholesome things, like watch only wholesome cooking videos on Instagram, or those funny people that do the funny videos about siblings. Those are funny. You may watch those. I give you my permission to watch funny reels on Instagram, but do not go down any dark rabbit holes, folks. Focus on the positive. Do you accept rubles? I think so. I think YouTube does. If you have YouTube in the country where you are, rubles would be Russia, then yes, I accept them all. All right. What's happening over here? You guys, in 10 minutes, you're going over to Dr. Joe's stream. What can we do for 10 minutes? What can we do for 10 minutes? Oh! We can catch up on the latest on Dave Neal, because guess what? In the Tonsil Twins case, Dave is expecting to have news tomorrow tomorrow is supposed to be his trial, and he is expecting to have news about that soon. And where is it? Where are you, Dave? Dave, where was your latest video on Clayton? Oh, and there are new victims. We can watch a little bit of this. Skip. God, YouTube is just gonna screw with me all day.
Slur Nation News. I got a Sunday video for you. No Super Bowl today, right? We got a week off before the big dance. So we're going to talk about some court filings from the past that have unearthed and some new information regarding new victims. Intimate victims, we are up to, I believe, 5. We're going to cover that right now. Follow me on Instagram at @DNeils and get ready for tomorrow's Bachelor Rush Hour. That'll be available
That's 2 new victims we didn't know about, guys.
first thing Monday morning.
Let's skip ahead
Best
to
way you
where
can
he
support the
talks
channel,
about that.
yellow here, but it is available. Sort of information that's behind the yellow here, but it is available in its entirety on Patreon. We're working through the list of intimate victims here. We have got 2 new victims. We believed Mike was victim 1, Greg 2, and Clayton 3. We can no longer call them that because we have a victim between Mike and Greg, and we have the first victim, of course, of intimate concern here. And that first victim, we discuss the tactic that she used, and again, according to sources here, to manipulate him into contacting her, a tactic that was sending herself to the ER. And we talk more about this, but it's wild. Our source doesn't even believe she was overdosing, but she threatened that she had, and that's very interesting. Now, non-intimate incidents. There's a high school friend who was non-intimate, spelled that wrong, but there was guilt of self-harm put on him. Same guilt of self-harm that was put on the anonymous woman we have here. There's also somebody that's another source that we didn't include that I'm going to hold off on talking about because they're borderline wanting to come forward, but a little nervous that they maybe be I think their issue is more they don't want to get fired. It's one thing if you don't want to be publicly brought into this and the shame that's included and this and that, but it's another that like you don't want to lose your livelihood. Now, how could someone lose their livelihood? Well, we've seen tactics that can be brought to you and in ways that could distort the truth and things like that. Non-intimate incidents. Some people in the Patreon wanted me to be included there because, of course, she threatened self-harm. Said there would be blood on my hands if she hurt herself due to the actions of my channel. I want to remind everybody we want this thing to end. This is almost like a hostage situation. Best case scenario is nobody gets harmed, but all of the harm has already been done emotionally to so many different people here
and financially.
I think the way that this thing ends is she gets the help she needs, or never at least does this in the future, because now it's all exposed. People will know her name for this is just not going away. She's already tried to change her name. It's not going away. And that's not to harass her. That's just to say, if she ever pulls this in the future, everyone's going to know her playbook.
Thank God. And I think there's going to be a documentary too. Rumble, Slidey Pie, thanks for the $1 Rumble rant. Had to give $1 from the medium pours. I appreciate the medium pours. Thank you so much for that. And also, it looks like there was a PayPal. Medium wage for medium smart. Megan, thanks for keeping us entertained today. Thank you for the $19. It looks like $18 from Tracy. Thank you so much. I appreciate that. And 5 gifted memberships from Hemplin, Texas. Another 5. That's 10 today. Thank you so much for those. And congrats on the memberships, those of you who won it. Oh, look, you got one. Awesome. My guest is Flabbard, got a gifted membership. Fantastic. Welcome to the Fox Den, everyone. Excellent. Thank you for that.
And maybe this will also help prevent other people from making up crazy claims. And now clearly there is a mental health aspect to this, but until we solve these victims, we can't really help the person. It's like if Jane Doe is a fire, we need to put the fire out. And I mean this, stopping her from doing her shit, right? That's the fire that needs to be put out, because all these people are getting burned, and we can't deal with her until we deal with them. So anyway, let's jump into some other some of the minutes that are shown here. It just showing all the way back to September, where the police department and the protective order hearing and telephone calls called and wanted to know when her hearing was. So there was an injunction against harassment placed against Jane Doe from Clayton.
Okay, now I want to move over to, he has some news about his court case.
Most people have no clue that in 2023, the best way to make...
Hold on.
public. Go to the court hearing. You can go to my court hearing, February 8th. I think it's public, right? Everyone can show up. Throw a party. Who wants to bring me cake? Cake and pizza. Let's go. But hold off on that. We don't know what's going to happen with that. So
basically, Dave said, I don't know where it is in this video, but he basically said that he is expecting a call sometime today to give him information on what's going to happen with his hearing. He believes, and he said this publicly today, so it's okay if I say it. He believes that she is going to drop, she wants to drop it, but she has stipulations, and he hasn't said what those are. I hope, Dave, if you're listening, Dave, don't let her stipulate to anything. Just drop the false charges, period. Because if she's trying to get you to like not talk about this or take down some video, no, fuck that. No.
Go fuck yourself. But go fuck yourself.
You know as well as I do that that information needs to be available for the public for the next victims, because there will be more victims. There will be no stipulations. Zero. Unless the stipulation is something like, I'll drop my my harassment against you if you God, I can't even think of anything. If you stop calling me Dodo Bird, you know, he can stop calling her that any day. That's fine. I'm sure he probably would have done that anyway. So if it's something that, you know, if it's something like that, okay, maybe. But don't take anything down. Don't do any of that. Berta, thanks for the $5 super sticker. I appreciate that. All right, what are we at? It's 5:57. 3 more minutes. So guess what? It's time. It's time to go. My outro is at least 3 minutes, isn't it? Isn't it? If it's not, just tell Dr. Joe I said hello, and I'll see you back here, 9 a.m. Barring any more emergency trips for strep tests, this is where I will be. I'm tired. I'm going to finish my laundry and lay down and watch Everybody Loves Raymond, my nightly routine. That's what I do. All right. See you later.
I was lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. Oh, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna stay. No, I don't wanna say goodbye. No, I don't wanna say goodbye. This time I know my road is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. And my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye.